Yes.
May I have lordship?
Original said, sorry. Yes, please.
My lord, I am praying leave without certified copy. My lord,
Grant.
my lord,
My lord,
urgency is this.
Urgency we don't know. It will
My
come in
lord,
the
my lord, extreme urgency. My lord, honorable single judge has directed to pay 10 lakh compensation to the petitioner, my lord, and directed to the authority to initiate certificate proceedings. My lord, without hearing to the
Let it appear in the list. Give a notice to the other side and mention for urgency. We'll consider.
grateful to your lordship.
to mention two hearing matters, my lord, because it was in the list of Honorable Justice Mutation and Honorable Apupu Sinha Roy, my lord, that is not coming before this.
In the list, it was in the list.
In the month
But we please wait for some time. We cannot add. Our list is already heavy. Hearing matters, we have to dispose of some matters, then add.
Yes, my lord.
Otherwise, the addition will be cosmetic. It's a cosmetic thing then. Yes.
My lord, may I be permitted to mention a matter?
Yes,
My
will
lord,
come.
let my senior, my lord.
He is obviously a senior, but we have started.
My lord, my lord, hearing matter, my lord, land acquisition matter.
But these are the applications, my lord.
Application.
Lordship, may I be permitted to mention a matter? The stay application is pending. The urgency is that
You are mentioning the stay application.
Yes,
Need
sir.
not mention urgency. Yes. Yes. Call on this.
Your lordship, may I be permitted to mention a matter? The liberty was given by the.
What is the matter? First, start with that application.
It is a hearing matter, but section 5 application.
Then mention the application, right? At the top, application, and mention the section 5. Yes, call on.
May I be permitted to mention one application, ma'am?
Yes.
I beg to mention one application for maintenance, ma'am.
And over. No further mentioning, please. Call on the list. No further mentioning. Yes. We will take up the list. Yes.
Order 41, my lord.
My lord, order 41.
Come to one. Come on the next. Yes. Who is appearing in one?
I don't know. Your lordship.
Yes, your matter we have heard substantially. Who is for the other side? Yes.
Item number 1.
Mr. Chakraborty, there is a prima facie thing.
My lord.
Please come to that order. What is the page number of that order? Justice Banerjee's. Sorry, Justice. The first order that one of which review has been sought.
In this application, my lord, the order is not there. In I can number 12, the order
Yes, it is there. Where that concession was recorded, Mr. Chakraborty.
my lord.
Where is that order? Please.
You have heard my case on 9th September, your lordship.
Mr. Chakraborty, this concession,
My
the
lord.
concession was for in a limited context. We can understand. Learned counsel appearing for the respondents contends that the deference to the desire of the court, respondents are ready and willing. That means your client.
My lord.
Ready and willing to substitute the order of removal from service by order of premature retirement. This was the only concession given by you, accepted by the court. We agree.
Yes, yes.
But no concession was given on her part to waive her claims regarding the salary for that period, which is her only claim now.
That
Please,
was
let
the
us.
direction of the court. Honorable
That is
court.
the direction of the. If that be the direction, it has to be preceded by some adjudication. There is nothing. Because just see, the court proceeds on the premise in view of concession made by the appearing parties. We dispose of the appeal by the following order. In view of the concession made by the appearing parties, this was not a concession by her.
Because no concession was recorded.
On this
Consent was recorded to that effect.
concession, only your concession, that instead of this removal of service,
That is a
premature retirement.
compulsory
And
premature
then
retirement.
if you do that, if you concede that, Mr. Chakraborty, it's an obvious corollary to that, that she's entitled to the salary because she'll be treated to be, it will be treated to be a premature retirement, and she'll be entitled to that.
Only 2 points.
So we'll grant that salary. You just on this you address and we'll dispose of the appeal in her favor.
On this, my lord, what I am submitting,
Yes.
kindly come to paragraph 4 of that.
Of that order?
No. The application.
Yes. Sorry, paragraph 4.
Paragraph 4.
Yes, Mr. Kut, paragraph 4.
In that order, order was passed. Some benefit was given, retirement benefits, and it was
No, definitely. Regarding other things, no difficulty. You are not in contempt of court and you have complied fully.
Yes.
But we are on that order only. We would recall that order. There is no adjudication. And the court presumes that that is also a concession. That was an adjudication without any adjudication. But it is said, if it was an adjudication, Mr. Chakraborty, even then we would be hesitant to interfere with that in review, in recall rather. But here it's apparent that the court proceeded on the premise that on the basis of concession, I am granting this, whereas that is not reflected. She never gave any concession whatsoever, at least from the recording of that order. Your concession, you are fair enough, But your concession also includes her salary for that period. If you say premature retirement,
Only
she isn't
to
entitled.
that extent, that is an implied consent, because our learned advocate at that point of time when this order was
Very
passed
well.
did not
Even
raise
if she
any
conceded
objection.
to this, let us proceed on the basis the concession is recorded to be, instead of removal, it will be premature retirement. This is the
Premature
only
retirement.
concession recorded. Even if she consented to that, then also she is entitled to the alimony, the salary for that period.
Only one thing, paragraph 4 of the
Paragraph 4 of that. Yes.
your petitioner states that she received her provident fund and gratuity dues after fighting a long legal battle through her retired with effect from 5th August 2023. For her arrears salary, she made another application after taking leave from the division bench, presided over by Honorable Ashim Kumar Banerjee and his companion justice on 7th
What is the
November
relevant portion
2000.
which you want to?
11. This portion.
No, such. We are allowing her application.
What I submit, my lord,
What do you submit?
they
Give her the salary.
accepted the order.
Running from
Something
pillar to
was
post
given,
in
something
this
was not given. Waited for 4 years, made a contempt application, obtained the benefits given to her, and thereafter, after 4 years, she came up with the application claiming salary.
Benefit
Whether
of-
this is permissible
payment
by way of
Gratuity
review.
Act was not given. Payment Gratuity Act speaks about cumulative interest. I
You
have
are
not.
allowing your application. The present application is in effect for review of an order dated June 6, 2022, whereby a Please take your seat. Let us pass the order. We are passing an order in your favor. You are disturbing us.
No, you're
Please take your seat, ma'am.
beg to
Is there a
differ.
seat behind you?
I
First,
beg
check
to-
up whether there is a seat. Sometimes it happens. There is no seat. Yes. Somebody takes the seat and Mr. Mishra might be sitting on your seat. Yes. Whereby a division bench proceeded on the basis that in view of a concession made by the appearing parties, comma, the appellant stroke review applicant would be treated as retired from service with effect from August 5, 2003. Full it was further recorded that in terms of the concession, comma, the allegations brought against the appellant would be treated as withdrawn and stroke or cancelled, and that the appellant would be entitled to all retirement benefits available to her up to August 5, 2003. Full however, comma, the present bone of contention is that the coordinate bench, comma, while observing as above, comma, added that the review applicant would not be entitled to salary for the period from September 5, 2001 to August 5, 2003.
Along with consequential benefits.
We are not passing any order. We are releasing the matter.
No, you're not.
Full stop. The division bench went on to hold that the review applicant, comma, however, comma, would be entitled to all notional benefits, including incremental benefits during that period for the purpose of computation of retirement benefits. Full stop. Next para. The petitioner, comma, appearing in person with the leave of the court, comma, submits that she never conceded to waiving the salary for the period between September 5, 2001 and August 5, 2003, and the concession, comma, if any, comma, was given only by the respondents to the limited extent that the order of removal of service of the petitioner would be substituted by that of premature retirement as on August 5, 2003. So next para, learned counsel appearing for the respondent contends that there was tacit consent on the part of the petitioner to the entire order dated December 12, 2019. Full stop. Even after having taken full Chakravarti, take your seat. Even after having taken full advantage of the order by accepting the other benefits, comma, the petitioner came after 4 years, comma, subsequent to filing of a contempt application, comma, in the meantime, comma, with the present review application. Full stop. Next para, it is, comma, thus submitted that the application is not only time barred but also not maintainable in law, comma, since the order under review was passed on consent. Full stop. Next para, upon careful consideration of the submissions of parties, comma, we find that although the petitioner uh, subsequently became an advocate, comma, she was not one at the relevant juncture. Full stop. Next para. The same is evident from the nomenclature of the present application itself, which states that the application is for, within double inverted প্রত্যেকটা letter cap দিয়ে দে, new cause of action arising out of cap say non-hyphen existence of the respondent Bond Standard Company Limited, double inverted close. Full stop. In the same breath, comma, it is stated that it is an application under Order 47, Rule 1 of the Code of Civil Procedure, as well as restoration of the case. Full stop. Next para. The caption also says that the application is under Order 9, Rule 9 of the Code of Civil Procedure. Full stop. Such confusion in nomenclature itself is indicative of the fact that the petitioner was not well conversant in law, comma, having not had much previous practice as an advocate, comma, and as such might well have been confused as to the remedy available to her. For some next para, it is evident from the filing of the contempt application in the interregnum by the petitioner that the petitioner proceeded on the premise that she was entitled to all retirement benefits on the premise that her date of service would be treated up to August 5, 2003, comma, including the salary for the entire period prior thereto. Full stop. Next para. Hence, comma, we find sufficient reason for condoning the delay in filing the review application by reading the prayer for condonation to be implicit in the application, comma, since the application seeks a review of the earlier order. Full stop. Next para. Upon entering into the merits of the matter, comma, we find that the concession, comma, as recorded in the order dated December 12, 2019, comma, was given only by the respondents and was limited to substituting the order of removal from service of the petitioner by an order of premature retirement as on August 5, 2003. Full stop. The petitioner never gave any consent, comma, at least as recorded in the said order. Full stop. Next para. In fact, comma, if we take the concession on the part of the respondent in its true perspective, comma, if the premature retirement was to be treated as on August 5, 2003, and the court directed, comma, as a consequence, comma, that all notional benefits, including incremental benefits during that period, would be paid to the petitioner for the purpose of computation of retirement benefits, comma, there could not be any conceivable reason for depriving the petitioner of the salary between September 5, 2001 to August 5, 2002, along with the incremental benefits associated, incremental and other benefits associated therewith. Full stop. Next para. In fact, comma, we find from the order in question that the coordinate bench proceeded purely on the basis that the order was being passed on the concession of the appearing parties, full stop. Even if the concession is taken literally, comma, the same would entitle the petitioner to salary for the entire period up to August 5, 2003, comma, the notional date of her premature retirement, comma, including the period between September 5, 2001 and August 5, 2003, comma, along with the associated other benefits, comma, incremental or otherwise. Full stop. Next para. Thus, we find that there was a patent error of law and fact in the order dated December 12, 2019, to the extent as indicated above. Full stop. It is well settled that the court's hands are not tied in the event the court finds a gross error or miscarriage of justice arising from flowing from its earlier order. Full stop. Next para. Such power is implicit in a court of law, comma, more so in a chartered high court, and as such, comma, we may very well traverse beyond the limited purview of Order 47 Rule 1 of the Code of Civil Procedure in view of the injustice done to the petitioner, and of ourselves, comma, recall a portion or modify a portion of a previous order passed by this court. Full stop. Going by such principle, comma, Can 12 of 2024 is treated to be a review application and is hereby allowed on contest, comma, thereby modifying the order dated December 12, 2019, passed by the coordinate bench in FMA 2447 of 2007 with Can 11913 of 2016 and Can 5206 of 2018, comma, to the effect that the portion of the said order which deprives the petitioner from the salary and the incremental benefits between September 5, 2001 and August 5, 2003, we hereby direct the respondents to pay to the petitioner her entire salary from September 5, 2001 to August 5, 2003, along with all notional, comma, incremental and other benefits associated therewith within a period of 1 month from date. Full stop. There will be no arrest to cost urgency.
Your Lordship,
period
kindly
may be-
include consequential benefits from the period,
Associated data column as well as all consequential benefits.
all consequences from 2003 to 2022,
Now we cannot
when the
increase-
company was existed.
Whatever you have given,
Thereafter-
only that. Yes, anything else?
Close the company.
Period may be extended by 1 month more.
1 month na kore thale within 2 months from date.
Your Lordship,
Can
kindly
12 টা show করছে না list এ?
amount.
প্রথমেই করে দাও Can 12 of such and such be treated to be on the days list. Nothing else. Thank you. Next.
Your Lordship, kindly mention the amount of
No.
consequences.
No.
Get calculated
Thank you.
amount.
Yes.
Maybe. Time for the plaintiff respondent.
Yes, Lord.
Is there some?
You have to ensure that it is not again kept parted, so be brief. He had already argued.
Yes, already. Mr.
Mr.
Ghosh already.
Ghosh had already argued.
Placed my-
Yes, yes, you had.
Mr.
placed-
Ghosh already argued.
Right. Just remind us, and I'll remind. I'll let my learned brother know about what happened before.
Yes.
পাঠানো হয়েছিল, আগে করছে, করে দিক, ছোট করে না। Mr. Ghosh, just remind us. We'll
Yes,
just recall.
I'm just, my lord, referring to the written notes I have submitted.
Oh, yes, yes, right, right.
I shall just refer to
We
it.
shall just go there and yes, yes. From there you can do. Written notes. This was your written notes.
Yes.
Plaintiff filed a suit. This start with this.
No, because
Just make sure of that.
it was
It is not
hard last, my lord, in the early part of.
law notes in FA number. Law notes in FA number.
Yes, yes. It
At the
starts
top.
with plaintiff filed a suit being titled suit number.
Law notes at the
Yes,
top.
yes. That is filed by the appellants. Appellants defend.
Yeah, Mr. Bhattacharya's note is there. Written notes
Yes,
of
yes.
arguments.
There's some mistake, my lord. The other day, my lord, we corrected that mistake also. That genealogical.
Which page? Mr. Ghosh, you just.
Genealogical table, my lord. There's some mistake. That was corrected by your lordship.
Acha, then. No, it was a part of your this thing.
My lord, in my note, my lord, I have given the copy of the judgment also,
Yes, yeah.
upon which we have relied.
Yes, yes, yes. Just for my learned brother, just remind us the facts of the case, Mr. Ghosh, and we'll conclude hearing.
My lord,
Single copy, double copy. Law notes you gave 2 copies each.
Yes.
Yes.
Yes, yes.
Justice Kumar নিয়ে চলে গেছেন। মাথা নাড়ছেন। কি করে নেবেন? এই ব্যাপার।
Everything দিয়েছিল that.
এখানে 2 কপি করে দেখেন, বার করে দিন। Law note। ওটা আপনি দেখুন, এটা আমি দেখছি। ওটা আপনি দেখুন। ওটা আপনি দেখুন। এই যে law notes। এটা হচ্ছে অ্যাপেলেন্টের, এটা অ্যাপেলেন্ট, ওটা হচ্ছে রেসপন্স।
এটা হচ্ছে
Yes, please continue.
May I place it?
No, need not place the entire thing. Just the facts of
No,
the case.
Only notes, my lord.
Notes also need not place. Just give the facts once more.
My lord, a suit was filed, your lordship kindly turn to the.
They were the
exact-
plaintiffs. They filed a suit.
Yes.
Yes.
Exact prayer of the plaintiff on the paper book. কবে আর কোথায় আছে?
No, you have even given that prayer in your written notes also, the first page. So no
Yes,
difficulty.
yes, yes.
That's very convenient.
12 থেকে 13
So it's a partition suit basically.
Yes.
On with a declaration that a deed of
Partition
settlement,
suit, further declaration that a deed
deed of settlement.
executed by the one of the Shebait is void. Well, the
Is equally binding. She says for declaration the deed of settlement
deed, my lord,
is equally binding.
deed of gift. A deed of
Acha,
gift.
E
Yes, yes,
is unlawful void. Right.
yes. But so far as the trial court judgment is concerned, my lord, so far as the partition is concerned, held in my favor. That no partition is not maintainable in respect of Devator property. And suit has been filed, my lord, your lordship will find, suit has been filed by the DT itself.
Yes.
Not, my lord, Shebait, my lord, on behalf of the DT itself, represented by the Shebait.
All right.
And so far as the first part, my lord, regarding partition, court held that no partition.
Devator property, no partition.
So that part, my lord, is in my favor.
But gift deed was declared to be
It
void.
has been said that it is void. To that, my lord, I can make my submission.
Yes.
Your lordship will kindly turn to
এই অনিন্দিতা এটাতে আমারও আমি নিজেও নোটস নিই ওরা নোটস ফাইল করার আগে আমার নিজেরও নোটস থাকবে থাকবে আমার তো নোটস থাকে সবসময় এটা তো রিটেন নোটস পরে ফাইল
এটা ওদের
সবসময় থাকে ঠিক আছে পরে খুঁজে দেখো ইয়েস প্লিজ কন্টিনিউ মিস্টার
just a minute, man.
ইয়েস টেক ইট
I'll kindly turn to page 3 of my note. Bottom.
Yes.
The defendant number 1 to 9, that is my client, referred the present appeal against the said judgment and decree internally upon the ground that learned judge rightly held that the property dedicated for fire uses cannot be divided, and if a division has been made, it is void. Reliance is placed in this connection to the leading case of Manohar versus Bhupendra, that is the full bench one.
Yes. Yes.
Still holding the field.
Still.
And then second one, Palas or turn of ownership is decodable, and also gift of Shebaitship in favor of a co-Shebait has been recognized if it is for the benefit of the endowment. The reliance is placed in this connection to the leading case of Manohar Bhupendra again.
Now, why did the trial court hold that that was void?
That relevant court.
What was the reason for? You have to also address that whether that is a good ground.
Judgment.
Otherwise, you may have a very good case, but why the trial court did it? Maybe for some other reason. Just look into that also.
Then, if your lordship kindly turn to page 2 of my note.
Very good.
I've given the
Yes.
findings in a nutshell.
Right.
Page 2 bottom.
Yes.
The learned judge in the court below, after considering the evidences adduced by the parties, disposed of the suit internally upon holding the following: that the plaintiffs are not entitled to get any degree for partition as claimed, that the deed is executed by Sukumar Chakraborty in 1996 is void and not binding upon.
But why? I mean,
that the settler Sarat Chandra Chakraborty, by executing the Akondama, dedicated all his properties to the deities, and settler did not reserve any right in respect of his properties to deal with the same in future. That the true import of the deed of settlement dated 19 February 1915 clearly goes to show that the settler never had any intention to partition the suit property in between his three sons. Rather, it was the intention of the settler to keep the suit properties in joint and Ejmali names, having right to reside therein and possess the same. And none of the Shebait can transfer or alienate the same, and it shall remain joint for all purposes, and there cannot be any partition. Or that the deed of settlement specifically gave direction that none of the Shebait can start Pala system to perform Seva Puja, that the deed executed by Sukumar Chakraborty has no binding effect upon the plaintiffs. This is that. That the present plaintiffs and defendant 2 to 9 are Sevais of the deities and they shall perform the Seva Puja jointly. My lord, if your lordship, my lord, like to go through that judgment itself.
That portion only will suffice.
Yes, yes. Judgment.
By the deed of gift, what was given to you, Mr. Ghosh?
My lord, one of the Shebait, his turn of
Pala's turn was given to you. The court said that that cannot be done.
yes.
That is the premise, basically. Yes, that appears from the judgment also. We are going through it. That the turns of any of the Shebaits cannot be transferred. That's why and all Shebaits should do it jointly. He gave only his turn to you.
Yes. And to me means, my lord, to the existing other Shebaits, not that to third party.
One of the existing other Shebaits.
Yes.
Not to all. But court apparently says it cannot be done. But if he was, he did not execute the gift deed, he would have that Pala in any event. So that right is given to you. Court says that cannot be done. But you say that yes, he would have done that. He did not give it to any third party. So why can't he do that? Relinquish his right
It's
in
for
mind.
the benefit of the deity itself.
And their argument probably would be that even if he relinquishes, it goes to the joint Shebaitship pool. Then everybody gets a turn. That's the one.
Page 80. Page 80.
Page 8. What?
80.
Page 80, my lord, is the
Judgment.
we finding that.
No, 80 is the start.
Yes,
Rather
yes.
start.
Finding that.
No, we are going through the findings actually.
Finding of CPA. Page 93. 94. 93. Page 95.
Page 95.
Yes.
Page 95.
Starts from page 90.
Paragraph starting from in this suit.
In this. Yeah.
Plaintiffs prayed for declaration that the deed executed by Sukumar Chakraborty in the year 1996 is
Right.
void and not binding upon them. Plaintiffs also prayed for a decree that they have the right to perform the Seva Puja to the deity and that the defendants have no right to obstruct them in performance of the Seva Puja as well as to get the share of the usurpers. To adjudicate all these disputes, the intention of the settler is to be looked into and has to be considered by religion concept and not by material concept. In the year 1949, settler, this is the original deed of settlement. Sarat Chandra Chakraborty executed the Arpannama and he dedicated all his properties to the deities, and settler did not reserve any right in respect of his properties to deal with the same in future. This concept has been accepted and settled by court when title suit number 184 of 71.
Mr. Coach, you can skip 6-7 lines. You can come to the true import of Exhibit
Yes,
1.
yes. The true import of Exhibit 1, that is registered deed of settlement dated 1958, clearly goes to show that the settler never had any intention to partition the suit property between the sons. Rather, it was the intention of the settler to keep the suit property joint and in Ejmali name. And he had only settled the property in between his three sons, having right to reside there. Had there been any partition of the suit properties, then the predecessor in interest of the parties can very well mutate their names and in respect of their specific portion of the suit property. Rather, the settler imposed the restriction in the deed of settlement to that effect that none of the Shebait can transfer or alienate the suit property by any means whatsoever, which deemed to mean that the suit property shall remain joint for all purpose, and there cannot be any partition of the suit property at any point of time. It is true that in the deed of settlement, settlor Sharat Chandra Chakraborty appointed his 3 sons as Shebait, and in the said deed he did not make any provision for losing the Shebaitship, nor he makes any provision for inheritance of the Shebaitship after demise of the one Shebait. The provision losing of Shebait and appointment of Shebait has been made in the deed for the year 1941. Defendants, though I am skipping over it, madam,
Yes, yes.
kindly turn to the middle. As there is no such provision in that deed of settlement as regards the
Yes.
inheritance of Shebaitship after demise of one Shebait, I think the deed which was executed by Sukumar Chakraborty in the year 1996 is in violation of the terms of deed.
Actually, he did not have a vested right in the Shebaitship. Basically, that is the principle. So he could not be inherited by his heirs, or no right, no vested right. He could not transfer it. He had to go in its own way. If he relinquished, then the others all would have. This is the premise. So let us come back to your written notes. We were at page
3.
uh,
No,
4, in fact, 4.
4. Yes.
Yes. 2 would be your main, one of the main.
Yes. Palas or turn of ownership is becauseable, and also gift of Shebaitship in favor of a co-Shebait has been recognized if it is for the benefit of the
This is very crucial. Yes.
Reliance is placed in this connection to the leading case of Manohar versus Bhupendra in AIR 1932 Calcutta, page 791 at page 29 of 44. Shall I place that or
Need not, need.
I have mentioned it?
Yes.
As the alienation was by an Orponnama to closely connected member of the family who seems to have more interest in the worship of the idol than anyone else, and as it seems to have been without any idea of personal gain, in order to prevent the interference of the appellant who claims herself as an alienee of the interest of the defendant number 5 to 7, we consider that the case is governed by the special circumstances to which MacLean CJ in Nirod Mohini Dasi versus Sivdas Pal at page 1 to 2. Copy is annexed, my lord. I have annexed it.
Yes.
The office of Shebaitship being hereditary, it devolves like any other species of heritable property. Reliance is placed in this connection to AIR 1979 Supreme Court, page 1682. So
Yes.
these are the, if you lordship want to read the portion of the judgment.
Yes, page 29 of 44 of the first judgment we have seen. Gifts of Shebaitship in favor of a co-sharer. After that, within bracket 47. And the entire thing, I mean, in a family governed by Mitakshara, thereafter.
Yes.
Page 29 of 44, gifts of Shebaitship in favor of a co-Shebait has been recognized.
Actually, Manohar Bhupendra dealt with
All the aspects,
every
all the
aspect of
aspects, all the aspects of it.
If you lordship time
That was an authority for all the aspects of
that is still holding the
still holding.
and it has been relied upon in 1979 Supreme Court also, which I have given to you.
There is one sentence here, page 29, if you come, Mr. Ghosh, after within bracket 47, your judgment, Manohar's judgment.
Manohar Bhupendra. Yes.
Yes, Manohar, bottom, the page number is at the bottom, 29. 29 of 44. Your Honor, Junior can help you. 29 of 44.
Yes, page 29 of 44.
You see within bracket there are certain numbers after 47.
Yes.
Gifts of Shebaitship
Gifts of Shebait
in favor of a
Shebait
has been recognized. Then, though this is not allowed,
except on the ground that such a transfer is for the benefit of endowment. Govinda versus.
So was there anything in the gift to say that it was for the benefit of the endowment? Or should we read that into the gift?
Yes, that I can place it, my lord, if your lordship so want.
Very good. We'll come to that after these judgments. If there was any mention of this, that it is for the benefit of the estate or something like
Yes.
of the endowment. The rest, yes. Court says right to office.
This is only
be acquired by adverse possession even. That has also been discussed here.
Yes.
So that's
there is no question of any adverse possession here.
No, that is going too far, in fact.
Yes.
Shebaitship by adverse possession. Then somebody's law practice can also be taken by adverse person. It is done actually sometimes and is absent for some time.
My lord, if I may say so, my lord, in our early days,
Yes.
Apurvodhan Mukherjee,
Yes, Mr. Mukherjee.
it can be said that it is acquired by adverse person.
Not
Nobody,
adverse person.
no other
No,
learned lawyers, my lord, could contradict him. But his very appearance is very casual and
His appearance, I have not seen him
you have not
practice
seen
now.
him.
I had not come. You have seen, obviously. You are much.
However,
But his legacy, we have heard a lot about him from you all only.
in
So-
fact, my lord, in one of such judgments which is reported
Yes.
in connection with Arbitration Act, reported in 1973 Calcutta.
Huh.
Matter was heard by Justice Laik, sitting with Justice Sengupta, KJ Sengupta. In that matter, my lord, Mr. Dasgupta, Mr. Apurvodhan Mukherjee appeared against us. And I was led by Mr. Mukherjee as usual.
What was the point?
But it was hard for 21 days.
So on what point there was it?
The difference in 1940 Arbitration Act and the subsequent arbitration change
But change is in 1996, much later.
1996.
But it was, you say it's a
No,
73 judgment?
not 9. After
Oh, pre 40
73,
Act.
yes,
Acha, acha, acha.
73. And I remember, my lord, Mr. Mukherjee, and that, my lord, in connection with a learned lawyer of the Howrah Court.
He was the arbitrator.
No, personal matter.
Personal.
And Mr. Mukherjee, my lord, practically prepared a
Thick notes.
note, my lord, in an exercise book, which is itself, my lord, very.
Treatise on the subject.
However, so these are the.
You have also handed over a copy of the deed of gift. This is the deed of gift.
Yes, all the.
No, this is a
deeds are-
settlement. Oh, all the deeds you have given.
All the details.
Deed of settlement.
First, initial is 41,
Huh.
by which the transfer or dedication was made.
And your deed is 96.
96.
So that is a Shebait Niyog Patra.
Yes,
So let us see whether there is anything.
yes. We'll read the quick. Detail.
Yes, one line is there, Mr. Ghosh. We are looking in sentences in your favor so that Mr. Bhattacharya can controvert those. Page 2,
Yes.
the fourth last line. আমার অবর্তমানে উক্ত গৃহদেবীর সেবা পূজায় কোনো বিঘ্ন না হয় তৎকারণ.
Yes.
So that probably satisfied the requirement in Manohar that for the benefit of the endowment. That's all.
These are.
Now, Mr. Bhattacharya,
My lord, after his submission, my lord, if necessary, my lord.
if
kindly give
necessary,
me
otherwise
2 or 3 minutes. My lord, your lordship, I wanted a.
we won't indicate whether it's necessary because of we have made up our mind. But
No,
if necessary, some new thing is placed.
In his notes, my lord, I have seen he has mentioned certain judgments. It may be, my lord,
Well,
I have to.
Maybe distinguish. Yes.
And my lord, the genealogical table your lordship wanted on that.
Please give a copy to him also so that
Yes.
later on there cannot be any.
Follow before.
Who gifted the property just in this genealogy?
Bharat Chandra Chakraborty is the original testator.
No, that gift did 96.
Sukumar.
To Kumar, yes.
That is
Last but one.
Yes.
last but one. Sukumar's son.
Sukumar's son,
4th of February 2000.
1960.
Sukumar to sons of Rajkumar.
Sukumar
And
to
To
son.
sons of Rajkumar.
Rajkumar is one of the other sons.
Rajkumar is the brother
So,
of Sukumar,
The entire last line.
Yes.
They got it.
not the female, but female heirs.
Acha, the,
Only the 6 male nephews. Mohanlal,
there was some restriction in the deed of settlement regarding male or female
no, yes, female excluded.
in the settlement itself.
These
Yes.
are-
Make it
So, Mr. Bhattacharya, yes. Mr. Ghosh, please take your seat. Yes.
Original settler is the Sharat Chandra. Original.
Yes.
The 3 sons, Kanai, Sukumar, Rajkumar. But Kanai, the predecessor of the plaintiff,
Other sons also, Bolai, he died.
2nd March 2001.
Achha, all right, yes.
Hukumar died on 4th February 2000. And Rajkumar died before that month.
Right.
Now you also can you see first date 1958. It's a Bengali. 1958. All right. You also have gone through the judgment. The Pala system that's been started by the present Shebait mutually. But kindly see the page 1958 document.
Yes.
19th February 1958. All right. This no, sorry, madam. First 1941. Well, I'm sorry. Back to 1941. 1941.
It's within these.
1941. First 1941. Have you got it, madam? But most of the
yes, 1941.
1941. But you're also going to see. Now reading, my lord.
Orponnama.
Orponnama.
Yes, Sri Durga didn't have a.
Yes. Sri Durga Orponnama. This is 41.
All. So what is this? Achha, very good.
41, 58, and 96.
41, 58,
and 96.
Very, yeah. There are 4 documents. What is the other one? Shebait Niyog Patra 2000.
No, 3 documents.
3 documents.
There must be.
96 is the deed of transfer, my lord.
There are 2 copies of 96. Very good.
আপনার কাছে 96 কপিটা আছে?
Yes, please come there, Mr. Bhattacharya.
Yes,
41.
I'm reading, my lord. Page 3 start from Ichha Nusare.
Mr. Ghosh, have you given copies of your version to him? Otherwise, pages may not tally.
Yes.
These are your versions.
Written note.
No, this is not that.
It is our version.
Your version, but then the pages won't tally.
Start from
written notes not
start from, my lord. Municipality. Have you got it, my lord? Page 2.
Page 2.
In Bengali, that's a municipality. No. In English.
In English, it's municipality. Yes, municipality.
জমিদারি ফেরেস্তা
Got it.
আমার নাম বহাল আছে আমি আমার 4 পুত্রকে সেবায় নিযুক্ত করিয়াছিলাম কিন্তু তাহারা নাবালক থাকায় দেবীর সেবা তাহারা করিতে পারে নাই মিউনিসিপালিটি ফেরেস্তা আমার নাম বহাল আছে
This is not telling.
নিজে
Somewhere else also municipality might be.
মানে skip over next page. ইচ্ছা অনুসারে আমি উক্ত দেবীর পূজা সেবা পূজা এযাবৎ কাল করিয়া আসিতেছি
ইচ্ছা অনুসারে, yes.
আমি উক্ত দেবীর সেবা পূজা এযাবৎকাল করিয়া আসিতেছি এ কারণ উক্ত দেবীর সেবায় যাবজ্জীবন কাল আমি আছি এ কারণ অবর্তমানে আমার তৎকালীন জীবিত পুত্র বা পুত্রগণ বা আমার
You are skipping lines.
No.
Yes, here there are other lines. In our copy, ইচ্ছানুসারে আমি উক্ত দেবীর সেবা পূজা এযাবৎকাল করিয়া আসিতেছি এ কারণ উক্ত দেবীর সেবায় যাবজ্জীবনকাল আমি রহিব আমার অবর্তমানে আমার স্ত্রী শ্রীমতী কস্তুরী দেবী সেবায়িত হইবে
এবং was not there why did you from what
the original deed it was.
The original is annexed with the
no in 41 স্ত্রী was not there.
I mean স্ত্রী I am not talking about the স্ত্রী also.
Don't talk about the স্ত্রী. Come to the husband. Yes.
Anyway, that has been added
হইবে তাহার অবর্তমানে maybe when the deed was executed she was alive but when he died. Yes.
জীবিত পূজা পুত্রগণ আমার ওয়ারিশগণ সেবায়িত হইবে যদি কোনো সেবায় দেবী যথাযথ সেবা পূজা না করে অথবা ধর্মান্ত গ্রহণ করে বা অসচ্চরিত হয় তবে অন্যান্য সেবায়তগণ বা বংশের যে কেউ তাকে সেবায়ত প্রদায়িত অপসারিত করিতে পারিবে এবং উপযুক্ত ব্যক্তিকে সেবায় নিযুক্ত করিতে পারিবে। That is 1941. Then my dear second page 58.
58.
Line number, my lord. First word. পোষ্য সেটেলমেন্ট বন্দোবস্ত আমার নিজ নিবুড় সত্য দখলি অর্থ সাচানসার অন্য সম্পত্তি সকল ইংরেজি 1941 চৌঠা জুন তারিখে লিখিত হাওড়া জয়েন্ট সাচানসার কিন্তু দেবীগড়ে নিত্য সেবা পূজা করিয়া আসিতেছি।
This is by whom? By the same person?
Same person.
The sons?
No.
Oh, same person. Yes.
Then my lord, skip up next page whether that will be পূর্বে লিখিত page 2. I also got him version পূর্ব লিখিত অর্পণনামা দলিলে
Yes, এখানে
পূর্ব লিখিত অর্পণনামা দলিলে ভাবি সেবায় নিযুক্তকরণ বা দেব সেবা চালান বা রক্ষণাবেক্ষণ
পালন পালন
পালন লিখিত পঠিত করা হয় নাই। তজ্জন্য অর্থ সেটেলমেন্ট দলিল দ্বারা এইরূপ বন্দোবস্ত করিয়াছিলাম যে আমি জীবিত কালতক সেবায় রূপে দেবত্ব সম্পত্তির সকল তত্ত্বাবধান ও রক্ষণাবেক্ষণ করিব ও সেবা পূজা আদি যেরূপ করিয়াছি সেরূপ করিব। আমার পর অর্থ সেটেলমেন্ট গ্রহীতা আমার পুত্রগণ ওয়ারিশগণ কমে আমার ন্যায় সেবায়েত পদে নিযুক্ত থাকিয়া উক্ত দেবীগণের সেবা পুজো আদি সাজ করিবে, আমার স্থলে সেবায়েত স্বরূপে থাকিয়া দেবাকৃত দেবত্ব করিবে। নেক্সট পেজ my lord. রাইট ফ্রম ওই সকলের যে আয় উপস্থিতি হইবে তাহা হইবে দেবীগণের সেবা পূজাদি করিয়া যাহা উদ্বৃত্ত থাকিবে তাহা 3 ভাতা তুল্যাংশে লইবে। মাত্র আমার নিজ তহবিলে রক্ষিত নগদ টাকা সোনারূপা কাপড় গামছা অস্ত্রপর পিতল কাঁসা তৈজস প্রত্যাদি সকল হইতে আমার অন্তঃস্থিতীয় খরচাদি ভাবে যাহা কিছু উদ্বৃত্ত থাকে তাহা পুত্র সুকুমার ও রাজকুমার চোখের তুল্যাংশে গ্রহণ করিবে। উহাতে 1 নম্বর গইতে কানাডা চোখে কোনো সত্য অংশ দখল অধিকার থাকিবে না। অর্থ দলিলে এত স্কোয়ারটি সার্জেন্সার কানাডা যদি প্লট 3 প্লট বি ওয়াই নট ফর সার্জেন্সার। নেক্সট, শ্রী রাজকুমার চক্রবর্তীর পুত্র পৌত্রাদি ওয়ারিশগণ ক্রমে আমার ন্যায় আমার পরবর্তী সেবায়ত ক্রমে ভোগ দখল করবে, কিন্তু কখনো অস্মিনকালে কোনো প্রকারের হস্তান্তর বা দায়যুক্ত করিতে পারিবে না।
This is against Rajkumar.
আমার ন্যায় আমার পরবর্তী সেবায়ত ক্রমে ভোগ দখল করবে, কিন্তু কখনো অস্মিনকালে কোনো প্রকারের that line is there, madam.
Rajkumar is our client.
Rajkumar is restricted, not Sukumar.
হস্তান্তর দায়যুক্ত করিতে পারিবে না।
Where is Sukumar spoken about previously? Now come to the previous.
ও আদি 2 নম্বর গ্রহীতা সুকুমার চক্রবর্তী স্কয়ার ফুট জমিতে যাবতীয়
যদি কিছু উদ্বৃত্ত থাকে তাহা পুত্র সুকুমার ও রাজকুমার তুল্যাংশে গ্রহণ করিবে।
হ্যাঁ।
দেন উহাতে 1 নম্বর গ্রহীতা কানাইলালের কোনো অংশ থাকিবে না।
থাকিবে।
কানাইলাল ইজ আউটস্টেড। Now next is অর্থ দলিল একাংশ নকশা লাল বর্ণ সাচ এন্ড সাচ
Yes.
স্কয়ার ফুট গ্রহীতা শ্রী কানাইলাল চক্রবর্তী প্লট সাচ এন্ড সাচ সুকুমার। ভেরি ওয়েল। 44 ফিট ও তদস্থিত
Yes. 3 নম্বর গ্রহীতা
প্লট ডি এন্ড ই ডিওই চিহ্নিত 13 ছটাক 44 স্কয়ার ফিট জমি ও তদস্থিত যাবতীয় স্ট্রাকচারস আদি 2 নম্বর গ্রহীতা শ্রী সুকুমার চক্রবর্তী
ও প্লট বি
চক্রবর্তী stops there.
Yes.
Then this is for Sukumar.
Sukumar.
And then the rest
বি
3 নম্বর গ্রহীতা রাজকুমার চক্রবর্তী পুত্র আচ্ছা you say this covers everybody.
This covered everybody. That is my submission.
Sukumar, Rajkumar, etc.
Yes.
Such and such পুত্র পৌত্রাদিক্রমে
Yes. বা দায়মুক্ত যুক্ত করিতে পারিবে না। উপরোক্ত নিম্নে তপশিলে বিশেষভাবে বর্ণিত উক্ত নকশায় প্রদর্শিত যে খালি জমি উঠান জল সার্টেন ওই খালি অংশে কেউ কোনো স্ট্রাকচার
So this is very crucial.
পূজার জন্য কেহ পালাপ্রথা করিতে পারিবে না। But can it be defined without following that intention of the settler, the mutual take and start pala? What happened, my lord? My client is not being with the plaintiff, is not being able to do the pala system also. That they are not going to perform Shiva Puja. There's a very famous San Jatra in the month of Magh. Huge, there are huge money. That's so many donations.
So why you are not being permitted? That is your
I have not been permitted because now there's a
that is a different allegation.
On the basis of this pala system, they have pala system 4 months, 4 on each.
But it says this says
পূজার জন্য কেহ পালাপ্রথা করিতে পারিবে না। It has been reflected in the judgment also.
So you are also doing the pala, acceding to the pala puja, contrary to this.
My client was saying that he is not being able to perform any pala.
No, but you also rely on the pala
yes,
system,
yes.
which is contrary.
But now I am submitting.
So you have acceded both of you to pala system.
Yes, but mutually that cannot
for
be.
convenience, obviously.
That my submission that cannot be. If it gave consent also mutually, it is not permissible. The 50. Then, my lord. Yeah. Sukumar, 1996. 1990.
Yes. 1996.
We'll start from on page 2, pure originality. উক্ত অর্পণনামা দ্বারা আপনার আমরা রেজিস্ট্রিকৃত 1 নম্বর ভলিউম 31 পৃষ্ঠা হইতে 34 পৃষ্ঠা লিপিবদ্ধ সাজানচার অর্পণ দ্বারা দেয়ার আফটার
Is the middle of a paragraph? What is the start of that paragraph?
Last 1, 2, 3, 4 or
What is the start of that paragraph?
paragraph উক্ত অর্পণনামা দ্বারা
তিনি আরো নির্দেশ দেন যে
yes 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 উক্ত অর্পণ after 1940 such and such উক্ত অর্পণনামা দ্বারা
then please continue.
মানে উক্ত অর্পণনামা দ্বারা তিনি আরো নির্দেশ দেন যে তাহার অবর্তমানে তার স্ত্রী ও আমার অর্থাৎ আমার মাতা কৌস্তভী তৎকালে তার জীবিত পুত্রতয় বা অর্থাৎ কানাইলাল চক্রবর্তী আমি সুকুমার চক্রবর্তী আমার কনিষ্ঠ ভ্রাতা রাজকুমার চক্রবর্তী ওয়ারিশগণ ক্রমে সেবায় পদে নিযুক্ত হইয়া উক্ত গৃহদেবীর সেবা ও পূজা করিবে। বর্তমানে আমি বিপদনিক, আমার কোনো সন্তান সন্ততি নাই এবং আমার যথেষ্ট বয়স হয়েছে, আমি আমার কনিষ্ঠ ভ্রাতার সংসারে বসবাস করিয়াছি এবং তার পুত্রগণকে অর্থাৎ গ্রহিতাগণকে আমি পুত্র শ্রেণীর পান করি। উক্ত ভ্রাতুষ্পুত্রগণ আমার প্রতি যথেষ্ট শ্রদ্ধাশীল যত্নবান এবং দেবীর ভক্তিবান। আমার এই পরিণত বয়সে উল্লেখিত গৃহদেবীর সেবা পূজা ও পার্বণাদিতে অতি নিষ্ঠাশীল করেছে। আমার অবর্তমানে উক্ত দেবীর সেবা পূজায় কোনো বিঘ্ন না হয় ও তৎকারণ উহাদিকে সেবা পূজায় বিঘ্ন না হয়। সত্যান সাজ মোহনা সত্যান সাজ গৃহদেবী সিদ্ধেশ্বর কালী মাতা ঠাকুর আমার স্থলে আমার পরবর্তী সেবায়ত পর্যায়ে নিযুক্ত করিলাম। উক্ত সেবায় দ্বারা আমার অবর্তন আমার স্থলে স্থলাভিত্তিতে বর্তমান সেবায় আপোষ চুক্তি অনুসারে প্রতিবঙ্গে সত্যান সাজ উক্ত দেবীর উক্ত স্থাবর অস্থাবর সম্পত্তি আয় উপস্থাপিতি গ্রহণ করিয়া দেবীর সেবা পূজা মন্দির সংস্কার সাধন ও মন্দির বাবদ প্রদেয় খাসনা ও ট্যাক্স ও আনুষঙ্গিক খরচাদি ব্যয় করে যদি উদ্বৃত্ত তত্ত্ব থাকে উক্ত ভ্রাতুষ্পুত্রগণ অর্থাৎ তার সেবায়তগণ উহা সময় অংশগ্রহণ করিবে।
Who are you? Who are you, Mr. Bhattacharya, in the genealogical table? Who are you?
Oh, I'm for the Kanai. I've come from Kanai. Kanai.
You have been excluded with your heirs.
Kanai has died. We are heirs of the Kanai.
So you're trying to get indirectly what you were not given directly.
That is why
You have no local standby.
I corrected it.
What happened to Rajkumar? Rajkumar is still alive.
No. That is why.
Oh, these are Rajkumar's sons.
These are the Rajkumar.
In fact, Kanai instituted a suit previously challenging this deed.
That
What happened to that?
lost up to this honorable court.
That has not been considered by the trial court. Did you not point that out?
No.
That is a
Then
separate.
we cannot look into it.
No, that has been pointed out.
That has been pointed out, but no importance was
Which page of the paper book it has
No.
pointed out? It is not there in your written notes of arguments.
Let him proceed, my lord. I shall be.
Yes. We have come from Kanai. Hey, Kanai. Kanai Sukumar Rajkumar. That is a page 10. But other day also the matter was I corrected it. It's a mistake, it's a typical mistake. Then my lord.
Typographical mistake. It's not a typographical mistake that you are the heirs of Kanai. You don't have any right, Mr. Bhattacharya. You don't have any locus standi to institute this. You have been excluded with your heirs and whatever.
Then my lord.
It's like that Bengali saying, "Oh, bhai, Kanai kare jane." That
But
principally applies to you.
উদ্বৃত্ত অর্থাৎ তাহা ভ্রাতুষ্পুত্রের সেবা দেওয়া গ্রহণ করিবে। সাজান স্যার সাবডিশন সাজান নেক্সট পেজ পেজ 5
আর এই তো সুকুমার আর রাজকুমার দুজনেরই হয়ে এরা সুকুমারের এয়ার সুকুমার এয়ার অবশ্য ওরা
নো মাই সাবমিশন was the day
কারণ
the Sukumar died.
You also would be heirs of Sukumar.
Yes, the
On
50-50.
equal footing as them.
Equal footing. 50-50. Then my lord, page 5 next. আমি আরো নির্দেশ আমি আরো নির্দেশ দিতে হি কন্ডিশন পুট কন্ডিশন অরিজিনাল সেলার 1941 then 58 আমি আরো নির্দেশ দিতেছি যদি কোন সেবায়
The অসৎ চরিত্র was there in the previous one.
that is it.
And it's very difficult
No,
to
no,
prove.
yes. I am not saying that. আমি আরো নির্দেশ দিতেছি যে যদি কোন সেবায় is putting this condition কোন সেবা দিন plaintiffs also 10 Samsur. Not the years, রাজকুমার যদি কোনো সেবায় দেবী সেবা পূজা বিত রাগ হয় বা অসচ্চরিত হয় তবে তিনি সেবায় দেবে কার্য নিয়োগ করতে পারিবেন না তৎসলে অপর সেবায়তগণ সম অংশে দেবী সেবা পূজা করিবে।
He is referring to the Shebites as he has appointed.
He has appointed. No, he's meaning thereby he is appointed. By my subject before he put this condition, defines that original settler intention. That is
Yes,
my
in
submission.
line with that. So what is the difficulty there? We don't understand.
My
This is in consonance with the original settler's intention also. Bitarag hoy অথবা অসচ্চরিত.
Yes.
Same thing.
যদি
He
সেবায়
is carrying that forward to his person, the persons to whom he is giving.
my submission মানে he can suppose for the sake of he had transferred sebae seat only because of my I have been aged.
Suppose that is done,
only
yes.
that. If what is
This
what
is
is
a restriction
what
which is there in the
what
original.
conditions there, they everybody will follow. My subject before.
This condition was there in the original settlement deed also. So this is not a new thing he is imposing.
যদিও সে দেবী
Same thing.
my lord দেবীর সম্পত্তির সমংশ বক্তব্য উক্ত সেবায়তন একমত হইবা কিংবা সকলে একমত হইতে না পারে অধিকাংশের মধ্যে সেবায় নিযুক্ত করিতে পারিবেন সেবায়ত করে যেতে বাট ফার্স্ট ইন্টেনশন নোবডি ক্যান ট্রান্সফার সেবায় মাই সাবমিশন বিফোর হয়েছে ইট ইজ লাইক ইনহেরিটেন্স বিকজ মানে সুকুমার হোয়েন ডায়েড মানে কানাই ডায়েড অন 2nd March 2001 after death of Sukumar. It was like
2nd February 2001.
yes, the Mr. My Ranepend also submitted before office of Shebait is heritable. If it is heritable, nobody can transfer the Shebait is the Kanai. He will be the yes, the 50-50. The Rajkumar sons the present appellant.
Let
He
us
will
once,
get 50%. We will get 50%.
Mr. Bhattacharya, let us come back once to the 58 deed where Kanai was excluded. Let us see how he was excluded.
58.
58 deed internal page, the portion which you placed just above that, where D plots, the plots have
Oh,
been
that
demarcated.
is so far as
No, we are wanting to see the exclusion of Kanai, the language of that.
No, last
You come there, the pages,
পুত্র
no, where তিন ভ্রাতায় তুল্যাংশের লইবে,
yes yes
there, মায় আমার নিজের তহবিল রক্ষিত নগদ সাচান সাচ,
yes
তাহা পুত্র সুকুমার ও রাজকুমার, উহাতে 1 নম্বর গ্রহিতা শ্রী কানাইলাল চক্রবর্তীর
কোনো
সত্য সংস্রব দখল অধিকার রহিবে না. So as per your case also, when Rajkumar died, Kanai was alive, but Kanai has been excluded from the entire thing, including Devdevi Seva Pujo.
no Dev is the upper for partition that was we did not that the suit has been decreed in part for partition is concerned that has been our pair has been turned down only Dev
Actually, let us come back to the previous page in your favor. We are now speaking in your favor.
yes
তজ্জন্য অর্থ সেটেলমেন্ট দ্বারা পূর্বলিখিত অর্পণ নামা দলিল, the portion which you placed.
Your Lordship is reading from
This is page 2 of your
Page
58 deed.
আমার পর অর্থ সেটেলমেন্ট
58 deed, page 2, middle. পূর্বলিখিত অর্পণ নামা দলিলে ভাবি সেবাই
অপরাধে ভাবি সেবায়তগণ নিযুক্তকরণ বা দেব সেবা চালানো রক্ষণাবেক্ষণ
তজ্জন্য অর্থ সেটেলমেন্ট এইরূপ বন্দোবস্ত করে যে
বন্দোবস্ত করিয়াছিলাম যে আমি জীবিত করত সেবা
after that sentence,
Yes.
আমার পর, please read from there, that goes in
আমার
your favor.
পর অর্থ সেটেলমেন্ট গ্রহীতা
আমার পুত্রগণ,
আমার
so you are
পুত্রগণ
not excluded there.
yeah not excluded there
So Kanai is
All.
not excluded from
No.
the Shiva Pujo.
what else was not excluded
He was excluded only in those properties which have been demarcated.
আমার ন্যায় সেবায়ত নিয়ে থাকে উক্ত দেবীগণের সেবা পূজা দিয়ে আদি করিবে ও তপস্বী দেবীদের সম্বন্ধে যে রূপ এক করে বসবাস করেছে আমার সহিত একসঙ্গে সংসার করতে আমার স্থলে সেবায় থাকে আর দেবগীত বজায় রাখবে ও দেবত্ব সম্পত্তি সকল তথ্যের মতো রক্ষণাবেক্ষণ করিবে.
This read with that they cannot part with kono prokar hostantor ba daya and no pala protha.
And no pala.
So as per the intention of 1958 deed,
Yes.
all of Kanai included, Kanai was included for that Shiva Puja.
Shiva Puja.
All of you would be entitled to do that.
Yes.
And other Kriyadi and everything. I Upasattadi that also.
That yes.
Teen bhataay. Teen bhataay, right. After that, some property, other property that regarding that you have Kanai has been excluded.
Yes.
So if you had a right, teen bhataay tullangshe loibe, I and the Shiva Puja,
yes,
without there being any pala,
any
without there being any transfer rights,
yes,
then all of you had to do it, and then all of your arguments come.
Yes. That is my submission before Lordship. Then, my Lord, you also did my submission before Lordship. The learned child that did not commit any mistake, my Lord. If you kindly see page 96 and 97 of the judgment.
These were considered, yes. We were looking to that, but you can please that. Yes.
Property that has been allotted in paper, we are not.
Property,
No,
you are
no,
saying-
yes. My Lord. My Lord.
Yes, he says none of the Shebites can transfer. He considers the deed of settlement. Can transfer, alienate, property shall remain joint, and no provision for losing Shebiteship.
Yes.
That is also what he says.
Yes.
No such provision for inheritance.
Yes. Also, my Lord, to import or exhibit one registered deed, middle portion, or a settlement deed such as clearly goes to show the
Yes.
settler never had any intention to partition the suit person. That's it. Rather, it was the intention of settler to keep the suit in joint, such and such. That is why not.
So therefore, your contention, Mr. Bhattacharya, in effect is because you cannot blow hot and cold in the same time if you are relying on that deed.
Yes.
So your partition suit may fail, but the declaration regarding the gift deed should remain.
Yes. Partition will fail. We are not talking about partition.
But the gift deed should go.
Gift should
That
go.
gift deed.
Yes. Rather, the settler impose a restriction, the deed of settlement, to the effect that none of the state can transfer or alienate the suit by any means whatsoever, when deemed to mean that the suit property shall remain joint for all purpose, and there cannot be the suit property shall remain joint. There cannot be any partition of the suit property at any point. It is true, but we are not talking about, we did not file any appeal also against that. Then on the next page.
No provision for inheritance.
Let's say inheritance of Shebait after demise of Shebait. If the provision losing Shebait appointment has been made such as the dependent, though Alienal canonical never performed the Shiva Puja, but to that effect they failed to bring any positive evidence. I do not find any evidence from the case they got to withhold that canonical Chowdhury had lost his Shebait in terms of the deed of settlement for the year 1958. That just fallen from your losses also. Shebait that has been.
Yes.
Then
yes.
needless on Sajan sir. Then, my Lord, and after his demise, the present plaintiff became Shebait of the deities, and accordingly, the right to perform the Shiva Puja and all other religious such and such.
Yes.
As there is no such provision in the deed of settlement regarding inheritance Shebait, I think the deed using Sukumacho.
Get your point.
Yes,
We have seen this.
Then Pala also, my Lord. Next. Moreover, start from the said deed executed Sukumar, I find that
we have marked that. Pala, it is totally against the intention of the settler.
Yes.
And you have placed that clause also.
Yes.
You
Clause
placed
also.
before us that clause. So the start Pala Puja, Pala cannot be started. None of the Shebites can start Pala Protha.
Yes.
That is the finding of the court.
That's right.
What is your argument on this partition suit not being maintainable?
Partition suit,
so part of the relief could have been refused, part should have been granted.
Yes. But partition suit, we did not. We accepted that, but so far only for Shiva Puja.
What will happen to the poor deity? You are at loggerheads.
Yes.
At least if there was Pala system, something could be salvaged for the deity. Anyway, if this deed of gift remains, then you don't have anything.
Yes.
That is contrary to the intention that is.
Well, I have cited one judgment.
Yes, let us see your. In your written notes, that must be there.
That judgment 2004, volume 4, CHN.
Where are your arguments in the written notes?
Oh, yes, yes.
Evidence, everything we can understand. What is the argument? You are reproducing the ground.
Here. Now start from page 15.
Yes.
The
C. present case, Sukumaji Seva Devatore
page 15 of his.
Such and such take all income derived from movable immobile such and such, the interest of such and such. But that was my submission. Shebait right cannot be transferred for pecuniary consideration. But for pecuniary consideration submitting, he has stated whatever the residue that will be the present defendant, they will get the residue. What will income? Income is derived. That is it. Then, my Lord, the section 402 Hindu provides the Shebait has no power to alienate property of idol and devoted property. That section I have mentioned.
It is not for pecuniary consideration.
But what this is a residue. The what are income are coming. But-
the gift deed is not for residuary, for any monetary consideration.
that is not for monetary consideration.
Why have you taken this?
No,
This
I am
is
not saying that.
applicable.
Either for monetary consideration. No. That I have.
For pecuniary consideration,
That's
it's a gift deed.
give it. That's it. Then, my lord, if Shebait cannot delegate his duty and cannot create any interest in mock property during his lifetime, it's a Shebait. Then, my lord, Fukumacho did not utter in single deed of transfer against Kanal for making said transfer. Transfer was alive. He was not dead, Kanal. Who excluded Kanal? Then, rather, gift deed of Shebait Devoto also, which allotted to him under deed of execution. It was not declared that other Shebait Kanal violated the condition of settlement such and such.
Your written notes are very confused and prolonged unnecessarily. Could have given bullet points. Very short points involved. So why did you go into so much? Should have referred to the 1958 deed, specific provision.
And 41.
Yeah, and 41 and 58 is a crucial.
Yes, 58 is a
deed, actually.
Yes.
So that provision that regarding this Shebaitship,
Yes.
all three sons were given, not only Shebaitship, but to enjoy the usufructs of that, whatever I and etc.
Yes, yes.
That was given to all the three persons. Certain specific properties were excluded. Kane was excluded in respect of those. But regarding Shebaitship, all three and their heirs.
And there.
And regarding income.
Now,
This is your main point.
main point, and not only that, my lord, my service, because he cannot transfer by making a deed of 1996. Because if the Sukumar died, what will the effect? Sukumar died. When the Sukumar died, my client, my lord, the Kanal was alive. Kanal was alive. His share, according to inheritance, he will get that property. 50-50. My client will get the 50, and the heirs of the Rajkumar, they will get 50.
You get through Kanailan himself.
Yes. Then 2004, volume 4, Calcutta High Court notes, page 435, I have handed over. Other day, my lord.
You have not referred to that here?
Yes. I have referred.
2004, where have you referred?
Yes, I have referred. Ready? Refer.
ওটা বোল্ডে করেনি বলে চলে গেছে কে পেজ 18
Yes.
my learned brother pointed out.
Yes. 74 minus feeding Kalibari. Your lordship knows only one paragraph I shall mention before lordship.
Which paragraph gives the paragraph number?
My lord,
You have not given those copies of the
I
judgment
have given.
previously given.
When the matter was taken up by other coordinate bench, presided by Justice Tomensen, we handed over.
Are you insinuating that those have traveled beyond our state?
Well, I have given the book also. And I give
No, there is-
one copy also I give.
We are not finding any copy here. That's why we are asking.
The lordship asked me to hand over a copy.
Then what did the lordship do with the copy?
যেগুলো রেফার করেছিস
Well, this one again.
নোটে যেগুলো
No,
রেফার
no.
You are taking advantage that their lordships are not there. You must
No,
have-
I'm not taking. No.
Their lordship won't have ownership of those.
Their lordship, no. Their lordship asked me if there is any judgment like a line of inheritance. I got it, Mala, I handed over.
We don't find any line of anything.
Mala, this is the handover. I'm handing over.
But this will be one copy then.
Two copies.
Two copies.
Yes.
Then you are not sure whether you had given.
But your counsel can take it by book also. বই
ফেরত বই থেকে উনি দেখবেন
Alright, you also can see paragraph.
What about the other judgments? There are no copies of any of these judgments.
Other judgment also. This thing.
Also same applies. We don't find copies.
74 ta there.
74, 76. Three judgments.
Not
you have-
77. I'm not relying on. Though it has been
76 you are not relying.
no, not relying. But
Why?
74.
76 there is some adverse something against you. We'll look into that.
No, that will not help. Other for
Will it go against you? We'll look into
not
that.
against me, but it will not be help me.
So para 14
Yes.
we won't look into para 14. We'll look into the other paragraphs. 76,
74.
76.
70 so no paragraph.
Don't look into it.
I have seen one lot.
Not relied on
74 ta there.
at hearing.
কোনটা রিলাই করছিস না 76
74.
74, 1932. Which paragraph you are saying, Mr. Bhattacharya? And 74 Supreme
Oh,
Court, which
70.
paragraph?
I'm good.
পড়েছিস
Eka 23.
কি আছে দেখো
Man, I'm reading paragraph 23. Dr. B.K. Mukherjee doubted the property of this decision, Sri Madhya Bhedingi Kalibari. That higher as
Oh,
the
achha.
end of second edition of Dr. B.K. Mukherjee.
Para 23.
Para 2074? No, I handed over the.
Oh, sorry. No, 74, you don't have a copy. 74.
Oh, if Mandra don't have a copy.
We don't have any of these copies we are telling you.
So there is.
Achha, please, no, we have our tabs. We'll give us some time.
Yes.
But we require the copies at the time of.
I shall.
Very well, we can look at the time of delivering of judgments. You can also look into this. Give us some time. Then.
Hey, give the copy.
One copy.
This is the 74. I've got it.
2 copies.
Yes.
You're giving birth to the copies.
What? My junior, he told me he has already.
He had them tucked up somewhere for some other matter. 3 pages. You pay him for the Xerox copies.
Paragraph 23.
For
Dr. B.K. Mukherjee.
Doubted the propriety of this decision. Sri Venkana Iyer, as the editor of the second edition, Dr. B.K. Mukherjee, legal law lecture, also expressed the same view, such as that. And even if the transfer is for no consideration, the transfer would be bad if it is not in favor of those next in the line of succession. Now, my subject at that
So
point.
this is the book is quoted. What did the court hold ultimately?
Dr. B.K. Mukherjee take law lecture, certain question was that a certain paragraph 25. In the present case, the appellant cannot invoke the doctrine or transfer the Shebait's right for the benefit of the
details cannot be transferred.
There's a female. He was the female.
Cannot be transferred for pecuniary consideration.
For pecuniary.
That is not the case here.
That is not the case. But if no consideration, it would be bad if it is not in favor of those.
A book is cited.
That book cited.
Previously, several judgments were cited which says the transfer of Shebaiti rights was not by UEFA sale but was found to be conducive to the interests of the idol. It was held to be valid. So that was the line of distinction. That if it is for by UEFA sale or for consideration, then it is not valid. That was held here. And this is precisely Mr. Ghosh's case. It was not a transfer for consideration. It was a gift. Because the previous paragraphs, all the judgments say that for the benefit of the deity, it can be transferred. But here the court holds that if it is for consideration, pecuniary consideration, it cannot be transferred. This is not applicable to you.
Mr. Ghosh has cited the submission the Shebait's right of inheritance.
He has cited judgments which says
inheritance
can be transferred.
But inheritance, so my submission, people lordship, inheritance, if the Sukuma died, the Sukuma's property will be devolved upon the plaintiffs and defendant.
This judgment is not helpful to you.
That.
So 2 judgments you have cited are not helpful to you.
No, 2020.
No, the other is AIS 76, which we are not right now looking into, but we are definitely interested.
I did not want to cite, but I mentioned in that, but now I'm not citing.
You had the time to go through that afterwards. 2004, which paragraph?
That was for other things. It was for this is a line of succession. Line of succession. Then line of succession was what? 2000 paragraph, my lord.
So once he is appointed as Shebait, it goes by line of succession.
Yes.
That is also contemplated in your case also. Your deed, 58 deed. It said what is Crome.
Yeah, what is Crome?
What is on Crome or something.
Yes.
Which paragraph? Any particular paragraph of this judgment?
Paragraph, my lord. Let me know.
Para 12.
Yes.
You have underlined, extensively underlined. Yes.
8.3 also, intention of the settlor was a right should be confined within the family itself among the families of the male descendants such and such. Is the daughter and such and such. But intention here also, intention you lost it in 1958.
and 12. But this judgment also holds, and Justice Nagaratna's recent judgment also holds that the gotra of females change after marriage. We don't understand this proposition. Gotra means your lineage through a particular sage.
Yes.
So how can my birth change? Anyway, that's a subject for some other day.
Yes, some other day also.
For some other day.
Yes.
Not this matter.
There were
Consistently, I'll go through
10
the
also.
woman changes. How can my gotra change? Even if I'm a woman, I was born in the lineage of some rishi or some sage. That cannot change by marriage.
The paragraph 10 also, my lord.
Paragraph 10 also. Very well.
Answers to this question in this case can be found in the decision suit between such and such. The intention of the founders was that all her lineal descendants should hold the Devata property and jointly perform Shiva Puja. The only alienation which was contemplated was the gift by state successor to one successor. So whenever the foundress express direction or by the ordinary rule of Hindu law of the property, the right of ownership may be regarded as being in the first place of hereditary. The question that arises whether there has been a modification of that principle usage of the family. This is not pleaded and no evidence has been given of any usage. Many members of the family are purported to lose the right of ownership such and such. Then, my lord, paragraph 10(1). The decision in the case of Rajesh Songmoli versus Gopeshwar was affirmed in appeal such and such. So that in this said decision inquires a person enjoys the right of property and office of Shebait during his lifetime. On his death, nothing remains to be bequeathed by will, since a will takes it to sunset. It was further held that no such usage to be ensured right of Shebait could be bequeathed will. This was the view of Makram J. such and such. Was pleased to hold that question of Shebait is of a guardian of infant heir. He had no power to alienate except for necessity for the benefit of the Thakur. The right to manage as Shebait ceases with the death of Shebait, and there remains nothing to bequeath after this such and such.
But he expressed no intention, and the Justice Woodruff did not express any intention opinion on the question of alienation inter vivos. That is also holding. Here it's an inter vivos transfer.
But at that point of time, according to Hindu successors, they are not the heirs. They are not there because according to Rajkumar, my class 50, they are also 50. My subjects are now we are getting one third. And Pala system, that is totally against the intention of the settler.
But you were also complaining that you are not getting your palas.
Yes.
So you have acceded to that also.
That is absurd.
Mr. Ghosh, a very crucial point has been raised by Mr. Bhattacharya.
Yes.
58 did that Shebaitship has been given to all three, but only certain properties they were mentioned specifically. Regarding those, Kanai was excluded. Now, what is your answer to that? That is very crucial. That may change the complexion of your arguments.
So far as 58 deed is
58
concerned,
deed, yes. If you come to page 58 deed, Mr. Ghosh, please come to
Yes,
your copy, the last page 2. If you please start from page 2, about 10 lines from the bottom, 8 lines from the bottom, Amar por Otto settlement. 58 deed.
yes.
I copied it.
Page 2, middle.
Page 2, lower than middle, about 8 lines from the bottom. 10 lines. Amar por, yes.
অত্র সেটেলমেন্ট গড়িতে আমার পুত্রগণ ওয়ারিশানগণ ক্রমে আমার ন্যায় সেবায়িত পদে নিযুক্ত থাকিয়া উক্ত দেবদেবীগণের সেবা পূজাদি করিবার ও তফসিল দেবত্ব সম্পত্তিতে যেরূপ বসবাস করিতেছি সেইরূপ আমার স্থলে সেবায়িত স্বরূপ থাকিয়া দেবকীর্তি বজায় রাখিবে ও দেবত্ব সম্পত্তি সকল তত্ত্বাবধান ও রক্ষণাবেক্ষণ করিবে এবং সকলে সেবা পূজাদি করিবে এবং মিউনিসিপ্যালিটি কর্তৃক যখন যে ট্যাক্স হইবে তা যথাসময়ে সকলে একত্রে আদায় দিবে এবং আবশ্যক মতো গৃহাদি মেরামত করিবে এবং আমার যে সকল যজমানাদি আছে তাহাদের ক্রিয়াদি হইবে। No problem. But his Shebaitship has not been hampered.
Gift deed.
Gift deed is only for the turn of ownership of Sukumar.
It is not at all the gift deed.
And after the Sukumar death, automatically the other two parties become Shebait.
So therefore you say Shukumar's portion, but here Mr. Bhattacharya has placed two other portions also.
Yes.
One is that কোনো প্রকার হস্তান্তর বা দায় সংযোগ করিতে পারিবে না। হস্তান্তর includes gift.
It is not a gift.
It is not a gift, my lord.
The
And
Shebait
so far
gift.
as your
It's
lordship
here.
kindly turn to that judgment, my lord.
You may say something that this rider কখনো কোশ্মিনকালে কোনো প্রকারে হস্তান্তর বা দায় সংযোগ করিতে, there may be some doubt whether this refers to the entire thing above, including Shebait ship, or these three plots.
My lord, I am giving it. এই ওইটা দেখি ওই আমার নোটটা কই
It's a bit contradictory, the Shebait, the Arpanama itself.
It is not a gift.
দেখুন
my lord, kindly turn to
হস্তান্তরটা
judgment
প্রপার্টি পরে বলছে, Shebait ship নিয়ে বলছে, বাট তারপরে আবার and also পূজার জন্য কেহ পালা প্রথা করিতে পারিবে না। That is also there. See, pala protha cannot be done. You don't have any share in your Shebait ship. It's together. It's all together.
very well.
So your share, there is no such thing as your share in a pala.
No, no. My lord, kindly turn to that.
Your share you could not have transferred. That is Mr. Bhattacharya. Could not have transferred.
Turn of ownership can be transferred. That is according to Manohar Bhupan, as well as in 79.
Even if there is no pala, but pala is turned.
My lord, I am just kindly turn to that judgment, my lord, which I have annexed to my
Manohar, yes.
Yes.
But here it specifically debars. It says পূজার জন্য কেহ পালা প্রথা করিতে পারিবে না।
Palapotha has not been done.
But if there is no pala protha, turn is pala.
Palapotha has not been done.
But turn means pala.
Turn of owner, turn of
Share of Shebait.
Shebait. My lord, kindly turn to, your lordship kindly turn to the first
Manohar.
Manohar Bhupan, page 13 of 44. There is judgment of Purigo. I don't know. One noted. That বুঝিয়েছো সব।
Yes, perpetual minor, that principle, basically.
My lord, your lordship kindly turn to page 13 of 44 of that judgment.
13 of 44, yes. 13.
At the top.
Yes.
The question referred to the full bench therefore mainly depend on the question whether Shebait ship in Hindu law is property of any kind, to which Tagore versus Tagore may apply, or is merely an office to which the founder of an endowment is competent to appoint or nominate person in any order of succession, which may have the effect so far as the founder is concerned, to use the words Turner LJ in Surjamoi, that creating a new form of estate or altering the line of succession allowed by law for the purpose of carrying out his own wishes. This is the question which was referred. Now, I'll kindly turn to note. Kindly turn to, my lord, page 20 of 44. Page 20 of 44.
20 of 44, yes.
Towards the middle. In later times, Hindu law, towards the middle.
Yes, in later times.
In later times, Hindu law made property dedicated for pious uses imputable. Of this, reference is to be found in various texts and authorities, which are found collected in Pandit Pranat Saraswati Hindu law of endowments. And there is also to be found their discussion as to the meaning of the expression Yoga Kemam in Manu, about which there is a considerable conflict. Some authorities maintaining that the expression indicates the notion of a fund for religious or charitable purposes, and others denying that that is the meaning of the expression. It is unnecessary to go into the details of this controversy here. Religious endowments or devotor are of two kinds, public and private. In a public endowment, the dedication is for the use or benefit of the public. But when property is set apart for the worship of a family god in which the public are not interested, the endowment is a private one.
There's no doubt this is a public, private.
Yes.
No doubt.
The courts have given effect to results logically following from such a distinction. For instance, in Kunwar versus Ramchandra, Judicial Committee observed, when the temple is a public temple, the dedication may be such that the family itself could not put an end to it. But in the case of a family idol, the consensus of the whole family might give the estate another direction. Chatterjee and Page JJ, in the case of Chandicharan, held that in order to convert the absolute devotor property of a family Thakur into a secular property, it is necessary and that a consensus of all persons interested in the worship of the deity, including all the members of the family, male and female, should be obtained, but doubted whether Kanwar Durganath's case was not incompatible with the true spirit that moves a pious Hindu to make such a devotor. And in Gulab Chandra Shastri's well-known book on Hindu law, it has been cynically put as a corollary following from this decision of the Judicial Committee that if all the members of the family renounce Hinduism and choose to throw the family god into the waters of the Ganges and themselves enjoy its property, no outsider can raise any objection. The endowment being a private one. That the family god is not so very helpless has fortunately been held by the Judicial Committee in Promoto versus Podumno. This distinction, however, is not to be found in the original text of Hindu law and is a distinction of comparatively recent origin, based no doubt on sound principle and necessitated presumably by change of social condition. To find out the real incidents attaching to Shebait's ship, one must
Mr. Ghosh will just come back and resume in 10 minutes. Mr. Ghosh, we don't have any quarrel with this. Nobody can have any quarrel with the proposition. Yes, it can be inherited and can be transferred for the benefit of the deity. As a general proposition, yes. But we also at the same time have to look into this particular Arpannama, whether what was the intention of the settler. So there, what is your answer
The
to this?
96 did,
1958.
58 did, yes.
58 was the intention of the settler. You are all abiding by that.
58 তো সেটলারই করেছে।
Yes, 96 is your criticism.
Settler করেছে তো 58
58 was done by original settler.
That is what we are saying.
Yes,
We have to look into that to
yes,
see his intention.
yes.
Now, his intention was very clear. He said that the settlement রইতে আমার পর আমার পুত্রগণ ওয়ারিশানগণ ক্রমে আমার ন্যায় সেবায়িত পদে নিযুক্ত থাকিয়া উক্ত দেবদেবীগণের সেবা পূজাদি করিবে, such and such. So the language uses আমার পুত্রগণ ওয়ারিশান ক্রমে. Warishan, when Sukumar died, his Warishan included this other brother also, the one who is excluded now,
Yes.
Kanailal,
Sukumar means the,
your donor,
yes,
your donor.
yes.
So when he died, can he deviate from that line of succession?
No, I've not said that. So far as his turn of ownership is concerned, he can very well transfer.
So can there be a share in Shebaitship? Yes, maybe.
This turn of ownership, I am not putting in that. Turn of ownership.
But turn, Pala has also turn. If you by turn you mean Pala, it's jointly all have to do it.
Right. But they,
He's whatever his
yes. But so far as,
right of Shebaitship.
yes, right of Shebait.
But his right,
Yes.
as per this deed, Arpannama,
Is there any single evidence, my lord, on record which my learned friend can place before your lordship, where it can be said that he came to participate and he was refused?
now, that is different. But Mr. Ghosh, you see,
There is no,
even Shukumar's share or turn, that also devolves upon all, including Kanai. And after Kanai, he is here. Shebaitship.
Right.
So, but by this 1996 deed, he is exclusively allocating, earmarking his turn of the Shebaitship to these people.
yes,
Can he do that? Because he cannot exclusively give it to some people. Whereas the 58 deed says it has to go to all his
I'll
heirs.
kindly turn to that Manohar Bhubendra's case. I'm just placing it.
No, but here it is against the 58 deed of settlement itself. In your case,
Yes,
Monohar says it can be done. One can transfer his share, but here it's debarred by the it's against the intention of the settler itself, because the settler says তিন ভ্রাতা এবং তাদের ওয়ারিশনগণ ক্রমে তুল্যাংশে পাইবে and whatever. Now, therefore, if all three of us together get something, and our heirs will get after us, can I during my lifetime
so long, my lord,
exclude someone?
amongst the three, if one of them, my lord, transfers his turn, that can be done. I am on that.
But his turn
Yes.
is also heritable by all his successors
After his death.
after his death.
I'm not disputing that.
But you are curtailing that. You are avoiding that. Sukumar is rather obviating that during his lifetime by giving it to exclusively somebody during his lifetime,
No,
so that after his death, all his heirs don't get it.
that to that extent, my lord, it may be bad. But so far as his turn, during his tenure,
Yes, but his turn is also then after his death, because he gives it during his lifetime, so that he avoids his turn also being distributed among all his heirs
after his death.
after his death.
That, my lord, I am saying, my lord, that cannot be done.
So then the deed of gift becomes void, because deed of gift has not been restricted.
Deed of gift is with, so long he lives.
Deed of gift is immediate, or deed of gift or deed of whatever. In the 1996 deed, Shebaitship Niyog Patra, he does it forever after. That does not stop at his death. He does not till my death.
But
This
to
happens.
that extent, it may be bad. But up to that,
Now he is admittedly dead now.
yes,
So therefore it should be set aside to that extent.
yeah, that cannot be
They
done.
also have the right.
Because they never came. that I want to participate in the Seva Puja, and I has been refused. No sort of
They need not-
single evidence is
They
there.
need not prove that.
And even that case is not made.
Suppose they need not prove
On
that.
the other hand, my lord, he challenged that original deed, lost up to this honorable court.
That is not before the trial court, not discussed.
Oh, yes, yes. It is
Where is that?
before the trial.
Which page?
Different. The dismissed or deferred.
Dismiss or default?
No.
Yes, yes. Appeal is dismissed for default.
Dismissed or deferred. Yeah.
I did not
Yeah.
marry.
The current
Yes, brother.
What is that?
page 106 part 2 ওই তো দিয়েছো দিইনি
It is discussed in internal page.
part 1 106
Hmm?
100 or something.
106
দাদা,
Part
ওটা
one?
face করেছি আমরা।
This was our
Yes.
case in the trial court.
103
Where is it discussed by the trial court?
Okay. Damn.
81.
Don't even
Page
find any
81.
info on that.
কত রকম বলছো?
Page 81. 81 এর আগের পাতা। এটা আমাদের
না।
পেজ 84।
ওই এটা কোথায়?
At
Page
184 of 71.
Yes.
Yes.
Court says it at page 96 in statute number 174 of 1971.
Page
It was
84
held by the court that settlor had the right to
Maladi,
execute the deed of
Kindly
settlement.
turn to page 84.
is the pleadings of the defendants.
Or my lord, page 83 bottom.
Yes.
Defendant 1 to 9 substantially filed a joint written statement to counter the case of the plaintiffs. In the written statement, defendant number 1 to 9 disclosed that Sarat Chandra executed a deed of settlement on
That was a challenge to the 1941 and 58 deeds.
no,
Yes.
58.
41
Those deeds. That is different.
41
That is different.
the suit of
Suit of 1971. 84 of 1971.
Page 84, if you continue, you will see.
Yes, page 83 bottom, then page 84 top.
If you continue, you will see what the suit is for.
My lord,
Please continue, page 84.
no. Suit was dismissed on contest.
No, please, you are reading from page 83.
That was, my lord, the latest patent appeal or second appeal filed.
No. Has filed a suit for declaration and injunction that the two deeds executed by Sharat
My lord,
Chandra.
kindly, my lord.
Please complete that sentence.
Yes,
that will
yes. My lord,
answer it.
kindly, let me place, my lord, from the earlier paragraph, page 83 bottom.
Yes, do that.
Defendant 1 to 9 substantially filed a joint written statement to counter the case of plaintiffs. In the written statement, defendant number 1 to 9 disclosed that defendant, my lord, my client, the present appellant before you know, disclosed that Sarat Chandra executed a deed of settlement on 19 February 1958. But the father of the plaintiffs, namely Kanailal, in order to grab the entire suit property as 16 runners on Shebait, filed a suit for declaration and injunction that the two deeds executed by Sarat Chandra in the year 1941 and 58 are not valid against Sukumar Chakraborty and Rajkumar Chakraborty in the fifth court of Munshi Howrah, being titled suit number 184 of 71. But the suit was dismissed on contest, and it was decreed that the said two deeds were valid.
So it was the Orponnamas which he challenged, not this deed of 96.
96, my lord.
Orponnama challenge failed. Orponnama, all of you are relying on.
Yes,
now. This is immaterial.
yes.
You are saying so long that they had challenged this deed and failed previously. This gift deed.
They said it is void. I say
They said that was
96 is void. That
is
was
the defense in this suit. They did not file a previous suit and lost.
No.
That is different.
His predecessor filed the suit, the earlier one.
That is the earlier one. He failed there. That is settled now.
Yes. Now, my lord, after 96 deed, Your lordship will kindly turn.
Now all the parties are relying on the 1958 deed. He's also relying on 1958 order now.
Because 58 deed has been held to be valid. But,
Yes, he has no option but to.
No option, yes.
But the 58 deed itself says these things.
Yes.
That after this Shebait is Uttoradhikari gone krome. So therefore, by virtue of succession. So after this Sukumar, the successors would be all of them, Kalidas and all these people, including Kanailal and Rajkumar's sons.
Right.
But during his lifetime, he executes a gift deed, giving it exclusively to Rajkumar's sons.
To that extent, it is void.
No, it cannot be. It's not limited to that extent. The deed is not restricted to his lifetime.
No.
We cannot say a deed is void to a particular extent.
My lord,
it's either void or not. Once he gives, once I divest a property, deed of gift is executed by me.
No, so long, my lord, he lives, my lord, that deed remains
that
valid.
rider is not there in that deed. If that rider was there, then it would be different. The deed says, I hereby bequeath.
No, I can return to that deed itself.
Once you are divested of a particular Shebaitship share or turn, you cannot get it back after the death. It cannot revert back to your estate. It was not a lifetime transfer. It was an absolute transfer. We cannot segregate the deed. Once it goes, it goes. For all practical purposes, I donate my turn of Shebaitship, it goes. Nothing to say after my lifetime, this will revert back. তৎস্থলে অপরাপর সেবায়তগণ সমঅংশে পূজা করিবে সমঅংশে ভোগ দখল করিবে
page 2 second paragraph
yes
বর্তমানে আমি বিপত্নী আমার কোনো সন্তান সন্ততি নাই এবং আমার যথেষ্ট বয়স হইয়াছে আমি আমার কনিষ্ঠ ভ্রাতার সংসারে বসবাস করিয়া আসিতেছি এবং তার পুত্রগণকে অর্থাৎ গরিদাগণকে আমি পুত্র স্নেহে পালন করিয়াছি উক্ত ভ্রাতস্পুত্রগণ আমার প্রতি যথেষ্ট শ্রদ্ধাশীল ও যত্নবান এবং দেবদ্বিজে ভক্তিমান আমার এই পরিণত বয়সে উল্লেখিত গৃহদেবী সেবা পূজায় পালা পার্বণ আদি অতি নিষ্ঠার সহিত সাহায্য করিয়া আসিতেছি
rather it's the other way around. See the next sentence. আমার অবর্তমানে
উক্ত দেবদেবী সেবায় পূজায় যাতে বিঘ্ন না হয় তৎকারণ ইহাদিয়াকে অর্থাৎ আমার কনিষ্ঠ পুত্রগণ যথাক্রমে
আমার স্থলে আমার পরবর্তী সেবায়ত
বর্তমানে আমার স্থলে স্থলাভিষিক্ত হইয়া পরবর্তী সেবায়তগণের আপোষ চুক্তি অনুসারে
these are very I mean it's very evident আমার অবর্তমানে and আমার পরবর্তীতে so therefore it's forever it's not restricted to his lifetime. This is a bad transfer.
No, my lord, so far as now, my lord, it has become less important because my lord, he has already died.
It was bad.
He has already died.
It was bad during his lifetime also because he transferred. There are not two transfers. One transfer takes place at present when I execute the deed, and another transfer takes place after my death. It's not that. It's a common transfer, immediate. There is immediate investiture of title in the of Shebaitship rights on the donees. It's immediate. So if it's immediate, Mr. Ghosh, and then it continues forever as per this. It's a continuum. So therefore, the vesting is immediate. By virtue of this vesting of his rights on one portion of his successors, he goes against the grain of the settlement deed.
58 deed.
58, yes.
That is your lordship's observation. That's 58 deed.
That is his observation also in 19.
No, my lord, so far as this
it's not, it does not say it will come back or there will be another transfer after my death.
No,
nothing of that sort.
Not
I give
necessary.
it, it's gone. So that will continue after his death also. Amar abortomane.
After his death, my lord, I am not objecting.
We cannot say that a deed is partially void.
No, so long, my lord, he is alive. He is being incapable of performing Seva Puja. That part cannot be done. Cannot be set aside.
Now there also there is some doubt because 58 deed has a portion which says,
and that has already been done.
What has been done?
Well, that he is dead now.
Yes.
So the other parties and they became my lord Shebait according to the original deed.
Yes, so So that deed cannot survive then. That deed has to be set aside then. How can that deed survive?
Malad, so far as that later part is concerned.
And that 558 deed also says কোশ্চিন কালে কোনো প্রকারে হস্তান্তর বা দায় সংযোগ করিতে পারিবে না. How do you
This has
avoid
gone,
that?
my lord, a substantial change, my lord.
হস্তান্তর.
In
Gift
view
is
of
হস্তান্তর.
in view of the judgment of the Manohar versus Bhupendra, my lord, your lordship kindly see.
Manohar says it can be transferred.
Yes.
But if the Orphanama itself precludes, how can it be? Manohar does not say, even if there is a clause preventing such transfer, then also it can be transferred. Manohar never says that. Nobody can say that. It's the intention of the settler, Mr. Ghosh. Nobody can say that. Manohar says, yes, it can be transferred.
Yes.
But Manohar does not say, even if there is a specific bar in the Orphanama, then also it can be transferred. That cannot be a correct proposition of law.
No, my lord.
There's a specific
in
bar.
The original deed, my lord, by which, my lord,
That has marched into 58. You are all going by 58 deed. You have acceded to 58 deed. You act upon 58 deed. All of you have. Nobody ever challenged 58 deed. They challenged and they lost. So after that, that's res judicata and issue estable.
Yes.
Issue estable for you also.
Earlier one.
Yeah.
Earlier suit.
58 deed, earlier suit, they challenged. You did not challenge. That operates as issue estable against you also. You cannot now resile from that position and say 58 deed does not exist. You have fully acted upon. So 58 deed is what we have to look into. And it specifically bars transfer also.
No, my lord, kindly turn to.
We'll look into it and decide. You cannot improve the 58 deed now. It's too late in the.
My lord?
You cannot improve the 58 deed now.
No. My lord, kindly turn to the Manohar versus Bhupendra's case.
No, that proposition we are saying that settled proposition, Mr. Ghosh. It can be transferred, it's heritable.
And in 79 Supreme Court also, my lord, that has been.
Nobody disputes. It can be transferred. But the question is whether if there is a specific bar in the Orphanama itself, whether then also it can be transferred. That question was never decided. And no court on earth can decide that if there is a specific bar in the Orphanama itself, then also it can be transferred. How can it be held? That cannot be a correct proposition of law, Mr. Ghosh. You also won't be submitting that probably.
No, my lord, what I am submitting, my lord, is on the basis of the Manohar Bhupendra's case. My lord, kindly, I am just, my lord, referring to some of the relevant portions.
Manohar Bhupendra says that it can be transferred. A Devottar property, the Shebaitship of one person can be.
Turn of ownership.
Turn of Shebaitship can definitely be transferred.
Yes.
We cannot doubt that. Can be transferred. But unless there is a specific bar, it's like saying a property can be transferred. A property, if I have title in a property, it can be transferred.
Let us, my lord, go to that date. 58. 88.
Your only possible argument could be, Mr. Ghosh, that transfer restriction is applicable to these plot numbers which have been given to each of these people. If you come to page 3 of the.
That is with regard to possession, possibly.
No, if you please come to page 3 of the. Now we almost know this 58
Page 3 of?
Your 58 deed.
58.
Yes, we know it better than you. We're probably better than the settler now.
This is the area which was allocated.
That's your best argument. Suppose that's
No,
your best.
that is there.
No, that's your best argument.
Yes.
We are reading it for, I mean,
Page 3.
Page 3, please come to the third sentence.
অর্থদলিলের একাংশ।
No, উহাতে, from উহাতে. We are starting
উহাতে
from
1 নম্বর গ্রহীতা কানাইলাল
we are reading উহাতে 1 নম্বর গ্রহীতা শ্রী কানাইলাল চক্রবর্তী কোন সত্ত্ব সংস্রব দখল অধিকার রহিবে না।
অর্থদলিলের একাংশ নকশায় লাল বর্ণে রঞ্জিত প্রদর্শিত such and such plot
কানাইলাল চক্রবর্তী
স্কয়ার ফুট 1 একর 1 কাঠা 8 স্কয়ার ফুট মাপের জমি
need not go into that
and other things.
Suppose we are putting it to you. 3 properties.
Yes.
অত্র দলিলের such and such Noksha Lal Borne goes to one person.
Hmm.
The D and D goes to Sukumar. O plot BFH goes to Rajkumar Chakraborty. It said Putra Poutradi Warishangrame Amarne Amar Poroborty Shebait Sutre Bhogdakol Koribe. Then without any pause, it continues. কিন্তু কখনো কোশ্চিনকালে কোনো প্রকারে হস্তান্তর বা দায় সংযোগ করিতে পারিবে না. Now, therefore, you may argue, Mr. Ghosh,
This is
this restriction is applicable to
transfer
these plots.
third party. And also, my
Third
lord,
party,
third
obviously.
party.
No, we are not. Third party, obviously. But কোনো প্রকারে হস্তান্তর does not restrict to third party. Even inter se. কোনো প্রকারে হস্তান্তর, but you may at best argue, Mr. Ghosh, that this pertains to the three properties immediately above that, because it's a continuous sentence and there's a dari, there's a full stop after that other part which deals with Shebaitship. There are two compartments of this deed. One says Shebaitship, insofar as that is concerned, all the three sons after me, all my three sons will get Shebaitship equally, and their heirs thereafter, their successors after them, and also the usufructs from that Shebaitship or whatever from the DT, Sheba Puja. That ends there. Then three properties are discussed. As far as these properties are concerned, A goes to X, B goes to Y, and C goes to Z. And in a continuous statement with that sentence, পুত্র পৌত্রাদিক্রমে ওয়ারিশনক্রমে আমার ন্যায় আমার পরবর্তী সেবায় চুতে ভোক্তাবল করবে, কিন্তু কখনো কোশ্চিনকালে কোনো প্রকার হস্তান্তর বা দায় সংযোগ করিতে পারে. That may, you may argue that that pertains to those three properties which are demarcated among the three. Those cannot be transferred, but not the Shebaitship. This rider does not apply to the Shebaitship which ends with a full stop previously. We'll look into this.
No, my lord, kindly turn to
Yes.
after that, that plot BFH চিহ্নিত 1 কাঠা 3 ছটা 15 স্কয়ার ফুট জমি, you also got it, অবস্থিত যাবতীয় স্ট্রাকচার 3 নম্বর গ্রহীতা শ্রী রাজকুমার চক্রবর্তী পুত্র পৌত্রাদি ওয়ারিশাঙ্গন ক্রমে আমার ন্যায় আমার পরবর্তী সেবায়িত সূত্রে ভোগ দখল করিবে. This is the deed of 58. Yes, this is the deed of the testator.
The settler.
Settler. That means
That is the question. What
3
that
নম্বর
means.
গ্রহীতা শ্রী রাজকুমার চক্রবর্তী পুত্র পৌত্রাদি ওয়ারিশাঙ্গন ক্রমে আমার ন্যায় আমার পরবর্তী সেবায়িত সূত্রে ভোগ দখল করিবে, কিন্তু কস্মিনকালে হস্তান্তর করতে পারিবে.
Right.
So Rajkumar Chakraborty is another client. Rajkumar
That is
Chakraborty.
precisely what you are saying. That is
Yes.
your best argument.
So this is the testator's intention also, that Rajkumar Chakraborty alone can do it. But হস্তান্তর বা দায় সংযোগ করিতে পারিবে.
So that restriction is, it applies to only those three demarcated properties.
Yes. No.
And not the Shebaitship.
Shebaitshipটা তো রেস্ট্রিক্টেড নয়, এই প্রপার্টিগুলো ট্রান্সফার করতে হবে, জাস্ট এটা
কি বলছে?
যেটা বলছে Shebaitshipটা কোনো রেস্ট্রিকশন নেই, Shebaitship ট্রান্সফারের কোনো রেস্ট্রিকশন নেই, প্রপার্টিগুলো দায় সংযোগ করতে হবে.
No, my lord, I say, my lord, it also refers to Shebaitship.
If you say that, then you are gone.
No.
Then you are gone.
No.
If it refers to Shebaitship also, that restriction, you cannot transfer.
No. This is 58D.
58D.
Referring
If
to
that refers
Rajkumar
to,
Chakraborty.
you rely on a deed whereby one Shebait transfers his Shebaitship turn to some persons.
That
If
is
you
the-
say this applies, this restriction applies to Shebaitship also, then you could not have transferred. Kumar could not have transferred.
No. My lord, this is done by the testator himself. This has been done by the testator himself, by this 58 deed. So we cannot go above that. Am I clear to logic?
Are we clear to you? We are saying that কিন্তু কখনো কোশ্চিন কালে কোনো প্রকারে হস্তান্তর বা দায় সংযোগ করিতে পারিবে না. It cannot refer to himself. The testator cannot refer to himself by saying করিতে পারিবে
That
না.
refers to Rajkumar.
No.
Yes.
To all.
Mr. Ghosh, that is what we are saying. We are speaking at cross purposes. We have understood, Mr. Ghosh. We have done. Hearing is concluded. The matter is reserved for judgment. Mr. Ghosh will look into the deed. We get your point.
My dear Lordship has got the deed, copy of the deed.
All the deeds you have given us. And we will definitely look into the 1976 judgment because Mr. Bhattacharya says he relied on that, but now he does not.
90?
97.
No.
Yes.
I think
Won't
it
have
will not be applicable. That is
এটা রেফার করেছে কিন্তু রিলাই করে
your lordship told my lordship.
আমাদের?
No, we don't know.
এটা আমাদের
Now, no.
No, with regard to
No, I know.
76 he has not relied on. That's why we will look into that. Why he did not rely.
এইটাই ওনাদের এইটা তো
Bhupendra 2004, that has been relied upon.
আমার নোট করা আছে।
No, what you have relied on, we'll definitely
yes,
look into.
yes.
But
No, my lord, kindly turn to Mr. Bhattacharya's note, page 16.
Why?
Page 16.
For what?
The 1974.
He says he does not rely on that at here.
No, 76 he does not rely.
70.
We'll look into 76 also. That is what we are saying.
The 74, I read only paragraph 22.
So my submission is with regard to 74. This is a sale in favor of a stranger.
Yes.
And the
Mr. Ghosh, when he was placing it, we told him that it is not
and
applicable.
76, my lord, is permanent alienation.
he doesn't really
76.
I do everything.
76 is not relying on.
I will not relying on. I have not relying on.
Nobody relied on 76.
Yes.
74, you are right. We told him that this is for consideration.
Yes.
Yours is not for consideration.
And that is in favor of a stranger, my lord, not
Also
with-
stranger. Right. Absolutely right.
on that ground alone, my lord, it can.
That is not applicable.
I'm appearing for the respondent. I'm being led by Mr.
Record.
Vishnu Shah. I'm just seeking one indulgence, my lord. He's on his legs. I'm just praying for a Passover.
No, the appellant finished.
I believe that Mr. Shah was making
Mr.
his
Doctor, you are there in
submission.
this matter. You had concluded.
I had concluded in both the 3 and 4. Well, I'll just indicate, Miller, it will come back to your lordship myself.
Yes.
Miller, this pertains to supply of iron ore. Miller, the iron ore, Miller, the period of contract was for a period of 1 year. And I'm supposed to supply them on a fixed basis on a quarterly basis. Now, Miller, there were 4 quarters in a and one of the essential terms of the contract was full payment had to be made in terms of the consignment for which you are seeking. Now, so far as the first quarter was concerned, there was a partial payment made, but we allowed at the supply. And thereafter, from the month for the next 2 quarters, there was no demand, there was no supply. There was a dispute regarding the quality of the iron ore, but that is not the subject matter of this arbitration. Thereafter, in the last quarter, Milord, they all of a sudden say that supply me the iron ore. And I write to them saying that please make payment because your payment for the first consignment is also due. They make payment under the first consignment and then say now pay. I said no, the contract says that you will have to pay the entire payment in full. So what they do, they give me a check with a covering letter that don't present the check. And my argument was that if that is so, there is no question of any full payment being made. And ultimately the contract expired. The matter was referred to the arbitration and the arbitrator held that since I had insisted on payment and in spite of the fact that in the first quarter I have supplied the goods without insisting on full payment, there was a waiver. And Milord, my endeavor was to show to your lordship, Milord, that that letter which says that no, I'm not going to make payment, puts an end, even if there is a waiver, that puts to an end to any estoppel. And I put him on notice that I'm not waiving. But be that as it may, Milord, the arbitrators went on to hold that there was a breach and the consequences of breach and all the about.
Mr. Datta, you probably also argued that even if it was not waiver, but even if waiver point is not accepted, even then that could have been restricted. That should have been restricted to that one time only.
Yes.
And it could not be a universal waiver for all time to come.
Yes, once I have waived does not mean that
Yes.
it waives for the rest of the contract.
And whereas the contract conditions say that they have to pay simultaneously before
Yes,
getting it,
absolutely.
they
Full
have to pay.
payment.
That also you pointed out. And there was another argument also probably that there was a you had a liability to pay that to supply that amount for every month or every quarter.
Yes, every quarter.
And you dealt with that by saying that no, it was not a liability to continuously pay. They had to apply for and
Yes.
pay
Absolutely.
for. So those it could be sporadic also. They had to apply and pay.
Yes.
Unless these were there was no continuous liability on your part.
Absolutely.
So therefore, the premise of the damages and everything
Absolutely.
else
There
is
was
bad.
no breach, and therefore there is all the consequences for. It's basically saying that, Millard,
Yes.
there cannot be any second interpretation of the term that full payment is to be made when I'm insisting that full payment. has to be.
Yes.
That
yes.
was that.
And your waiver argument or their waiver argument also goes because you specifically denied. I mean,
Yes, I'm in writing, and that the arbitrator has taken note of, but saying that you could not have because you have already waived.
already waived.
Therefore, you cannot insist on payment anymore.
Yes. yes.
If your lordship desires, Millard, I can give a list of dates because there are only 6.
You had given a list of dates actually.
Oh yes, I
had given a list of
written notes. I had not, but
written notes will direct you.
those Millard.
So ask Mr. Shah to file his written notes. We have heard him at length.
He
on
was
that.
placing his, he was making his submission, Lordship. I believe he'll
You
want
have to start it then. I mean, we cannot keep these matters pending. These were parted. That's why you
just playing for a Passover, my lord.
remove the just. It's not a just. It's not very unjust on the court. Because we have kept these matters as specially fixed matters, ma'am. Kept these specially fixed to honor our commitment because we had heard it, I had heard in part with Justice Kumar. And since the bench has broken, we put it in this bench, put it above the other hearing matters. Because it was parted, we had a moral obligation to the counsel and the litigants so that they don't have to re-argue the entire thing and it goes to the bottom. That is the only reason we have kept it as specially fixed.
I understand, my lord, but I've just.
Are you enjoying any interim order?
No,
Yes, my
Millard,
lord.
I was not enjoying it.
Grant an interim order and just adjourn it to the bottom then.
This is
They were proceeding with the execution, and when I brought it to your lordship, Millard, they considered that they will not proceed. But
No, we'll make that an order of the court and keep it till disposal of the matter, and then it will appear in due course.
This is stay, right?
no, there is no stay because the appeal was
So
being
there
heard.
will be a stay now.
Lordship.
That is our intention.
Just one indulgence. my
Sorry,
lord,
no.
Because I did not.
You have his points with you. Where is his file?
I do not have his.
You must have your own notes. You're in the matter also.
Just got the brief.
Who else is there? They must brief you. Why did you take the brief on a sudden note?
Lordship, the handling advocate is not available. I've just been given the papers. Lordship, I'm just seeking for a Passover, my lord.
Passover.
And Millard, one
Obliged, my lord.
this arbitration is not governed by the 215 Amendment. It's pre-20.
Pre-20. How does this help you? Patent illegality is not there.
No, the scope is more. So the arguments that are being made that patent illegally restricted, it was SOPICE which would be governing that. So illegality will be there. Anything which is illegal, court can look into it.
I'm obliged.
Passed over.
Millard, I may get stuck, Millard. My
Yes,
junior-
no difficulty. Mr. Shah will argue.
Item number 5.
I am
The
for the-
Thakur was, yes. You were arguing probably.
My lord,
Sir,
some argument was made
yes.
due to paucity of time. Your
No, you
lordship-
started
lord.
cited judgments also.
My lord,
Yes, we recollect that. Just remind
I am placing just the facts of the case.
of the case for Justice
My lord.
Fishery also here.
It is case, my lord, pertaining to mutation. What happened, my lord? My client is a fisherman cooperative society
Yes.
in the district of Uttar Dinajpur, the sole cooperative society. 300 general members. Rearing of fish is the main object of their cooperative. In the year cooperative society registered in the year 1994
Right.
under the Society Registration Cooperative Act. In the year 1998, the said cooperative society purchased a water body with consideration. Thereafter,
1999.
1999.
15th of March,
my lord.
1999.
Sorry, my lord.
No, sorry. Yes.
Thereafter, my lord, what happened? It is a very checkered character, my lord. The proceeding was initiated against the ex-landlord under Section 6(1) under the Estate Acquisition Act. And deity, against the deity, land was vested by the settlement officer in the year 1967. Thereafter, my lord, Shebait of the deity challenged the findings of the revenue officials, filed a writ petition. Writ petition was also dismissed. Thereafter, appeal was preferred. Appeal court set aside both the order of the revenue officer and the writ courts. Thereafter, my lord, state filed a special writ petition before the Honorable Supreme Court. Honorable Supreme Court dismissed the appeal filed by the state government. Thereafter, my lord,
the vesting gone.
Gone.
It went.
And not only that, my lord, after the order passed by the Honorable Supreme Court, restoration of the land and the record of rights taken place by the order of the revenue authorities. Thereafter, my lord, West Bengal Land Reforms Act under the provision of 14 capital M proceeding was initiated. And thereafter, my lord, in the said proceeding, in the year 2001, land was vested.
You purchased in 1999 from whom?
1990 purchased from the deity.
Acha, from the deity.
From the deity.
At that point of time, there was no vesting, nothing.
There is nothing, my lord, free
No.
from all encumbrances.
Right, right.
Before that, my lord, there was a challenge before the Honorable High Court regarding some provision of the land reforms and regarding virus challenge.
Yes, Paschim Banga Bhumijibhi.
My lord. And that matter went
That
to
is
the
still in limbo,
Supreme Court.
yes, yes.
State preferred specially.
Right, right.
Bhumijibi Sangho also.
Bhumijibhi also did not specifically set aside 14M.
My lord.
But even then, that
matter is still pending before the Honorable Supreme Court. What happened when the mutation, before that, my lord, in the year 2003, the Shebait filed a suit against my client.
In 2003, Shebait filed suit for declaration and injunction.
Right, my lord. That suit was dismissed in the year 2011.
No appeal.
No appeal.
Yes.
In that said suit, it is.
Was it dismissed on contest, Mr.
Contest.
Thakur? Yes.
Contest.
Contest.
Contest, my lord.
No appeal, that attained finally.
My lord, only one thing, my lord.
Yes.
Kindly take the note. In the said water body,
yes,
Uttar Dinajpur Jila Parishad invested 21 lakh of rupees for development of the water body.
Okay. Invested how much?
21 lakhs for development of water body.
Very good.
In the year 2014, my lord, my client made a representation for mutation.
2014? Yes, yes, we've got that. Yes.
Assistant Director of Fisheries also wrote a letter to the BLRO to mutate the name of the petitioner's land. But they did not take any steps, my lord. Thereafter, in the year 2022, we filed another mutation application in a format, specific format, my lord. Nothing has been done. We moved the original application before the tribunal, my lord. Honorable Tribunal, my
Due
lord.
to the inaction of the BLL on the original proper format application.
Learned Tribunal,
yes,
directing the BLR to call a report.
File a report, yes.
In the said report, it is BLRO submit a report before the tribunal stating inter alia that matter is pending before the Honorable Supreme Court.
The
and
Shebaits are members of that
my lord, Bhumijibi Sangho. That is why mutation cannot be done. Not only that, the mutation case is rejected. No processing was initiated, no notice was given to my clients.
They also said something, Supreme Court order restraining
My lord, Supreme Court, I am coming, my lord. Supreme Court passed several interim orders.
In Paschim Banga, that matter.
Paschim Banga Bhumijibi Sangho. There is a restriction not to create any third party right, not to transfer, not to alienate the property in question.
But you purchased it before that?
Before that. Not only that, my lord, my humble submission before lordships, then that order of the Honorable Supreme Court is not applicable to my case.
Why?
Why, Lordship kind?
Mutation is not transferred.
Not only, my lord, case filed before the Supreme Court, the Bhumijibi Sangho, those are Shebaits of the deity, not deity filed specially petition before the Supreme Court.
Did Shebaits did not file on behalf of the deity?
No, they are independent. I mean, Lordship, kindly see the interim order. There is specifically stated the members of the Sanghos and on such land. That is why, my lord, the report of the BLRO is not applicable to our case. Not only second
You purchased from the deity itself through the Shebaits.
A registered deed. My lord, thereafter, my lord, what happened? Tribunal passed an order. In the tribunal, we filed an exception against the report. Thereafter, tribunal passed judgment that since the matter is pending before the Supreme Court and Supreme Court passed an interim order, that is why mutation cannot be done unless the matter is disposed of. Not only that, my clients did not prefer any appeal.
Tribunal dismissed the matter.
Dismissed, my lord. Thereafter, my lord, against that order, we have come before your lordship. In the said writ petition, State of West Bengal filed a affidavit in opposition, verbatim, which was filed before the tribunal, my lord. In the said affidavit in opposition, their stand is very clear. One is the 14M, they can take the further proceedings apart from the proceedings which was concluded by the Supreme Court judgment. Second is the land has consideration on that 14M proceedings. So many lands, huge amount of land has been vested. Second, third point is Paschim Bongo Bhumijibi Sangho filed a special leave petitions. Shebaits are the applicants. That interim order is applicable in this case. That is why mutation cannot be done. Fourth is the rejection of mutation without initiating any proceedings, without giving any notice, that has been rightly done. My lord, my humble submission is before your lordships that there is a legislative competency regarding 14M. That's a different proposition. Matter is pending before the Supreme Court. Whatever the interim order passed by the
14M proceeding has been initiated.
14T3A. That proceedings land was vested. And power has given under section 14M, my lord.
Yes, right.
And no notice is required to be served upon the applicants regarding proceedings under section 14T3A.
But this land, this water body was also vested under 14T.
14T3A.
This was also vested.
Vested.
So unless that vesting is set aside ultimately in the Supreme Court, how can it be mutated in your name?
My lord, this matter, the land of deities have not challenged before the Supreme Court.
No, this water body has been vested. Whoever has challenged.
Nobody has challenged it.
But water
they have said, that you are the purchaser, you did not challenge it. My contention is.
No, as of today, Mr. Thakur, whatever may be the provisions, whatever may be the provisions or the effects, fact remains that this water body stands vested by virtue of section 14T3A order.
My lord.
As of today.
My lord.
So as of today, unless that vesting is set aside by whichever forum, how can there be a mutation in
my lord? I am coming, my lord.
The rest we all appreciate everything.
My lord.
You are not bound. You were purchasers before.
My
but
lord.
This is the subsequent proceeding.
My lord, subsequent proceedings. My lord, so far the full court decision of our High Court, the purchaser is entitled to get notice. Proceeding initiated after purchase,
That's one of the grounds on which 14T3A proceeding may be vitiated.
right,
But till now, it stands. It has
Right.
not been set aside by any
well,
competent
I
body.
mean, my
Then how can
my
it be
humble
mutated?
submission before Lordship, the mutation does not create any title,
No.
not extinguish it.
No, but you have to prima facie have title to have your name mutated. They must be satisfied that you have a right to mutation. Mutation, otherwise anybody and everybody will come and say, have it mutated in my name. You have to prima facie
Prima facie,
show
my
some
lord.
right. But that right, as of today, it's an admitted question that there is a 14T3A vesting.
Vesting,
If
my
that be so, as of today, state is the owner. Unless that vesting is set aside by some competent forum or
My lord.
court.
My lord,
So as of today, how can it be mutated in your name?
my lord, only
We can say at best that subject to this 14T3A proceeding,
because
there
post
any-
possession of title, vested means title goes in favor of the state
yes,
unless it is set aside.
absolutely.
Concept of mutation is
You are seeking a mutation in your name,
cooperative society.
cooperative
My
society.
lord, we cannot take loan.
But
Hold,
how can it be mutated in your name? As of today, it is the title is not with you. Title is vested in the state in a subsequent proceeding under 14T3A, not the previous 6 proceeding.
my lord,
So
my lord,
why and how can it? Why should it be and how can it be mutated in your name?
if the mutation is being done, it would not cause prejudice to the state because title is not extinguished.
The state would be prejudiced or anyone else would be prejudiced, Mr. Thakur. It's a question whether the person who is seeking mutation, he or she or it is entitled to that mutation.
My lord,
What is the criterion for mutation? You have to have a title or a right, an indivisible right to the property. Today, as of today, by virtue of this 14T3A, you don't have a right in the property.
my lord,
Why should it be mutated?
my lord, with great humility, I am submitting.
Yes.
When I purchased the land with consideration without notice,
Then you had a title.
Thereafter, my
Subsequently,
lord,
14T3 has been.
after 5 years, proceeding has been initiated.
Yes.
Thereafter,
but an order has been passed. Did you challenge the order, 14T3 order?
No notice, no order communicated,
But you
nothing.
know of that order.
Even my lord, in
When
the
you came to know of this 14T3.
in the tribunal, they did not annex the order of the vesting. Only my lord,
disclosed that
schedule
there
of
is
the
a-
land.
They disclose that there is an order. They
There
have to
is,
challenge that before a proper forum.
they have stated in their averment. Nothing enclosed the
Did you-
order sheet of the vesting.
Did you ask for a copy of the order or
No,
did you apply?
frankly speaking, I did not.
But the moment Mr. Thakur they disclose that there is a 14T3A order, you have to challenge that order.
A date of order is not there. Nothing.
You
Lordship
did not
kindly
make
say-
any inquiry. You had to make an inquiry under the Right to Information Act. Also, you can do it. You could have done it.
Well, it has been done, whatever the order communicated by the BLRO during the pendency of the original
Do
application.
you dispute
Last 14
these
years,
people that there is no order of vesting under 14T3A? Do you say that?
no, I did
If
not.
you do not take that stand, then you concede to the proposition that there is an order of vesting. If there is an order of vesting, unless you challenge it and have it
Well,
set
they have
aside,
annexed.
it remains.
They have annexed only the land that in the vesting schedule.
You could write under the Right to Information Act, you could get information immediately from the authorities.
My lord, I am
You did not do that. So your right only will accrue upon this vesting being set aside. Mr. Thakur, you don't have a ground now. Tribunal was justified. Maybe the reasons given were not correct.
my
Maybe
lord,
as a
more than
purchase-
2,400 acres land has been vested.
that
State
may be a
government-
bad order.
My lord,
But you have to challenge that and
state
set
government
aside.
has the power to take the land from the deity apart from this land of the cooperative society.
Private deity it can. Public deity it cannot. Public
It is a
endowment it
They
can.
have said it is a public devotor.
They have stated it's a public devotor. Or
Specifically
if it's
stated.
public, then deity is the riot.
Deity, no doubt, deity is the right.
If it's private, it would not be. In any event, when according to them, what is the order of the vesting of this 14T3 order? What is the
My
date of that order?
My lordship, kindly come.
Just give us the date of that order, according to them. Mr. Shen, what is the date of the order? Can you tell us? Because you have taken that stand.
Order of the tribunal.
No.
My lord,
14T3A, vesting order.
kindly come to page 219.
এই
219.
জেরক্স করে দেবে আমাকে
Paragraph Roman 2. Paragraph Roman 2. An information was received from the district land and land reforms officer Uttar Dinajpur, DLRO in short, by it is later bearing memo number such and such, with reference to the memo number such and such, Malda dated such and such of the officer in the vesting cell SDLRO Sodor Malda regarding the schedule of retained and vested land pertaining to the case of 1 of 2001 under section 14T3 of the West Bengal Land Reforms Act 1955, drawn in the name of Sri Ishwar Radha Vallabh Dev Thakur of Kandi district Mursa, from which it appears the subject plot of LR plot number such and such, such and such was entirely vested in the state.
We want to know the date of the that order.
There is no date, my lord.
46 of the AO-টা কোথায়
It is also revealed there from that the compliance such and such.
Page 251A, no date is given. They do not disclose any date.
41 তাহলে পেজ নাম্বার কত হচ্ছে 46 মিলছে না তো
Lords, kindly come to paragraph 6, page 242.
Yes.
With regard to the averment made in such and such, it is to state the Honorable Tribunal on such and such passed an order directing the authority in the district of Malda to initiate a fresh proceeding covering all the lands of deity in a single proceedings, taking into account of all the lands held by the deity all over the state.
Actually, proceeding were initiated in 1996.
And to determine
Notices were issued. They challenged all those notices before the tribunal. Tribunal quashed the notices and gave liberty to the authority to initiate a fresh proceeding.
That is why I am
because
reading that paragraph.
it
I
does
am
not
reading.
appear that the under actual which provision. Then again, that my lord was taken up the proceeding in terms of the order of the tribunal. And actually, my lord, in my list of dates, it appears every.
It should be clear, my lord.
So they may say that after 1989, 1999, that means after the date of purchase, it is vested, but no.
Please come to 256 page.
256, yes.
It says that initiated and disposed of on 25th of September 2000. A date is given.
Order dated 20th June 2001.
Is that order quotes a previous order? It refers to, whereas it appears that a proceeding under section 14T6 such and such.
Yes.
On 25th of September 2000, they give a date.
25th
September 2000 under section 14T6.
Initiated and disposed of on 25th September.
Yes.
Under those sections.
In terms of it's a fresh proceeding initiated prior to that, 96. Then that proceeding was challenged and the liberty was given to.
Yes, by virtue of that, this proceeding was again
initiated. Continuation of the earlier proceeding.
Maybe, but it was disposed of on 25th of September 2000 means that is the date of the vesting. The order.
That is
under T.
না এটাকে চ্যালেঞ্জ কোথায় করব
এটা তো অর্ডারে পরে এই প্রসিডিং নেওয়া হয়েছে, বসো, অর্ডারে পরে এই প্রসিডিং নেওয়া হয়েছে।
14T6 says revenue officer on his own motion or upon any information may, after giving
So-
persons interested the opportunity of being heard, inquire and decide any question as to whether such and such. It has been decided. It says initiated and disposed of on 25th of September 2000. That is the fresh proceeding.
And it
So-
has not been challenged.
25th September 2000, that remains, Mr. Thakur. Unless you challenge that and get it set aside, that has never been challenged. So you get it from this order. This was challenged before the tribunal by you. This was the first order. This was the first order, probably.
It has been annexed before the Honorable Tribunal, first time, my lord.
No, didn't you challenge this order before the
No,
tribunal?
no. I am playing simpliciter's mutation.
Mutation.
But their contention, as it appears from the writ petition as well as the proceeding before that the matter is already settled. There is no question of further proceeding because of 6(1) proceeding under estate acquisition.
That chapter is over.
but
Fresh opportunity given, fresh proceeding initiated. This is a fresh.
it is under section 14T of the
14T6
Land
is
Act.
completely different. It's
But-
a reopening.
Reopening. It is under the separate proceeding, separate.
Yes, yes.
It is not a fact that the entire matter is closed or there is no further proceeding can be done because it's an independent
No,
proceeding.
that can absolutely be done after the statute.
But the point or ground which has been taken before your lordship as well as before the my
Those are all on the premise that there is no subsequent proceeding. If there is any
there
subsequent
cannot be because the vesting already made done under that 6(1)
that
proceeding.
was set aside.
That was set aside, so no further proceeding. It is their only case, and they have not challenged it.
No, Mr. Thakur. If you don't challenge this order, nothing remains. Your name cannot be mutated. There's a vesting in the state. State is the owner. It's recorded in the name of the state. You have never challenged. At least they disclosed before the tribunal. Why didn't you prefer a challenge with an application for condonation, or the date of knowledge was that date? Now it's too late in the day.
My lord.
Unless you challenge that, this is a fresh vesting. 14T6, you know better than us that it can be reopened.
My
Because
lord,
of
only
these
one,
matters.
only one prayer, my lord. I am praying for certified copy of the proceedings before the BLRO. And
You apply before the BLRO. If
Right.
you apply, it will provide, and you are given liberty to challenge that if you are permitted otherwise in law to do so.
my lord, I am praying another prayer, my lord, not to disturb my position.
That we cannot.
That is the order of the civil court.
Civil court's order, you get it implemented before the civil court.
Civil court order, civil suit filed by the
If there's an order of injunction from a civil court, it's a civil suit is pending.
no civil suit dismissed.
Dismissed. how is that
Shebait
get-
filed by the civil suit.
That is dismissed. There is no. You did not file. You did not get an injunction order.
Between the two group of Shebait.
That
I am,
is a-
we are the defendants.
You file a suit and get an injunction. Who prevents you?
My lord, it's a complicated.
You can ask for an injunction before a civil court, regular civil. But first you have to challenge this. And as of today, you won't get an injunction probably before a civil court also, because this vesting proceeding stares at your face. It has been reopened and it has been vested in the state again. So if 14T6 is not challenged, everything, you don't have a right to get an injunction. If you don't have a right before a civil court, we also won't grant. You are disposing of, you are giving you
Only
those
state cannot create third party right.
They can. Today they can. It's vested in them. They can create third party rights. Nothing will be sub judice. They can definitely create. That is the difficulty. There is a vesting in the state under 14T6.
No, my lord.
So you cannot, unless you challenge that, that remains. They can create third party rights. Build a palace there for Mr. Shen maybe,
My lord.
or some other favored council. Mr. Galib is also there. Mr. Bandyopadhyay would be neglected. He's too tall for a mansion. Anyway, we are disposing this off. So everything else goes. All the other arguments become, academic. The present challenge has been preferred by an association of, by a cooperative society run by fishermen, whose livelihood is primarily pisciculture. So next para, the said cooperative society purchased a property from a deity, comma, through its Shebites in the year, no, on March 18, 1999 by a registered deed of purchase. Full stop, next para. In the year 2003, comma, the Shebites of the deity filed a title suit for declaration and injunction, which was dismissed on contest in the year 2011. Full stop, next para, having not challenged the same, comma, the same at the said decree attained finality. Full stop, next para. Subsequently, an application was made by the present appellant for mutation of the property in the name of the appellant society. Full stop. A representation was also made by the director of the Fisheries Department, assistant director of the Fisheries Department in the year 2014 for such mutation. Full stop. Those not being considered by the concerned block land and land reforms officer, comma, it was subsequently detected that the application for mutation filed by the present appellant was not in proper format. Full stop. Next para. Accordingly, an application for mutation was filed in proper format in the year 2022. Full stop. Since the block land and land reforms officer did not mutate the property as per the application of the appellants, comma, the appellant moved the tribunal, land reforms and tenancy tribunal. Full stop. The tribunal sought for a report from the concerned BL and LRO. Full stop. Such report was filed and indicated that the Shebites of the deity, comma, from which the property was purchased by the appellant association, appellant society, are members of the Poschimbango Krishi Bhumijibi Sangho, comma, which was a party to a litigation where by a judgment of this court, comma, certain some doubt was cast on the virus of some of the provisions of the West Bengal Land Reforms Act 1955. Full stop. Since a challenge is pending before the Supreme Court for resolution of the issue, comma, the tribunal, the BLLRO opined that no mutation can be granted in favor of any party at present. Full stop. That apart, comma,
So for the interim order passed time to time by the
we have not
Honorable
completed, Mr. Shen. That apart, comma, the BL and LRO also opined that there were several interim orders passed from time to time by the Supreme Court restraining third-party interest being created. Full stop. Next para. The tribunal was satisfied with the report and dismissed the challenge of the appellant on the ground of pendency of the Poschimbango Bhumijibi matter before the Honorable Supreme Court. Full stop. Next para. Learned counsel for the appellant submits that the Shebites of the deity are parties in the Poschimbango Bhumijibi matter, whereas the water body in question was purchased by the appellant from the deity through the Shebites. Full stop. As such, comma, neither the deity nor the purchasers from it, that is the present appellant, comma, are bound by any order passed in the said matter. Full stop. Next para. That apart, comma, it is argued that the mutation in the name of the appellant, comma, which is the owner of the property by purchase, comma, could not amount to a transfer of the property in favor of a third party. Full stop. Next para. However, comma, it is candidly submitted by learned counsel for the appellant that before the tribunal, comma, the state represented that in the interregnum an order has been passed under section 14 capital T within bracket 6 of the 1955 West Bengal Land Reforms Act 1955, whereby the property, the water body in question, has been declared to be vested in the state. Full stop. Next para. It is, comma, however, comma, submitted that no copy of the said order was ever handed over to the appellant. Full stop. As such, comma, it is submitted that since no notice of such vesting was given at any point of time as per law to the appellant, comma, which is the lawful owner of the property, comma, the vesting cannot stand in the way of mutation in the name of the appellant. Full stop. Learned counsel appearing for the state categorically opposes such contention and submits that in view of the subsequent vesting under section 14 capital T within bracket 6, comma, pursuant to the leave granted by the tribunal, comma, the property is now vested in the state and there is no occasion for mutation being granted in the name of the appellant. For the next para, although a previous proceeding under section 6 of the West Bengal Estate Acquisition Act was set aside earlier, comma, it is submitted that by virtue of the subsequent vesting subject to leave of tribunal, comma, the property now stands vested in the state. Full it is reiterated that the appellant, comma, having not challenged such subsequent vesting, comma, cannot claim mutation in its name. Full next para, upon a perusal of the records, comma, we find that the this order, page 256 order was passed by the BLLR or the DLLR?
Passed by the
BLLR. No, no.
DLR.
DLLR.
Yes, yes.
256. Because it's referred to the BLLR such and such. The special revenue officer vesting cell Malda, officer in charge. Whereas I
The BLLR.
BLLR.
Yes.
Malda special officer could be there.
Orders. Revenue officer. Yes.
Revenue officer is BLLR.
Yes, that will be BLLR.
Of the revenue officer dated June 20, 2001, passed in Malda case number 1 of 2001 under section 14T within bracket 6 of the 1955 Act, that it was recorded therein that a proceeding was initiated and disposed of on September 25, 2000 under section 14T within bracket 6, comma, 14T within bracket 8, 2, TO2, 14T within bracket 9, read with sections 14M within bracket 5 and 14M within bracket 6 of the 1955 Act as amended, to inquire and decide as to whether the endowed property is public or private nature. Full stop. It thus transpires from the said order that subsequently, having the appropriate authorities under the 1955 Act having held that the same is a public endowment, comma, the deity was considered to be the Rayat and a vesting order was passed. Full stop. Next para. Although the appellant might have good grounds of challenge to the vesting order in view of the deity having apparently been divested of the property, we are putting this in for you, divested of the property in favor of the present appellant prior to the vesting, under section 14T, prior to the adjudication under section 14T within bracket 6, and in view of no notice having been served on the appellant, comma, the then owner, comma, the proceeding might be vitiated in law, comma, in the absence of a proper challenge against the order passed under section 14T within bracket 6 of the 1955 Act, comma, before a competent forum, comma, it cannot be said that the order has not taken effect. Full stop. Next para. Hence, comma, although the appellant has a fair chance and an arguable case if an appeal is preferred against such order, comma, sitting in this jurisdiction, comma, over an order of the tribunal in the teeth of the order already passed under section 14T within bracket 6 of the said Act, comma, we are unable to interfere with the order of the tribunal, comma, since in view of the vesting, comma, which still stands, comma, the water body cannot be mutated in the name of the appellant as on today. Push up next para. As such, comma, WPLRT 84 of 2024 is disposed of without interfering with the impugned order, but granting leave to the appellants to prefer an appropriate challenge before the appropriate designated authority under the 1955 Act against the order under section 14T within bracket 6 of the 1955 Act. If such a challenge is preferred within 3 weeks from date, comma, the said appellate authority shall consider the delay occasioned in preferring the same as bona fide in view of the pendency of the matter before the tribunal and before this court for so long. Next para. In the event such an appeal is preferred, comma, the appellate authority shall decide the same in accordance with law upon giving adequate opportunity of hearing to all concerned and sufficient opportunity to the parties to produce the documents in support of their respective contentions and decide the same as expeditiously as possible, comma, preferably within 6 months from the date of such appeal being filed by the present appellant. It is made clear that we have not entered into the merits of such appeal, comma, if preferred by the appellant. Next para, it will be open to the appellant to seek interim reliefs before the appellate authority or before any other competent forum stroke court for protection of the property in the interregnum, comma, if the appellant is otherwise entitled to have such order in accordance with law. No rest to cause.
Only one thing, may I?
Yes, Mr. Absolutely.
The proceeding, my lord, the vesting order passed after the, my lord, it was, my lord, registered in their name or after the deed of conveyance.
Vesting order is bad.
Vesting, my lord, may I
the face of it.
May I tell, my lord, only thing, lordship, kindly record that it is our case that the proceeding was initiated much before that. But the Shebais, they have challenged the said proceeding. And then the tribunal, my lord, after setting aside those notices, gave liberty to initiate a fresh proceeding. In that interregnum period, my lord, the property, my lord, that was, my lord,
transferred
delineated or transferred in their name.
Bold letter.
Yes,
not correct.
Yes, it is.
Bold letter একটা কোনো
Every time,
learned counsel for the state এখানে argument করছে, learned counsel for the state further argues that the vesting proceeding was initiated much prior to the transfer in favor of the appellant.
Yes.
And after such vesting order was passed, comma, the same was
in the midst of the proceeding was challenged.
After such vesting order was passed, comma, the Shebait challenged the same, upon which a fresh proceeding was directed to be initiated by tribunal.
There was no vesting order initially. The proceeding initiated, notices were served, they challenged the same, and the tribunal, my lord, quashed the notices and said that the fresh proceeding, fresh notice. Notice.
Then counsel for the state further submits that notices for vesting the land were served under which act? Land Reforms?
Under the Land Reforms Act 14T6.
Under section 14T bracket 6 of the 1955 Act,
yes,
were issued much prior to the transfer of the property in favor of the appellant. Such notices were challenged by the Shebites of the deity, upon which the notices were quashed and liberty was given to the state to initiate fresh proceedings.
And this is the vesting is the result of that fresh proceeding, but initiation.
Thus, comma, it is contended that at the juncture when the transfer was effected in favor of the appellant, comma, the deity was still the owner of the property. Next para, learned counsel adds that
it's a continuation of
the vesting order is the culmination of the initial proceeding,
yes,
which was started
in 1996.
In the year 1996, prior to the purchase of the property by the appellant. Next para, learned counsel for the appellant denies the above contentions. Their submission must be recorded. এটা বললে দিদি যেখানে ওনার সাবমিশন শেষ করে আমি আমাদের ইয়েতে চললাম সেখানে ঢুকি।
Supreme Court delivered judgment in the year 1999 October.
Their contention must be recorded.
How the proceeding can be initiated before that?
At 3 and 4, Malad, I'll make one request today. Malad, Mr. Shah was there. In the first half, he was waiting, but Malad, now he is on his legs in another court. Malad, if it
He'll forever be on his legs.
Malad, he was there in the first half. Malad, if it could be taken up on the next day.
On the prayer of the respondent, the matter is adjourned for the day.
Execution.
No, for the day only, let us.
Grateful.
Don't proceed with the execution in the meantime.
But we are not. We are not.
You said that on the last occasion, so abide by that also.
Yes,
now.
absolutely. Great.
Yes.
And for the appellate, my lord, this is that
That matter, yes.
coconut oil Shalimar.
We are fed up with those tins of. Passing off actually. Passing off. Trademark passing. Yes.
Basically with regards to the shape and design, my lord.
Shape design, extensive arguments were made and
Yes, my lord, Mr. Rudraman Bhattacharya had made his arguments concluded.
Yes,
Mr.
yes.
Ranjan Bachawat was
Mr.
making
Bachawat
arguments.
was. Yes, what about that?
My lord, Mr. Bachawat is not present today.
Not present in court.
No, Lord.
So what should you do? Tell us.
My lord, can it be fixed next week?
Next week.
In that case, my lord, can it be on Monday? Mr. Bhattacharya on the last occasion during mentioning had
Very
requested if it could be on
An
Monday.
adjournment is sought on behalf of the respondent, comma, who was arguing in the matter. An adjournment is sought on behalf of learned senior counsel for the respondent who was arguing in the matter. Full stop. Accordingly, let the matter stand adjourned till November 10, 2025.
Grateful, your lordships.
Matter, I am appearing on behalf of the respondent led by Mr. Deobrata Sarai, Your Lordship. Last occasion, day before yesterday, Your Lordship was released the matter with Justice Uday Kumar, Your Lordship.
For it to be placed before us. In all the matters you have done that, in all these 14 matters, because they were parted, we placed it quite at the top.
Yes, Your
You are
Lordship.
for the respondent.
Yes, my Lord. And there
Are
is
they enjoying any interim order?
no.
They are enjoying an interim order.
No.
Then start the matter. They had started the matter. It was heard in part.
Yes, my Lord.
So Mr. Sengupta is to
May I
argue now.
kindly pray for short passover before Your Lordship.
What is the meaning of short passover? You had started arguments. Because these are specifically parted matters, we gave precedence to them over the other matters. Then it goes down in the list. At least start the matter. None appears for the appellant at the time of call. Full stop. The respondents. 6 you are appearing.
Yes,
You had finished your arguments.
my lord, we have concluded our argument.
Yes, they are
Mr.
two.
Bachawat was giving reply, my lord. We
And
can recapitulate, my lord, for your lordships.
An adjournment is sought. This is 7-8. 7.
This is 7. The state, my Lord.
So you can start the matter. You were arguing on the last occasion. They had finished.
This is coming.
Let us wait for him. We will wait for him. The order record করতে হবে না। We are waiting for him. Let him come. Appellant had concluded.
Yes, my Lord.
Tell him we are waiting for him only. Parted matters, how many matters
Mr.
will
Basu is Mr. Shoptangshu Basu, learned senior advocate, is appearing on behalf of the appellant, my Lord.
He had concluded. His arguments were
6. I am
6 were passed in order. Mr. Basu had finished his arguments.
Yes.
You had started. Our notes say so. They had also filed their written notes. So you have to complete your argument and file your written notes. Last order to কোথায় এখানে? What is the matter about? Remind us.
Declaration of vacancy, my Lord.
Vacancy regarding?
Vacancy in a place.
Yes.
Previously, Honorable Division Bench presided over by Justice I.P. Mukherjee was pleased to direct to declare the vacancy with the terms of the Control Order 2013. But the vacancy which has been declared, that
Vacancy for what?
vacancy for appointment of distributor, my lord.
This is what, LPG or?
No. Distributor means MR distributor,
MR distributor.
modified ration distributor, your lordship.
What is the impugned judgment? What was done by the learned trial judge? With the single judge?
Learned single judge was pleased to direct to declare vacancy, and order has been given in my favor. Challenging the said order, the private respondent has filed this appeal.
You are for the private, for the
I am for the
petition.
petitioner.
So let us see what was their argument. Sorry. They said apparently something was not, division bench observation was obiter, and parent notification and amendment has not been challenged.
Yes, my lord. This is the contention of the private respondent in the writ petition, who is appellant before your
Yes,
lordship.
yes. But what is, you started your answer, Article 14 something you said. All vacancies have been recalled under fresh notification. Yes, we'll wait for him. We are waiting for him only. You can start in the meantime. Your arguments, whatever are the points. You are Mr. Paja?
No.
You are Mr.
Das, Mr. Shubhankar Das.
Mr. Shubhankar Das. Yes,
By Mr. Sahara.
Yeah, acha. Oh, acha, you are for the, yes, respondent.
Yes, I am for the writ petitioner.
Yes, yes,
Here,
you are Mr. Das, right?
respondent number.
So, Mr. Sahara was arguing, or Mr. Sengupta?
Mr. Sengupta is appearing on behalf of the state.
Who was arguing on the last occasion? Who started arguments? Mr. Sahara was probably
Yes, my lord.
So, what is your case? Or will close your arguments and hear Mr. Sengupta then?
Let Mr. Sahara come.
Start the matter at least. We have kept these matters only because they were parted matters before the previous bench, the other bench. Otherwise, this goes down the list.
The order impugned at page 168.
Don't read the order impugned. Sheer wastage of time. What is your point? Elaborate on your point. You must have had some conference. Mr. Sengupta, what is the stand of the state in this?
My lord, first of all, my lord, 3 points I am making subject to my lord's approval. But I cannot see my affidavits, my lord. I have filed also an affidavits, and my lord, it was taken into account by the single judge. My lord, here, my lord, my only limited, my lord, kindly, these are the question, my lord, I am formulating. My lord, kindly subject to my lord's second approval.
You are supporting the impugned order, obviously.
Yes. First of all, my lord, first submission I am making subject to my lord's second consideration,
Yes.
that my lord will come to a finding first whether there is any mandatory order regarding preference that the petitioner has sought for. Number one, this is my, let me, no. Let me make my.
So they are answering their appeal because you are not there.
Yes. My lord, first of all, my lord, first point, my lord, I am making kindly, these are the point of law is being involved, question of issue.
So what is your stand?
First, my lord, let me, my lord, the first one, whether, my lord, if my lord comes to a finding, there is an order, mandatory order regarding preference, then they have a case. The writ petitioner have a court. This is the cause of objection filed by my learned friend, senior colleague. My lord, second,
you say there is no mandatory order.
There is no mandatory order regarding preference. Second, my lord, Mr. Sahara, the senior advocate, my lord, made a submission at the relevant point of time that it is in discrimination. Why? Because so far other.
It will actually, Mr. Sahara, be better if he argues first. Because if he is taking this stand,
yes,
then you will give a composite reply to.
Yes, that is.
It will be better actually.
Yes.
Second point
My
I am
submission
making.
is recorded, my lord. I need not
Yes,
repeat.
yes. You also file a written notes about it.
Yes, so Justice Bhattacharya is newcomer. That's
No, Justice Bhattacharya will have that. He remembers as much as I do of your submissions.
Well,
whether it is a compliment to other honorable judge or is
No, it's against me because I don't remember anything. That's why.
my lord is taking a note, extensive note.
yes,
Yes, yes,
already.
we have seen that, and we
Yes.
pose questions to you.
Yes. And my lord, Mr. Shah,
discrimination.
yeah, Mr.
Discrimination.
Shahara submitted. There is a discrimination. Why? Because X7 except this particular spot in question where the advertisement was floated at the relevant point of time. Others were so far others are concerned, they were actually the authority took a decision that new the advertisement to be made. So for other the
Other
leadership and the my lord the in question distributorship is in
What is your answer to that, Mr.?
now, my lord, my reply is to that. If my lord comes to a finding again at the cost of it, comes to a finding in reading out or in reading between the lines, my submission would be there is an order, mandatory order, that I have to make an advertisement further, and this is up to the level of the Supreme Court. It went to the
Regarding the other matters.
No, this
Why
is
not regarding-
why I have singled out.
Why?
Because why the person?
Just ask why.
Yes, that is the question. My lord,
That is
my
answer.
submission would be there is a mandatory direction on the part of the Honorable Division Bench that you have to make a fresh tender or advertisement on a particular spot mentioned in. And it was challenged before the Honorable Apex Court, lost the.
That is not this plot.
This plot.
This plot.
Only why I have carved out, because Mr. Shah has submitted, this is a discrimination. Why you have singled out only one person have been preferred or has been preferred or has favored?
Division bench said that there has to be a fresh tender.
Fresh tender regarding and the plot is mentioned in the division. So I have got no other, I cannot cancel, then there is a
SLP was
conflict.
rejected.
Yes, ma'am.
SLP was rejected against that.
SLP was rejected. And my lord, there is a, my lord, kindly consider, because I have no choice. Because if I cancel this plot in question, if suppose if I were cancelled, then there will be a criminal, the contempt proceeding. So I want to avoid that because there is a clear-cut order, and this was upheld by the, not upheld because this is a, my lord, SLP just dismissed. So the doctrine of merger is not available. However, the division bench order stands. So I have got no other alternative but to, my lord, make and face advertisement on a particular plot. And it was mentioned. Now, my lord, the third point. These are the, my lord, according to my humble submission, that there is no discrimination because I have to give the order, or I have to comply with the order of the Honorable Division Bench. That's why I didn't.
On the discrimination.
There is no discrimination on this one because I have to comply. There is no, Article 14 is not applicable.
Third point.
Now, third point is, my lord, kindly consider one thing. The latest, my lord, the Control Act has come into effect. Now, my lord, there is a
which year?
2024 or something like. My lord, right now, my lord, 25, I think so. 24, 20. Huh? 24. My lord, the Control Act, my Control Order, my lord.
24, yes.
24. Now, my lord, there is a provision. Crux of the case, there is a provision. There, the 50 lakhs. 50 lakhs, I have to show my security or something like that. That it has come down to or 25 or something like that. What they are seeking, because the honorable men, they have sought for cancellation of this particular plot in question, and direction may be given to the authority to make a fresh tender or face advertisement. That is not subject to my lord's honor. That is not possible. Why? Because in the
Same is Mr. Shahara 6.
Mr. Shahara says because now they have the credential
If it would
and
be
they can comply with. Yes,
So-
if any fresh advertisement be given on the particular spot. There I say, my lord, first of all, my lord, kindly, if my lord goes through the Honorable Single Judge judgment, it is very clear, Honorable Single Judge has said, Honorable Single Judge proceeded on the basis, my lord, that there is a mandatory order of the Honorable Division Bench to give preference. That is the crux of the case, my lord. And my lord, there is no such thing. And my lord, kindly see the prayer. Or brief. Brief to
Not required.
No, no.
Those are for ordinary people.
অনেকদিন আগে সব মামলা করিস মেলা kindly see, মেলা kindly see. The prayer application for state, this is school তুলি আর একটা কোথায় কটটা কই
Learned Single Judge says that there is a mandatory order of the division bench to
mandatory order to give preference to a self-help group, women group or self-help group. Previously it was there, my lord. I should be candid to my lord. Previously it was there, and my lord, that it was modified, and my lord, they didn't challenge. It was it will be reflected from the Honorable Single Judge order itself. There is no challenge was made. If simply they have come forward saying that they because the order says
the division bench judgment was Justice I.P. Mukherjee.
Yes,
Single judge was Justice Moushumi Bhattacharjee.
Moushumi.
We recollect the entire matter now.
Yes.
What other point?
Yes, these are the 3 points, my lord, and can you see
Remembered by
the
self-help and women.
yes, self-help group, my lord. Self-help
Rather
group,
obvious.
women's group or something like that, my lord.
So very well.
So these are the points, my lord.
So therefore you gave preference. You had to give preference to them in any event.
I had to give preference.
Not them, self-help and women.
Now because they are what they are seeking right now. They were seeking a fresh tender to be.
They are not
published.
self-help or women.
But they are self-help group, claiming to self-help group. Women.
Then why give preference to them?
Oh, my lord, what they are seeking.
Oh, they got the order. Sorry. For that, they are. What is your answer to that?
They are seeking that.
Yes, that order
first
was given them.
advertisement is to be made. Advertisement because everything was quashed. Only 7 except you cannot. This is
So
a
what is your answer to
discrimination.
that, Mr. Sengupta? What is your response to that? Rather that women and self-help group should be given.
Yes, women and self-help group. So far,
given.
this manner kindly consider. My lord is preferring an appeal.
No, I am not preferring it.
No, sorry. My lord is hearing the appeal. Sorry, my lord.
You will prefer the appeal after it.
My lord, yes. My lord is hearing the appeal.
Yes.
And my lord, in the appeal court, my lord will see whether the order of the Honorable Single Judge is contrary to law or something like that, or is perverse or something like that.
It is not.
My humble submission would be because Honorable Single Judge has proceeded with that only one, that there is an order of the Honorable Division Bench which gives them, that is the self-help group, a priority on the basis.
The valid basis.
That is the valid basis of the order of the Honorable Single Judge. In spite of the fact that the Honorable Single Judge has recorded our views as well as the petitioners, the other appellants' view, that first of all they didn't challenge that order, the actual the circular where that is statutory circular where that is clearly held that 50 lakhs is so far the.
No, what was the impugned order of the learned single judge? Ultimately, what was it?
Ultimately, my lord, they may be preferred. They may be given the same opportunity, 25 lakhs, which the latest.
What was the exact direction? A new tender? Nothing. That they have to, they will get it. They will get.
No, because government.
The ordering portion.
Government is direct. Kindly see the ordering portion. Government is that. Kindly see.
Oh, modification of the vacancy notification for appointment.
Because
modification in the light of self-help groups being
self-help groups as well as the mandate, the latest after modified, that was modified 25 lakhs, 50 lakhs to it has less. That is, it was yes, less than to 25 lakhs or something like that. Now it has come down.
So now the new tender, now you have to modify it by reducing that security to 25.
That is the
But you are then making contradictory submissions, Mr. Sengupta, because the first your ground was no
Yes.
mandatory order of preference.
No mandatory order of preference.
But then you say that the learned single judge's order, you are supporting the order. Or you say
Yes.
you say that you don't challenge the order first of all of
No.
the learned single judge.
No.
So you abide by the two modifications directed. One is women and self-help group has to be considered, and secondly, it has to come down to 25.
25.
Now you
That
make
I cannot.
now you abide by that. Now, but your first argument was there is no mandatory order of preference. Therefore, the COT should fail. What is the COT? What do they want in the COT?
That the preference because of their submission.
Women.
That the women and self-help group. They maybe.
You say that self-help group and women, that part of the order is not correct.
There is no mandatory order.
In that order also.
In that honorable division bench order. My lord, I am saying honorable division bench order.
Achha.
And number two, my lord, there is no case of discrimination because as per the order of the honorable division bench that was upheld by the honorable apex court, there was a direction directing me to make fresh advertisement on a particular spot that was mentioned. So there is no discrimination regarding Article 14 of the Constitution of India because their submission was that I cannot be single. That I have given paper.
You are not challenging that portion. The learned single judge in Justice Bhattacharya.
Yes, I am not.
Was that bench? Did that bench direct that women and self-help group also has to be given preference?
Yes, but no, not preference. But they are given to they will get that privilege.
They will only get that.
I get 1 minute.
I'm taking
That paragraph, last but one paragraph, page 170.
I will. Yes, kindly see the once.
The impugn order.
Yes.
Yes, we are there.
That's right. To paragraph 20.
Yes, 20.
The modification should be made in line with the reduced financial solvency limit of the facility. The zone of consideration, including for self-help group, will be in the accordance with the latest modification.
Yes, that means
that has been given a go by.
Latest modification takes that away.
Yes. Yes, takes that away.
Takes that away.
Reconcile both this finding and the conclusion cannot be reconciled. This is
that was your
case.
And my submission was also recorded. Kindly see that. Kindly come to page 174, first 173. Kindly see. The Honorable Single Judge proceeded on the basis of that there is a preference. My lord, kindly see.
Yes, that
173.
No, that we recollect. That we recollect.
Page 11. Paragraph 11, 170.
There was a finding that should be. The presumption was.
With the while the observation of the Honorable Division, may I read? But just a minute, madam. Well, the observation of division is relation to women's self-rule is relevant. Contention of the state as well as added respondents also cannot be ignored. Kindly see. According to state and the preference to self-help group in clause 26 controller was amended on 18 December 2018 and was done prior to vacancy notice dated 17/7/2019. The relevant paragraph of the amended notification dated 18 December 2018, which is part of the affidavit of the state respondent, shows that the zone was widened to include not only self-help groups, but also registered cooperatives, semi-government bodies, individuals, group of individuals. So, no preference, only preference part is deleted. But, my lord, the zone of consideration has been widened. But kindly see, petitioner did not challenge the amendment to the 2013.
You are reading which paragraph?
Well, paragraph 11, page 173. Challenge that it is therefore arguable whether petitioner can now question the dilution of preference given to self-help, women self-help after publication of impugned vacancy notice on 17/7/2019. Now, this is the, my lord, kindly consider the Honorable Single Judge, my lord, also in a doubt, my lord, that whether this order can be passed in his favor or not. Well, kindly see petitioner other givens, my lord, that is the petitioners, my lord, the court,
court relies on the 2018 notification, but amendment shows zone was widened.
Now it is.
Mr. Basu says that ultimately the direction was to follow the latest notification.
Why? That's
And coupled with that,
yes,
there's a contradiction in terms, Mr.
Yes.
Basu is saying. But it cannot be both together. The zone of, because the order says the court is not inclined, is hence directed to modify the vacancy notification for appointment within a period. And para 20 says the modification should be made in line with the reduced financial solvency limit, which is quite all right. I mean, that is also the intention of the division bench maybe. Across the state, the zone of consideration, including for self-help groups, will be in accordance with the latest notifications.
Yes. How
If that be so, he says, in accordance with the latest notification, they don't have a zone of consideration separately.
Separate, because preference cannot be given.
So if this is to be followed, then Mr. Shahara's client cannot be given any preference.
That's it.
Good. Now
is
let's
my
Mr. Shahara. Yes.
Can it be taken up in detail?
No. Part matters. That's why you have made this specially fixed. Mr. Shahara, you are ready in the matter, please. You can never be fully ready in any matter. No council thinks I am fully ready. We never think so. Even while passing judgments, I don't think that I am ready.
Understanding, my juniors told me that since this matter has been released, it is wrongly appearing. I had a talk with Mr. Agoral also. Yes,
14 matters, same order passed. We specifically said in respect of each of the matters that we are putting it in the regular list because it was part heard. It appeared before the other matter. Released only for that reason so that we can put it that bench. We don't know when that bench will sit and take up hearing matters. That is the only reason, to give you preference over the others. But if you don't take that preference, then we cannot compel you to. But Mr. Shara, we cannot. You are all here. Please complete the matter.
All right.
You are ready in the matter.
Before that, just 2 to 3 minutes time. So far, the history of the case is concerned. Because
No, that won't be completed in 2-3 minutes.
Yes. Yes. But initially, a vacancy has been notified in 2011.
Right.
Under 2003 control order. But in 2003 control order, there was no provision for providing.
List of dates.
No.
But there is a list of dates we have handled.
List of dates they have handled.
I'm not following the list of dates, because that has not been recorded in the list of dates. He is not following
List
you.
of dates and 1-2 pages written submission we have.
So they've given a 2011 thing. Anyway, we do it your own way. Yes.
2003 vacancy has been notified at Jamtala Hut.
2011.
Yes.
As per the 2003 controller.
2003 controller, there was no provision for giving preference to the self-help groups.
There was.
No.
No.
But one Borun Ghosh and my learned senior friend client, Mr. Basu's client, applied for. A selection process has been conducted. Finally, Borun Ghosh has been selected by all authorities, including the district controller. Then district controller forwarded the name to the director, district distribution, procurement and supply. He also recommended the name of Borun Ghosh.
Then?
Now the file has been forwarded to the secretary. In the meantime, on 8th August 2013, new control order came into force. With the rider that henceforth self-help group, especially women and self-help group, shall be given preference.
You satisfy both. You are a woman who run? Yes, very.
Now the secretary rejected the recommended only sole ground. New control order came into force by giving preference to the woman and self-help group. So previous vacancy goes. Accordingly, he rejected the recommendation and directed the district controller to declare fresh vacancy in terms of 2013 control order, where preference has been given to the woman and self-help group. A writ petition has been filed by Borun Ghosh. Justice Tapabrata Chakraborty passed an order in favor of Borun Ghosh, holding that there should not be fresh vacancy. Vacancy is state. Secretary is directed to reconsider the matter. Against that, an appeal has been prepared by the state, as also my learned senior friend's client. A division bench presided over by Justice I.P. Mukherjee, as his lordship then was, decided the issue. My lord, kindly take up one paragraph of that judgment. Kindly turn to my lord page. Come to page 6.
Why did they prefer? Because they were not selected. Borun Ghosh was selected.
The learned single judge held in favor of Borun Ghosh.
Right.
Learned single judge was the direction of the secretary to declare fresh vacancy. All right.
Which page?
Page Just I'm giving it.
Yes.
Okay, my lord.
87 না 62
62. তাই তো?
দুটোই
62 April of Shebait.
You see the আরম্ভ
Page 62.
It starts.
Kindly see the date of the judgment. This is very important.
It's not
25th September 2018. Kindly take note of this.
Yes.
And now call it on to page 86.
This is acha.
Page 86.
It's not in the paper.
Yes.
But I'm reading page 86. So kindly take note of the first paragraph. After third line from first top. As per 2013. Have a lordship got my lord? Page 87.
Page 87.
Page 87. Property portion.
It starts
6 or 7.
It starts from 82. Kindly turn to page 87.
কে বলতে দেন
Yes.
87 দেখবো তো
As per.
As per.
Yes.
What I'm reading. As per 2013 control order, there is a provision for giving preference to self-help groups, special women self-help groups. In view of inclusion of the provision for giving preference to certain groups, it implies that the zone of consideration of eligible candidate gets widened and the state gets an opportunity to select the best possible candidate for the purpose of distributorship. Accordingly, kindly take note of, accordingly, the decision of the state government to invite fresh application for grant of distributorship does not seem to be arbitrary or unreasonable. So, my division bench came to a conclusion since there is a new inclusion or preference to a women self-help group. The declaration of vacancy as decided by the state is not arbitrary, not unreasonable. This is the intention of the Honorable Division Bench. Now, the only pinching opinion is the issue of change of location of the distributorship. The vacancy at Jamtalahat could not be filled up for a considerable period of time. Accordingly, the need to fill up the vacancy is very clear. Without any possible reason to shift the location of distributorship, the action of the state is shifting to the location smacks a malafide and bias. It appears that the same had been done with the sole intention to favor a candidate who did not have the go down within the advertised area. Such action of the part of the state so and so. I'm not pausing for a moment. Why these findings? So for the previous vacancy is concerned, that was at Jamtalahat. Now, my learned senior friend's candidature, so far the previous postings is concerned, has been rejected on the ground. He could not show any go down at Jamtalahat. I have submitted paperwork last occasion. All together, there is a preference.
Now Jamtalahat has been shifted
Instead
to
of Jamtalahat, the vacancy has been declared nearby post office, where their proposed go down is shown.
Jamtalahat, they did not have any.
No. On that ground, their application has been rejected. Borun Ghosh has been selected.
No, they are not Borun Ghosh.
No.
Borun Ghosh has been selected. Their application has been rejected.
On that ground.
On that ground.
Achha.
Now the fresh vacancy sought to be declared nearby post office, only to favor this particular candidate.
Who is he?
And that has been taken note of by the learned single judge as also by the Honorable Division Bench. Why is this nepotism? Why this favoritism? Now, Your Lordship, kindly come to the next paragraph. In view of the aforesaid facts, the impugn order of the learned trial judge is set aside. Learned single judge selected Mr. Borun Ghosh. The advertisement and the vacancy notice published by the state on 13 July 2015.
No, the middle that has been blackened out in our copy. Is it highlighted?
I am reading from the paper book of the learned single
No,
judge. May I hand over the type copy on next?
No, but this portion is there also. That is probably highlighted. That's why it has.
Yes, now.
It's not scored through.
No, it is highlighted.
The appropriate authority of the state government is directed to initiate steps.
May I read my lord, the entire paragraph? In view of the aforesaid facts, the impugn order of the learned trial judge is set aside. The advertisement and the vacancy notice published by the state and so are also set aside because that is in the nearby post office. The appropriate authority of the state government is directed to initiate steps for issuance of fresh advertisement for filling up the vacancy of Jamtalahat Mauja, Kultuli PS in accordance with the provisions of West Bengal Public Distribution System Maintenance and Control Act 2013. Kindly take note of. At that juncture, there was a specific provision for giving preference to the self-help group, especially to the women and self-help group. Court directed to follow 2013 control order, not any subsequent amendment. The advertisement and vacancy notice shall be given wide publicity in accordance with the provisions of the control order 2013. This is the order, my lord. What was the duty of the state? To declare a vacancy.
Declare a vacancy
in terms of 2013 control order.
In respect of Jamtola Hut, pursuant to 2013, including self-help.
And the provision which was prevailing on the date of delivery of judgment.
That is 2013 control order.
2013 control order. What 2013 control order says on that day and the date of delivering judgment, preference must be given.
Women self-help group. That is undisputed.
Now what happened, my lord? When the vacancy has been declared, if you want to kindly turn up.
No,
No, Mr. Bhattacharya, don't go by Mr. Basu's.
Absolutely.
Sabotage his argument.
Vacancy notice. Kindly come to the vacancy notice.
When my lord argued, there was no microphone.
No. Judges' ears were attuned to that.
They're habituated with.
Now we have become habit. It's habit, Mr. Basu. Absolutely habit.
Hearing frequency is going down.
Absolutely. Absolutely. Memorizing frequency is going down.
That
because
is for
of
this Google. I am
not only
not,
Google,
I am
phone
not,
also.
I am not be surprised if my grandchildren, if you ask what is the name of your grandfather, he will search the Google and say.
We have other comments on that, but we'll discuss that later.
Now, kindly come to my lord, page 34 of the stay application. See the date of advertisement. 17 July 2019. Have you lordship got it? And Division Bench delivered the judgment at page 62, 25th September 2018. Why? Well, amendment.
This is the advertisement in terms of division bench. Supposedly in terms of this.
What they have done.
What happened in between? Yes.
In between, the preference has been withdrawn. On 17th of July 2019, page 13, your lordship, kindly take note, page 13. Kindly take dates. Take note of 3 dates.
Oh.
Division bench, 25th September 2018. Preference withdrawn. Kindly see the date. 18 December 2018. Thereafter, vacancy has been notified on 17 July 2019. Is it the spirit of the division bench order? Division bench says with no uncertain term, there is a change. Accordingly, we are accepting the views of the secretary. What is the change? To give preference. Mr. Sengupta submitted with your lordship that there is a direction we cannot withdraw the vacancy. The direction is 2013 control order.
So you say, as of today, the only possible order should be, the valid order should be that they have to revert back to the date of the division bench's order, follow the 2013 control order, and comply with that in its spirit and letter by giving preference to self-help and women groups, plus at that Jamtola Hut.
But that was my submission. But today my submission is this: no vacancy can be declared under 2013 control order. I shall come to that.
Then
fresh control order came into force.
But that defeats your argument regarding 2018 control order. You cannot choose your control order.
I am coming to that. I am coming to that. Before that, my lord. Your lordship, I have shown to your lordship, this is the vacancy. Kindly take note of, my lord. Following this subsequent amendment, without following the division bench judgment, vacancy has been notified without giving preference. That's my first point. You should not have waited. Even if you waited, you have to follow the division bench judgment.
All right.
Division bench judgment is very mandatory. Follow 2013 control order means 13 on control order stood on the date of delivery of judgment.
Right.
Which with no uncertain terms says preference should be given to the women and self-help.
You move on to next argument. Yes. Why do you say it should not also be, it cannot also be followed?
I am coming there.
Yes.
Before that, Lord. Yes. Now, your lordship, kindly come to page 90. Page, my lord. I consider that. Page 37. My next argument. Well, a number of vacancies has been notified. I have given one reference, page 37. Manbajar Purulia. But kindly see the date, 16 September 2019. This is subsequent to amendment. This is subsequent to amendment. So there should not be any preference. In Manbajar also. Kindly take note of page 37.
How it is relevant?
That has been withdrawn, my lord. Mr. Sahara should not miss this. Those
Why
have
they
been
have
withdrawn.
given preference in all vacancies except Jamtalahat. This has been notified on 16th of January 2019, subsequent to the amendment. But without following the amendment, preference has been given. Kindly take note of, my lord, the second paragraph.
There is Jamtolhat is does not feature here.
This Manbajar in Purulia.
Jamtolhat is it's a
It's a
different.
separate vacancy.
Then
why I am saying so?
Yes.
In all of our West Bengal, even after amendment.
This is an example of that.
Yes.
That has been withdrawn.
Yes. I am coming. Sir, I am coming. Kindly take note of
39.
second paragraph.
Page 39.
While selecting suitable candidate for granting distributorship license under the West Bengal Public Distribution System Maintenance and Control 2013, preference may be given to the self-help group, especially women and self-help group. This amendment has been taken place 18 December 2018. And this notification has been notified on 16 January 2019.
So for other places, even after 20.
Even after preference, in all of our West Bengal, preference has been continued. Except Jamtalahat.
Page 39. My lord, kindly come.
Now what happened, my lord?
Oh, sorry.
If I instate to your lordship, I can stop, my lord. Since the Shenmukh is saying.
Why should you? Have you asked you to stop? You can ask him to stop, but he won't follow our directions.
Now, your lordship, kindly come to the withdrawal order. Kindly turn to page 39. But number of cases has been filed in all of our West Bengal, challenging the condition of 50 lakhs for one preceding year. The state government took note of the same and ultimately decided.
You want to take advantage of both worlds. 2025, 50 to
Ultimately,
25 and self-help and
no, my case
how can
is
you have
that
both?
You have withdrawn all vacancies in all of our West Bengal on the ground that 50 lakhs for 1 year is not practical. Except Jamtalahat. You kept the vacancy of Jamtalahat.
Page 39 is that withdrawal?
Yes. Can you take note of page 39? Third paragraph, may I read, my lord? And whereas besides above, reasonable department has fined made to confirm service number of court cases in the Honorable High Court, Calcutta, against the aforesaid vacancies on the ground of applicability of the clause of particularly the relating to the restrictive clause of financial solvency of rupees 50 lakhs for last 1 year from the date of application and general insurance 1 year and so on. And whereas the government has decided to declare all vacancies. So, my lord, state government himself understood.
State government herself. State is she.
State is so decided that this condition of
state is she, country is she, state is he. Except we are not in Russia, that it's fatherland.
Motherland.
State is motherland.
Motherland.
Oh, that
in all respect. In all respect. So state government already decided that this 50 lakhs rupees on the date of application preceding 1 year is impractical. So withdrawn. All over all vacancies.
But that ground should also apply to Jamtala because it was never imposed in Jamtala. That's why it was not also withdrawn.
It has been imposed in Jamtala, 50 lakhs.
Oh.
It has been imposed like other vacancies in Jamtalahat. Which are case, specific case, I cannot.
No, after this, again, a vacancy, is there any other vacancy notification than Jamtalahat imposing 50?
Yes.
In all places, again, 50 has been imposed.
All. Then all withdrawn. Kindly see that body.
These are withdrawn. We are seeing these withdrawn.
After
Jamtala could not be withdrawn because this was never imposed in Jamtala in the first place, that vacancy notification.
Jamtala
So Jamtala remained as it is.
50 lakhs have been imposed Jamtala in all vacancies. It is not the case. Kindly come to my Jamtalat vacancy. At page, my lord.
So this was withdrawn on the ground of 50 lakh.
No, I am saying
Others were withdrawn.
others were withdrawn. But the same condition in Jamtalat kept pending. This is my kindly come to my lord Jamtalat vacancy. At page, my lord. Just I have shown to your lordship. Page 94. 34. Kindly turn to page 34. Kindly take note of. This is Jamtalahat. Kindly see the date, 17 July 2019. Kindly turn the page. Column number 5. Rupees 50 lakhs on the date of application. And 1 at preceding there too. Clause number 5 at page 35.
So this was before that withdrawal.
Before that withdrawal. In all of our West Bengal, now your lordship once again come to the withdrawal page 39.
Withdrawal that is 7th of August 2019. And before that, this Jamtala was there, but this was not withdrawn.
This was not withdrawn.
Where is 50 lakhs stated in page 30?
Clause 5.
Clause 5. 35. Page 35. Clause, my lord, clause 5. No, 5, my lord. Clause 5.
Yes.
Subsequent thereto, all vacancies which have been notified has been withdrawn, keeping only Jamtalahat. Our specific case, we are a women and self-help group. We cannot provide rupees 50 lakhs on the date of application. We can, but not for 1 year preceding. Why not see how many vacancies has been withdrawn? Page 39. All over West Bengal. The table. Hooghly, North 24 Parganas, Murshidabad, Uttar Dinaparur, all vacancies.
Understood. Up to this much, understood.
Up to the kindly come to the next page, page 40. Even 24 Parganas, South, serial number 8.
Very good.
Except Jamtalahat. 24 Parganas South, on the very same day, 2 vacancies have been declared. One Jamtalahat and another place. The another place has been withdrawn, but not Jamtalahat.
Right. Then what
Now,
happened?
my lord, kindly come to page, my lord. Now, what is the present position? Kindly
You had challenged this before the single bench in this matter?
Yes.
What had you challenged? What was the writ petition? Oh, they had.
My writ petition is condition of rupees 50 lakh.
You challenged this Jamtala Hart
Yes,
vacancy.
Jamtala vacancy was under challenge in the writ petition.
So page 34, 35 was challenged.
Impugned in the writ petition. On the ground, we should be given preference and rupees 50 lakhs on the date of application and preceding honor is not practical. It cannot be.
So not rupees 50 lakh and women self-help should be given preference.
These are the twofold submission before the learned single. Yeah, that was my case. I shall show to my writ petition.
So you have two things in your favor. One is division bench order, and also, in fact, in the new notification, the self-help group women was retained in 16/1.
Despite that events,
even after
at
20.
the time of division bench judgment, there was no such withdrawal. And all over West Bengal, all vacancies withdrawn, taking note of the financial solvency in respect
When
of
was
job.
women and self-help group withdrawn? By 2018.
Yes.
But even after that, a notification was issued, although that was withdrawn.
This is my second point.
But that has been withdrawn, they are saying.
That's something different.
On
Not
a
on
different
that
ground, though.
Not on that ground.
No, on a different ground. But still, that stands withdrawn now.
Yes. Now, you also kindly come to page 164.
Yes.
But this is the subsequent to the withdrawal of the vacancy, 18 December 2020. Kindly come to clause number 2. 25 lakhs.
25 lakh.
On the date of application and preceding 1 year. Now, it has again been changed.
But in the same breath, you cannot say that 2013 control order should be followed by including women, and that 25 lakh you would be getting. Choose one of two. You have to elect.
Only one judgment. where the state government in previous occasions, when 2013 control order came into force, withdrawn all over West Bengal all the matters, just on the ground that new control order came into force, we cannot continue. I have the privilege to appear some of the matters. We own the case before the division bench. Matter went up to the division bench. SLP, state prefer and SLP.
No, if 2020 is the last, or subsequently also there is another. After 2020, there was another. 2024 is the last.
First 2003.
No, that.
Then 2013.
3, 13, 18.
No, 18. 18 is the amendment.
Amendment of 2000.
18 is the amendment. The new control order came into force 1st June 2024. 1st August 2024.
So you want to come under that, but that does not contain women's self-help group.
I shall argue.
Cannot have both.
Today, in any manner, 2003 vacancy cannot be possible. What will be happen if a person selected?
That vacancy is still there in Jamtala Hut.
Yes.
That has been court interfered with. That has been court
But
interfered
that is still there. You at the same breath, you are wanting to take advantage of your being a women-run self-help group under the 2013 control order. And at the same time, you want to take advantage of 2024, which puts it to 25 lakh. Now, you have to choose one. Either you say,
no, I am not.
If division bench Justice Mukherjee's order is to be complied with.
I am what I am submitting. If you kindly come to page 164 just for a moment.
164, we are there, yes.
But kindly see the condition.
25 lakh.
25 lakhs on the date of application and preceding 1 year. Now, again, it has been changed.
And last paragraph.
Last paragraph.
This order shall not be applicable to the vacancies
Yes.
which has been notified by the
I
license.
say, subsequent to that, it has been changed, and again it has been changed. I have handed over your lordship as a loose sheet on 11th May 2022. Now it is 25 lakhs only on the date of application.
I can lose this. No, it is the 2013.
One loose sheet I have handed over on last occasion.
2024.
This is May 11, 2020. It has again been, condition has been changed by saying 25 lakhs only on the date of application.
No, এটা বলছেন 24 বলছে
আগের দিন দিয়েছিল এখন তো 25 হয়ে গেছে
এখন 25 হয়ে গেছে এই জাজমেন্টটা কোথায়
আর কোনো কাগজ কি এটা ছাড়া নেই
জেরক্স করে দিয়ে দাও মে আই রিড মাই
2022 there is something
11 May.
Oh, that yes, okay.
Now it is 25 lakhs only on the date of application, no preceding.
This is the last control order.
Last before coming into force 2024 control.
After that also 25 they are saying another control.
Fresh control order.
Before.
This amendment of the previous one.
My submission is that
so it's still 25 lakh.
All the vacancies has been withdrawn. I have shown to your lordship. Subsequently, after change of this, all fresh vacancies has been notified.
Yes.
Condition 25 lakhs only on the date of application.
But their state stand is that since Justice Mukherjee's order was there regarding this particular Jamtal Hut, they had to comply with that. Therefore, they could not withdraw it as such. They had to issue a fresh vacancy notification on that. So if they withdrew, that would be non-compliance of violation of Justice Mukherjee's division. That is the stand of the state.
That is the stand of the state.
Then they have to comply fully.
Yes, comply fully.
Comply fully means that was 50 lakh, but 50 lakh, then it was not 50 lakh. Then if you take, then 2013 control order says preference to women self-help, but 50 lakh.
So one hand, they are not following the division bench judgment, according to Mr. Sengupta. If they followed the division bench
you are also blowing hot and cold, Mr. Hara. You are once saying that
what to show before your lordship, they have to follow in its full spirit.
So your cross objection is also there. What do you want? You want the
reference to the self-help group first.
Then 2013 control order, because now there is no such provision.
Next submission.
How can you have both?
West Bengal, you have withdrawn all vacancies. Don't keep one vacancy alive. What is your principle?
How can Justice Mukherjee's order stands in the way? Then that should not be complied with. They should withdraw and issue fresh vacancy notification in terms of the latest. Then you don't have any preference as women health.
Notified in terms of the division bench judgment. I do agree. In the meantime, you withdrawn all the vacancies. Is there any bar for a?
They could not because Justice Mukherjee's order stands in the way. Justice Mukherjee's division was specifically directed, actually Justice Sinha directed. That bench directed specifically to issue a vacancy notification regarding Jamtola and giving preference to
2013 control order.
2013 control order.
This is also part and parcel of 2013 control order. This amendment. This amendment kindly take note of, my lord. Kindly read the first paragraph.
When the amendment came?
This is part and parcel of the 2013 control order. This is a modification amendment.
Modification of 2013.
Yes.
2000. Acha, 2012, that order number 3939.
Place before lordship.
That is the 2013.
Yes. Kindly see that order.
When amendment came?
Oh.
বলতে দাও তুমি যেটা 164 malad is clear. Kindly come to page 164. Yes. This is a modification. Second paragraph, last line. This is the amendment of 2013.
No doubt about
Think
it.
about it. ভুলে যাচ্ছিস কেন? এটাই তো ভুলভাল করেছিস। Kindly come to page 164. Second paragraph, last line. In terms of 2013 control order. So amendment is always part and parcel of the control order. Court says declare the vacancy under 2013. This is part and parcel of 2013.
But Mr. Shah, you cannot selectively choose the amendments.
Why?
You cannot selectively choose the amendments. By some of the amendments, women self-help group has been removed. By the others, 25 lakh has been.
Accept the views of your lordships. Then
Not our views. You cannot choose what. It's your election. If self-help group stands, the amendments cannot be given effect to it. Remains at 50 lakh.
To either accept this modification or you have to give preference to the self-help.
That applies to you, Mr. Shahara. You have to select your argument. You cannot take advantage of both. Self-help group, 2013, 50 lakh.
Yes. Yes. My first. Then now your lordship kindly consider. I shall rely upon two judgments. Before that,
A date kindly be noted that he is relied upon amendment 2022. Yes, oh, my lord has already seen.
Yes.
Page 164, that is 2020.
2022.
Yes. This is what he has relied upon, my senior colleague, my lord. He has relied upon an amendment that is on 2022.
Yes.
And this is 2020. 164 is clear. My lord, how can he really jump up, my lord, and keep.
How can you jump up? He's arguing. Yes. What else, Mr. Shah?
Yes. But first I shall rely upon on the self-same issue. So far the self-help group is concerned and preference is concerned. This is reported in 2019 volume 15 Supreme Court cases, page 718.
You'll hand up copies to us?
Yes, ma'am.
We'll
No, not yet. Lordship, kindly come first, my lord. Paragraph 3, the brief facts. Just one paragraph, paragraph 3.
Your respondent number? 1.
In this case.
In this appeal before us? Shama self-help group?
Yes, Shama.
Yes. Cross object.
Cross object.
Also the cross object.
Yes. Yes.
But kindly come the first flap. I have given the flap, page 7 of the online copy, paragraph 3. May I read, my lord?
Paragraph 3?
Yes. Just brief facts of the case. At page 7, online copy.
Online copy means this is.
Yes, my lord.
Yes, online web
Left
edition.
hand side. The number of page.
Page 9. Paragraph 3 is principal issue raised.
Yes, the principal issue raised in whether contract for the supply of such food for Ongwari should be given to the local Mohila mandals run along democratic lines with local women participating, or whether such contracts ought to be given by the state to large contractors under the guise of the condition of the tender, so and so. The contracts shall not be used for supply of nutrition, so and so, Mohila so and so. Then kindly turn to my lord, paragraph 49 at page 29. Paragraph 49. The book page is 746 and online page 29. Book page 746. Paragraph 49.
Yes.
when we consider NIT in question issued by the government of Maharashtra, we are of the considered opinion that it was not in the spirit of the orders passed by this court, my lord, our case. As the imposition of the condition of 25% of the turnover during any one of the last 3 financial years in the various districts by insisting for the performance of supplying at least annual average value equal 25% of the required turnover of applied sectors. As to the formation of the applied sector, it is apparent from the tender notice that each of the districts has been taken as a unit and yearly expenditure, for example, Ahmednagar, rupees so and so, yearly 25% would come to rupees so and so course, and so on district-wise with so and so. Thus, we find force in the submission that by virtue of the imposition of the aforesaid condition, only big players have been left in the field, and that is not in tune of the spirit of the Act and the orders passed by this court, as when as the policy framed by the government of India as projected on the aforesaid affidavit dated so and so. Then paragraph 50. Tender notice which has been issued also falls down. We direct the tenders to be invited afresh within 4 weeks, strictly in as per terms of the so and so, it has so and so. So our case is also that since 50 lakhs rupees condition.
You have not challenged the office order, Mr. Shahara. You have not challenged the office
I
order.
have challenged the vacancy. I have challenged the
The
vacancy.
vacancy notification has to be in terms of some control order. Unless you challenge the control order, you can take one of the limbs of your submission. Either of the same, both cannot hold true together. One is that because Justice Mukherjee's division bench said, in terms of the 2013 control order, you issue a fresh vacancy notification. Just by lapse of time, some other control orders amendments came in. They are trying to take advantage of that. They cannot do that. They have to stick to the date of the order of the division bench and comply with that in that letter and spirit, and follow that, issue a vacancy notification for Jamtala for giving preference to self-help women.
I understood, which is foreign from your lordship.
Then
Because
50 lakh,
according to
50
your
lakh has to remain. And the
That is-
second limb is, yes, you have to follow the latest notification. You are following that for all others, follow for us also. But if that is follows, women's self-help group goes, but it comes down to 25 lakh. It is not restricted to big players also.
I understood, my lord. Our
You have to
specific challenge.
choose one.
my lord,
Yes. What is your submission?
The submission of Mr. Sengupta, and which is foreign from your lordship also, that since the division bench gives direction, state
That
has
was your
nothing-
argument.
State has nothing to do. They have to keep rupees 50 lakhs.
So as per the 2013
lakhs.
notification, because you by lapse of time, you cannot take advantage of your own wrong.
But so far,
That is one argument. You made that argument. Now you are saying the latest control order has to be followed. 25 lakh, make it 25
but
lakh.
if
Then
you kindly,
women self-help group goes. They'll also have 25, you'll also have 25.
but so far, women self-help group is concerned. Our specific case is that altogether that was there, altogether.
No, it was taken away subsequently.
You have not challenged that.
So far, the taken away part is concerned, my lord.
Amendment was made.
That is not the issue before the learned single judge or before the division bench in the previous proceedings.
No,
So we have no case so far.
could
this
not
come-
be. Could not be because that did not come into
Right.
place.
Now, our only case in our petition we have made out, like other petitioner is all over West Bengal. The condition which we have imposed, rupees 50 lakh for 1 year.
So then it has to come down to
Now,
25.
your lordship, kindly take note of. You have considered that aspects of the matter. In the notification that has been recorded, number of cases have been filed. Challenging the condition number 5, that is rupees 50 lakh for 1 year. State found it practical to reduce the amount. Why I should be debarred from this?
Justice, the learned single judge's order, which is impugned before us, Mr. Shahara, apparently suffers from one fallacy. That is, latest notification has to be followed, giving importance to zone of consideration women.
For that our court also, my lord.
Now that, Mr. Shahara, is self-contradictory. If the latest notification is to be followed, the preference for women's self-help group goes. And if women's self-help group has to be given preference,
Understood.
latest notification goes. It's very obvious. So we have to modify that
I
either.
have to accept my lord favorable part, and I shall not accept the against.
No,
part.
both are favorable in different senses.
Understood. But once again, I am submitting, my lord. It's a state policy. It's a state policy.
That's why women's self-help group has been changed. Now state policy is, no, we are lowering it down. Men are equally important. So we will not give. And non-self-help group who do not help themselves, they are also equally important. So we leave it open for everybody, which is more inclusive, comes down to 25 lakh.
Just one paragraph of my petition. Prayer portion, prayer.
Whatever.
Page 17 is my prayer. Edit in the nature of mandamus, declaring the condition number 5 of the vacancy declaring notice dated so and so, issued by the district collector so and so, cost and settle Article 14 so and so. So our specific case in my writ petition, whatever the division bench judgment, I am not concerned about the same. There is no whisper in the vacancy.
There should be parity. It should be according to everybody should be on the same footing. And everybody else, regarding everybody else, Mr. Shahara, the latest notification is being followed. 25 lakh.
Yes.
So that then that it comes down to that.
Yes, and that's the order of the Justice Bhattacharya also, single bench.
No.
According to latest circular.
See the next part of the sentence.
Absolutely.
So you have to choose between women and money. Either 25 lakh or women.
Now my last submission. I
prefer to put it to the women self-help group, frankly speaking, personally speaking, because they have to be given a boost.
But today
I fully agree with your contention. But then you cannot follow the latest notification. Then I have to modify.
No, I understood.
But that argument is more lucrative. That 2013 the division bench's direction was in when 2013 was in force.
That's my main argument.
If you cannot frustrate that,
yes, by virtue of a subsequent,
by virtue of your delay.
Yes.
By virtue of your delay.
Best case, my lord. This is my
division bench gives preference to self-help groups, women self-help, which I fully agree with because at that point of that was the law. Now you make a delay.
All right, my lord. I'm accepting.
And you put in a new control order.
Today, whether my lord, this vacancy can be continued.
But you don't have 50 lakh, but you are a woman self-help group. So you would be ousted either way.
I'm coming to that. Today, if there is a vacancy by giving preference, I can.
Then women self-help group cannot be given a preference. We have to take that away from the women.
This is
presently it's not there. Currently, sorry.
2024.
2024, 2022, 2020. Women's self-help group has been taken away. 20 lakh has been.
At that material point of time, which has been just fallen from your lordship on the date of delivery of judgment.
Then 2030.
Either way, if 50 lakh goes, I cannot take the advantage of this 50 lakh reduction. Then I should be given preference to so far self-help group is concerned.
Definitely.
Yes.
Either of the two has to happen.
There should be a fresh vacancy. By giving preference, so only I should not be others also.
Others on similar footing.
Similar footing.
Self-help group.
If today vacancy
but then 50 lakh.
By giving preference, my client may apply for. They may keep rupees 50 lakhs at that bank account.
Yes.
So I should be eligible if I apply for. Now the question is that whether this 2013 control order vacancy can be ultimately materialized or not. Today, a separate terms and condition has been.
So your argument is self-contradictory, Mr.
No, I'm coming to that.
I am tempted, but I cannot.
Your lordship, kindly consider today new
regime has come.
Regime what?
Control order.
Public distribution system goes. Targeted public distribution system.
Whatever name.
National Food Security Act came into force.
But that is general. That's a general argument.
No,
that may be the state of affairs general. But we are confined to the papers. We cannot make a social comment in the garb of a writ.
What license they will give? 2013 control order?
Yes. You say that that was your first argument. Now you are saying no, 2024.
2024 control order after coming into force, they cannot continue the 2013.
If we record your submissions, if we show you your recording, you started with 2013 control order should be adhered to because division bench says
that was at the time of filing.
So now you change that argument.
That was at the time of filing of my writ petition.
Very good. Mr. Shahara, if your last submission, current submission, your latest submission is that the latest, whatever is the latest notification, that should be followed. Then let that be followed. Then that is your last prayer, that it should be 25 lakh.
I am just keeping to your lordship. Whatever argument I have made on the basis
what is your stand? You have to take a stand before the court.
On the basis of writ petition and on the basis of my court. That is the cross appeal.
So either it has to be 2013 or the latest notification.
Now I am coming.
Both cannot come
at that material point of time. This new control order has got it shown its picture. It was not in the post.
So what is your argument? That what is your stand?
It should have been submitted by the state.
Forget them. What is your stand? Forget them. What is your stand, Mr. Shah? You have to take a stand. You cannot rely on their
Supreme Court. The latest judgment filed by the state Supreme Court says after 2013 National Food Security Act, all vacancies should go and there should be a fresh vacancy under 20 new control order.
So the latest control order has to be followed, cite the judge.
And Mr. Sengupta also appeared in this matter. As such, I am submitting before you. What
Cannot remember so many things. You may remember, you have lesser matters. Mr. Sengupta will come within the definition of Article 12 soon. He'll become the state.
Ready থাকো আমি পাবো তোমার কাছ থেকে আমি রিড করব
So read petitions will be maintainable against him.
I got the clue I have a cause of action
This is the latest judgment.
দেখা বাবা
জানে
জানে আমি জানি না চালডাল জানে আমি জানি না
The person between does not.
they are all my
There
lord
are 3 and 4.
Collusion.
There are 3 and 4. My lord, this has been settled by the Supreme Court. Kindly see what was the state case.
একটু পড়ে
There are 3 and 4. না পড়ুন।
কবে কাছে
Following the National Food Security Act. The state stand.
Oh, this is our state. Very well, yes.
Paragraph 3, 4.
এটা তো ডিভিশন বেঞ্চের অর্ডার হয়ে যায়
Paragraph 3, 4, then 10.
Legitimate expectation.
21 and 20. Kindly take note.
Legitimate expectation.
Yes.
Promissory estoppel.
Legitimate goes paragraph 21, 20.
Yes.
কোন না শুনি পড়িবেও না
Report.
আমাদের টাইমও দেবে না
Or you can answer.
No, but there is a distinction. One little distinction. It proceeds on the basis that there is no promissory estoppel on the part of the state. There cannot be a legitimate expectation that state will not change policy.
This is their case.
No, forget their case. It's between you and us now. Now, there cannot be a legitimate expectation of state policy. State may change its policy. That's legislative and executive power. But in your case, the division bench direction comes in between. There's a judgment of the division bench, Justice Mukherjee's bench.
In that case,
That has not been dealt with.
in
That
case, the
facet.
division bench also directed in this case.
Is it? But that has not been dealt with. That issue.
what is the effect
Division
Was that?
allowed the appeal by holding
That
the vacancy which has been declared prior to coming into force.
shows that.
Yes. That's kindly. Kindly read paragraph 3 first.
3, yes.
4, sorry.
4 actually is being agreed. Is application.
And paragraph 3. Paragraph 3. next.
No. 4. Said judgment single judge was assailed. Intercourt appeal among by the division bench while deciding held that has failed to justify recall for recovery. Quashed the notification.
Last but 4 lines, paragraph 4. The division bench, while deciding the said appeal,
Yes.
held that the state of West Bengal has failed to justify the decision to recall the vacancy, and that it
Right.
has acted in arbitrary, unreasonable manner, and hence quashed the notification. So
That was the
withdraw-
division bench in that case, that challenge itself.
Yes.
Here, Justice Mukherjee's order has attained finality.
Now,
It's a judicial diktat which stares at our face, everybody's face.
in that case, in this case, there was
In this case, this merged into the Supreme Court.
why I'm saying so, the state policy is that in this case, at least, submission was before the Honorable Supreme Court also, that since the new control order came into force, we have the prerogative to withdraw all vacancies and declare the fresh.
No, my lord, probably not, my lord. I appeared because I lost in the division bench, honorable division bench. There, the case issue was there that I made a humble submission because the records. Oh, sir, ঠিক আছে, ঠিক আছে.
Kindly read, my lord. Paragraph 6 also. It is a state submission. And para 2021. Para 21 is very specific. Because after National Food Security Act, the entire concept has been changed. Today, 2013 controller, no license can be granted. They have to grant license under 2024 for targeted public distribution system. entire concept of public distribution has been changed under coming into force targeted public distribution system. National Food.
In this case, Mr. Shahara, in this case, the notification itself was issued in 2015. That notification did not take note of the change of law in the interregnum.
National Food Security Act.
National Food Security Act. But here the notification itself was published after the coming into force of the Food Security Act. Here 2015 was the date of the initial notification which was challenged. But in your case, the genesis of this matter, the notification was issued when 2013 control order was there.
So, my lord,
Up to division bench 2013 was prevalent. So rights crystallized on the date of the
I am in a
division.
better position. In that case, that despite knowledge that it has changed, they issued the vacancy.
Therefore,
in my case,
the date of the vacancy notification in this case, Mr. Shahara,
2015.
2015
Without
already
taking note of.
without taking note of something which came in between.
Yes.
But in your case, which we are now dealing with, in this case, everything, the rights crystallized up to the division bench order when 2013 was in force, and the subsequent, nothing came in. The statutes, the control orders, nothing came. At that point of time, 2013 control order was a valid control order which was pending. The rights of the parties crystallized with the division bench order on the 2013 control order. Now the question is whether on that would be the cutoff date. Here, it's only a question of implementation of that order, which has not been properly done, which is the grievance in your writ petition also.
But I am on the practical aspect of the matter. Why I am saying so? In that case, that was the argument of the state that we had not gone through the 2013.
No, actually, no, you are right, because here you are not seeking an implementation of Justice Mukherjee's order. That was one of your arguments before this.
Absolutely.
But it's a subsequent notification which you are challenging.
I am challenging
this
the vacancy notice.
Of dated
2017.
2017.
Yes. My challenge is the
So page 34, page 34.
in July 2019.
34, yes.
I was not a party before Justice I.P. Mukherjee.
Page 34, what is the date?
Yes. 17 July 2019. In that material point of time, this National Food Security Act came into force.
Yes.
That's a similar case.
19.
Yes, 19.
7th July 2019.
17 July. Page 34, 17 July
17th July
2019. This is much later than the coming into force National Food Security Act.
So this is the genesis of the present. So then this judgment applies.
Yes. My case, my only challenge is vacancy notice.
So now you have to restrict them to 25 lakh.
People have to kindly see the first paragraph. There is no whisper about any division bench order. 17 July.
No.
I am only challenging the vacancy notice.
Very well.
So I can rely upon this judgment saying that in 2017, when National Food Security came into force,
2019, all this came into force. This judgment is applicable. So therefore, 21, 22. Then your this women and self-help, that claim cannot stand because this change has come in.
on practical. I have argued 3 points.
We cannot interdict with state policy.
So far,
that is also state policy. State chose to withdraw. This special protection for self-help and women groups that has been taken away by the state. It's a state policy.
Not in our case. Just the I.P. Mukherjee's judgment.
No, we cannot rely on both together.
No.
What are you saying?
No, I am not saying.
That's the I.P.
You are saying the equal lordship, it is fallen from a lordship. So
you are relying on a subsequent control order which has now come into force. You want to take advantage of that, which does not contain any preference for women and self-help groups, but reduces the security amount from 50 to 25 lakh. You cannot take 25 lakh and self-help women advantage at the same. So we'll give you 25 lakh. At best, you can get that. Yes. Yes. Any reply?
So
judgment.
far that judgment is concerned, I appear before the Honorable Division. Issue was, my lord, that the
another there is one. Just this is reported in 1990 volume 3 Supreme Court cases, page 1990. 660.
1190 STC.
But I'm handing over to Papa. Paragraph 16. Last but one page.
Citation বল
1990 volume 3 Supreme Court cases, page 669. Krishna Kumar Khemka. Just last but one page, paragraph 16.
Yes.
May I read my?
Yes, yes.
Similarly, as observed in Honorable so and such act of the president done on behalf of the court pending that any one of the project position to the such and so only project. If we apply the above principle to the case of Tatas, the tenancy created in their favor by the receiver is in violation of contrary to the injunction order, and such an act is subject to the petition so and so. Therefore, the tenancy created in favor of the Tatas was in breach of the order of the court, and consequently, the Tatas cannot claim any protection under the provisions of the act, and they are liable to be evicted. In the counter evidence, so the case of the appellant is that the checks were never so and so. The court held, if anything happened, even in contrary to the order of the injunction.
What?
This is that should be quashed and set aside.
Certainly.
In our
how is that relevant here?
Our case, Direction 2013 control order.
You're again relying on 2013.
So far, the justice I've been for this concerned.
So we should take the best of both worlds for you. 2013 control order self-help women group, as well as 2024 control order for 25 lakh.
Only for so far that judgment is called because I have placed before the learned single judge, and that has been quoted.
You misled the learned single judge. That's why the contradictory order was.
2024 was not in picture.
You have failed to mislead here because of the able assistance of Mr. Basu and Mr. Sengupta.
Mr. Sengupta is there.
Yes.
I am aware.
2024 control was not
insignificant.
Yes.
Only
one self-help group or 24?
My lord, I am
25 lakh.
actually, my lord, my lord, what I am
state?
making humble so far state is concerned, my lord. First of all, there was no, my lord, discrimination. Because
that you have already argued. Just reply to what.
And my lord, so far the judgment which he has relied upon when I appear, my lord, he has, that is 20, the reportable, my lord, that is, I think, my lord, it is already
in the Supreme Court, that Supreme Court one.
That is the state of West Bengal versus Gisusjot. It is, I think, my lord, I have read out,
what is your contention?
That is the SCC book also. The judgment is reported one. My lord, here, my lord,
then give us a citation also. It will be easier for us.
Citation, division bench,
you have SCC online, you can just have a search with the name. Yes, what is your contention?
Yes, my lord. Before the honorable division bench, the issue was, my lord, that the vacancy, regarding vacancy, my lord, they have come forward against that vacancy that their right has been accrued because they have followed National Food Security Act. On the basis of that, vacancy was, my lord, was made, and the inspection was done, and my lord, something
get the facts from this case. Yes. You need not tell us this.
Something was done, and that's why the right is vested, and accordingly the vacancy should be cancelled. The
state's right was upheld actually.
Yes,
and you can change your policy.
Yes, because here, my lord, I made a submission that as far as as soon as the National Food Security has come into place, I have a legal obligation to follow certain things. And at that point of time, when the vacancy, my lord, was disclosed or was made, at that point of time, that the provisions incorporated in the National Food Security has not been followed. So no right, there cannot be any estoppel against any statute, and my lord, they have got no vested right. So state policy, my lord, always, my lord, provided it is not arbitrary. And the Supreme Court, my lord, has come to a finding. My lord, kindly consider one thing. That is, they have already made a submission before the Honorable Division Bench of our High Court. My lord has accepted that there is an arbitrariness on the part of the state, because there is a necessary, my lord, 14, my lord. My lord, I am straight away, my lord, kindly come to paragraph 14. There is a necessary, sorry. there is a necessary interplay between the plea of legitimate action and Article 14. For a decision be non-arbitrary, reasonable and legitimate action of a claimant have to be considered. This was on a separate footing, my lord. However, to decide whether the expectation of the claimant reasonable or legitimate is a question of fact in its. Whatever question arises is to be determined not in accordance with claimant perception, but in larger public interest where other more important consideration may outweigh what would otherwise have been the legitimation of the claimant. In food corporation, such and such, my lord, it is, I'm not skipping over. My lord, Naila, kindly come to paragraph 16. Statement and objection, my lord. The reasons of 2013 Act, my lord, progressively undertakes necessary reforms by the central. That is the National Food Security Act. I am talking about National Food Security Act. Here, that's not has, my lord, has taken into account. My lord, the national by the central government in the targeted public in consonance with the role envisaged for them in the proposed legislation. Section 317, paragraph. Section 320 provides the right to receive food at subsidized price, and Section 4 provides for nutritional support to pregnant women, such and such, such and such. Similarly, Section 5 provides for the nutritional support to the Section 6 provides for prevention and management of the Section 12, my lord, I am just skipping over. Preference should be given, my lord, the state. Well, now, my lord, it is clear from the different provisions of the 2013 Act. That is, 2013 Act means, my lord, the National Food Security Act. There is a paradigm shift addressing the problem of the food security from the current welfare approach to a right-based approach. Well, the Act confers legal right on the eligible beneficiaries to get the essential money through fair price of at a highly subsidized price. And the Act also envisages reforms necessary for distribution to the ration card holders. This court then, my lord, the 21-22, my lord, has already, my lord, has gone through. Now, my lord, my respectful submission would be, my lord, this is on a different context. I never say, I always say this is the present case, so for present case is concerned, only the regarding making an advertisement pursuant to the Honorable Division Bench is whether I am bound to make that advertisement or not. If it is not, then, my lord, my case, I will not succeed. If
they were a party to the litigation before Justice Banerjee,
no,
Justice Mukherjee,
no,
in that round they were not a party, right?
Not there.
They have challenged an independent subsequent notification.
Yes, indeed.
They say when in 2019 this notification was issued, they have no nexus with Justice Mukherjee's order, which is binding between those parties. They say you please follow the latest your control order and make it.
No, that is not their case. Their case, whatever
but
he has submitted.
How can you explain this 50 lakh? If you put in 50 lakh in the 2019 vacancy notification, Mr. Sengupta, then you also have to bring in women and self-help group. You are complying with Justice Mukherjee's division bench.
That's why, my lord, I first at the threshold, my lord, I made a humble submission that whether the order of the Honorable Division Bench gives a mandatory order. At the time of making the advertisement, you give preference. If it is not, then, my lord, this question would not arise.
Sengupta, if justice, the division bench, yes.
Division bench, that's why, my lord, kindly see division bench order. Kindly see, this is very important. One, only Mr. Shaharai has quoted certain portion. My lord, kindly come to
2013 notification.
Page 86. First note. What was the issue in that, my lord, case, my lord? Kindly see, page 86. It is not, that is the finding of the Honorable Division. It is not only on the basis that the vacancy notification where self-help group has given preference that was widened the scope, not that on the basis of that the Honorable Division Bench come to a finding. This is not that. There are other questions, my lord, kindly see. It is not in dispute. Page 86, last paragraph. This is the finding of the Honorable Division Bench. Yes. It is not in dispute that the vacancy in question could not be filled up due to continuous litigation for the last 15 years or more. When the vacancy was declared initially in the 2003, the Control Order 2003 was in force. Control Order 2013
2003 Control Order contained this women's self-help group.
That got point. It was
came only in 2013.
2013, yes. That's the only concept. The Control Order 2020 came into effect on from 8th August 2013. As per clause 26(2) of the Control Order, if the district administration feels necessary to declare by vacancy, shall be declared with the approval of the government. Such vacancy has to be widely published in the official notice board, official gazette notification, advertisement in local as well as widely circulated daily newspaper. As per 2013 Control, there is a provision for giving preference. Why? Because the scope was widened. not that the basis of which the Honorable Division Bench passed a mandatory order. In making an advertisement, you should always keep in into the mind, in your mind, that these provisions regarding preference to the self-help, I am not saying self-help group is still there, is in existence. Only preference as was if lifted. So preference was if the Honorable Division Bench, if I go by the Honorable Division, according to my humble submission, Honorable, there was no mandatory order which cast upon the authority at the time of making advertisement, the preference should be given to the self-help group. Rather, it says you make an advertisement in terms of the 2013 control order. It is clear. Well, last paragraph. Yes. Advertisement, the kindly see, in view of the aforesaid, I am skipping over my letter already. In view of the aforesaid facts and
with the provisions of Control Order 2013, which includes women and self-help groups.
Women and self-help groups includes after amendment. I will show that. Not preference.
Contained preference for women and self-help groups.
Preference was lifted only, but they have included.
Preference was
lifted. Preference was not there. The amendment, latest amendment, preference was not there. A preference actually was withdrawn. No. Preference was withdrawn. My lord, kindly consider. My humble submission would be, my lord, if there is a mandatory order, you make an advertisement first, fresh advertisement in terms of 2030 order, and at the time of making advertisement, the preference which was given to a seller is still remain.
What is that 2013 control order?
2013 control order. Kindly come to page. First of all, Malad, kindly come to page 21. 121. Malad, of the that is appeal, my lord. Malad,
it's not annexed to
the stay application.
They have the books.
No. You can annex actually.
No, if it's annexed, we'll see from.
Yes, that is mat number 622. That is the here. Malad, 121 page.
121.
First 121, then Malad kindly come. Malad 121, Malad got it. Malad kindly see. This is 21st. Oh, Are Baba.
We have.
Are আমি তো দেখে দেখাচ্ছি দাঁড়াও তুমি অত ভুলিও না 21st July 2014 Malad kindly see. That is the date.
Yes.
Here, Malad, kindly see 1, 2. 1 is not applicable, 2 is applicable. Applicants for distributorship must have.
When Justice Mukherjee passed his order, the
Yes.
division bench passed his order.
That's why that at that
That's
point
when
of time.
2013 control order was there.
At that point.
Is the 2013 control order annexed anywhere?
No. At that point, it was there. I admit.
This is the 2013 order and the permission.
But please hand over the photocopies of this in the course of the day.
My lord, clause number
13. Roman 3.
That's the preference clause. 26 Roman control.
Yes.
This was that on the date of delivery of judgment by the division. I shall hand over copy.
দেখিয়ে দিয়ে
August 2013. Proceeding 2003 contract.
Yes, yes, my lord. Kindly come to page 121, my lord. 120. My lord, what I am on, my lord, if my lord comes to a finding, yes, there is a dictat or the ratio. That is, the obligation is cast upon the authority at the time of making advertisement, which the state did in terms of 2013 control order, that woman's preference should be given. If there is no such mandatory order, then I have a case. If there is a mandatory order regarding both preference as well as 2013 control order at the time of making application on the very spot.
We are not saying you are right, Mr. Sengupta, that division bench did not specifically observe in its earlier paragraphs that we are mandating you to give preference to them.
Yes, that is.
But no, that is not necessary because division bench all the same said that 2013 control order follow 2013.
Madam,
That is the order
kindly consider, just minute.
That is the order.
Yes, madam, kindly consider. Yes, madam, I'm
accordance with
satisfied.
the provisions of control
Madam,
order.
provisions of control 2013. Madam, now, madam, kindly let us see. Madam,
13 control order has this.
Madam,
provision.
kindly consider one thing. Madam, at that point of time when the order was passed, madam, that was there. Madam, kindly consider.
Yes.
But madam, kindly consider one thing.
Consider
that 2013, my lord, state whether if my lord says that I have got no right or authority to make any amendment to the control order, after that, then my lord, they should have challenged that. They didn't challenge. Page 121, kindly come.
Mr. Shengupta,
They cannot go both ways.
We are not saying anything. You have to, you cannot blow hot and cold. You in the one breath, in the one hand, you are saying that because of this justice, the division bench order, you could not issue any notification, you could not withdraw notification, withdraw whatever regarding Jamtala, because this division bench order was there.
That is the mandatory order.
And then you go on to issue this vacancy notification, which is impugned in the present writ petition. There you do not give any preference to women and self-help group.
Why?
How can you do both?
Why, Malad, page 121? Because they should have challenged in their writ petition. Malad, that is the case, Malad. State case also. 121, kindly come to.
Why should they challenge you?
Malad, kindly consider. Kindly 120.
Notification.
Because they have challenged the vacancy notice. They should have challenged this one, 121. Kindly come to page 121. There the amendment was taken place when 21/7/2014, much before the advertisement. Malad, here 50 lakhs is there. And Malad, kindly see the order shall be applicable.
But this was after Justice Mukherjee's division bench.
Yes, after that's why Malad.
Your main content, the plinth of your contention is that we are following that division bench judgment.
Only,
that's why you could not do anything.
No.
So then you follow that
subject to my kind approval, only to the extent there is a mandatory order to make a vacancy publication for vacancy at that right spot, not otherwise. In terms of 2013,
what was the security payable? 50 lakhs.
50 lakhs.
It was 50 lakhs.
Madam, kindly see, 50, this order shall be applicable. Madam, this is, madam, what I am submitting, humble submitting. Humble submission would be, my lord, kindly see, these orders shall be applicable while processing vacancies of which inquiries will be ongoing or complete but have not been approved by the department. So, my lord, they should have challenged that this is arbitrary. Instead of challenging that, my lord, to 2014, my lord, kindly see, they have stated, my lord, kindly see their writ petition. Nothing is there, only advertisement was challenged. What is their the bone of contention? Contention was that the Honorable Division Bench has given a mandate, directing the authority to give preference to the self-help group or women's group.
So this page 121 is the first time when, no, 50 lakh was already there.
50 lakh was there, but my lord, when
did it first come down to 25?
Yes, I am coming. That is 164. No, 164. No.
When what was it reduced first? 2022. This one.
164 2020. 18 December 2020. 164, my lord.
This was
now
the first
therefore
time it was brought down to.
Yes.
Then, my lord, I have handed over the.
But
this was 25 lakhs.
This was after the impugned vacancy notice.
Yes.
So at the time of the impugned vacancy.
That is 121. 50 lakhs.
Yes.
And the
Mr. Shengupta, please let us complete. At the time of the impugned vacancy notification at page 34, in 2019, it was 50 lakh and no women self-help group.
No women self-help group.
So at that point of time, you have to, if you are to see at that point of time, it was a valid notification.
Yes. And kindly see, I will. Yes, sorry.
Then the 2018 control order was in force. The amendment. 2018 amendment had taken away that women and self-help group.
But the preference, only
preference was taken away.
50, yes. Preference, only preference. But they may be, yes.
Obviously, preference was taken away and it was 50 lakh.
50 lakh, 25 lakh.
So you may argue that in 2019, when the vacancy notification, impugn notification was there,
yes,
it was a valid notification.
It was a valid. My lord, this is by submission. My lord, if my lord comes to a
It
final.
has been ended in 1 minute.
Yes.
Yes.
I will take not more than 5. But can I take the date of Justice Division Bench of Justice Mukherjee's order?
Yes.
That is 25th September 2018, 62. 25th September 2018.
Yes.
Am I clear to my lord?
Yes.
See, both the amendments, one is at page 121. Can you take the dates? Only dates. 21st July 2014 is 50 lakhs.
Yes.
Am I clear to my lord?
Yes.
And then kindly take trouble to see this second amendment of the self-help group. Can you see? Can you see in the bottom?
That is 2018.
15.
2015.
Ache, din na eta apatot. Can you at the bottom? These are the two issues is troubling my lord. Justice Bhattacharya got it.
It's 2013.
Amended at the bottom I will get is 2015.
So this was Gazette notified on August 8, 2013. Oh, acha, very good.
Can you see the bottom?
Yes, yes.
আগে কথা নয় অনেক মাইক লাগিয়ে গুলিয়েছো
Oh, self-help group was introduced
self-help
by the 2015.
all along there. Only preference was given that was withdrawn prior to the passing of the order of Justice Mukherjee.
Self-help group preference was there.
Well, can you see this notification?
This
Definition is there.
Here the definition is there.
That has come into force in 2015.
What is the preference?
No preference.
Then what is the meaning of that?
Why I am
No. Rule 20.
I am showing the book. The book is not correct. I have nothing to say.
Well, this is an amendment. Initially,
I am saying this is amendment. I am showing to my lord this is the amendment.
This is the main control order.
Oh, in control
Which
order.
all enforced at the date of delivery.
No, that I am saying.
Absolutely not.
Please, Mr. Sara, please take your seat now. No. If I say something wrong, point it out.
To some extent, it is misguided.
My habit of misguiding.
The amendment you have annexed is not still applicable.
I am not annexed. It's a book. If the book is wrong, I have nothing to say.
Amendment you have annexed.
Prior to that, my lord, there was preference. In 2015, preference was withdrawn. Can you be satisfied with my submission?
By virtue of this 2015 amendment.
এই বইটা তো আছে থাকবেই তো কিন্তু ওই অ্যামেন্ডমেন্টের ডেটটা ডেট নেই অ্যামেন্ডমেন্ট ডেট This is the book Mr. Sahar is want to show to your lordship. YA, CYA.
In clause, actually the relevant provision is
means a group defined, self-help group defined.
Group may be defined,
yes,
but it did not have any reflection in the provisions. But if you see the same book, clause 26,
my lord,
clause 26.
Roman 3, but you also have to go through this requirement.
Roman 3.
Yes.
একই বই তো বইয়ের ডিফারেন্স হবে নাকি?
No. This is 2013
not Roman 3. Roman 2A. Roman 2A.
That has been amended.
There, inviting application from an individual, there the self-help group was included. Just self-help working group.
Nothing, no problem with this. We are concerned with the preference.
No, but by the 2015 amendment, this was 2020 amendment. 16/12/2020
Is the amendment.
Is the amendment?
their self-help groups have been included.
Included.
No preference.
No, that I'm saying. And previously 15 also there is no preference.
You also kindly go through this.
Hey, Baba,
It's just the definition.
But let us be sure which book we should rely.
No. 2013 control order came into force with preference. That's our case.
I am saying so. We are quarreling unnecessary.
No. This has been amended subsequent to the division bench judgment.
No, before that.
Division bench clearly says, since there is a change by giving preference, that observation has not been challenged.
Not necessary.
So on 8th of August 2013, clause 26(3) included preference to self-help groups, women's self-help.
Withdrawn. Kindly mark that when it was withdrawn. 2015, according to my humble reading. Wait.
Including men also. Right.
So, my lord, kindly recall on those lines of judgment when it says if the amendments on the date of delivery of judgment has deemed to have been taken into consideration. But I don't
And the
read
judgment
that,
was
my lord,
25th of September
18. So on that date, these amendments has deemed to have been taken into consideration by the Honorable Division Bench. That judgment I have not brought today, my lord, is in my mind.
The first page of this and this relevant page, you just please hand over later on.
My lord. So, my lord, Division Bench said 2013 order has to be followed, including its amendments which was prevailing on that date.
No, but when was the preference taken away? Because self-help group still, even if Mr. Shahara's client does not get preference as women's self-help group, but still as a self-help group, they are in a different category.
No, they can participate along with others.
No, 26(2)(a), which is a 2020 amendment, but that is subsequent.
2020 amendment. My lord has to see, I repeat, my lord, repeating, his law is subject to my lord sanction. The law is when the division bench or any court is passing an
2015,
order,
you only showed us, Mr. Basu, the change in definition. But that has to be reflected somewhere. Unless the self-help group term is used somewhere in the main control order, what is the use of changing the definition?
now this is the definition.
No, in 2015, when that change of definition came, what was the main provision?
Main provision, I am relying on Mr. Sahara. Since the inception, there was preference.
Yes.
I am accepting
that preference was there,
Was
but
there.
self-help group
No one
was
is disputing. Preference was there. But when it was withdrawn, that's the relevant date.
2015, very good.
Relevant date is in both the count. In both the count, I repeat, my lord. Now kindly come to page 121 of your lordship, please.
So that preference remained till after the division bench order, much after.
Preference prior to that, it was taken away.
When?
That is 15. I have shown to your lordship. Sorry,
Preference was not taken away. Men were included.
Preference was taken away. In that definition, there is no preference.
Yes, definition there is no definition does not contain any preference, Mr. Basu. 2013 control order, which was shown by Mr. Shahara, in clause 26, the definition cannot have a preference. Definition is only the definition of self-help group.
After
and
that,
in 2013 control order in clause 26(3), a preference was given specifically to women and self-help groups.
that is no more there when the division bench judgment was passed.
Maybe 2020. How do you know that? How do you know that? Because Mr. Basu, even if self-help group, the definition is changed. Self-help group was changed, definition. That says run by men or women, right?
Both.
But clause 26(3) says women run self-help groups.
Reference.
So suppose self-help group is like a human being. Human being can be both male or female. Self-help group is like a human being defined as both male and female.
An entity.
But if clause 26(3) says only women human beings are entitled to preference, then that is there. 2013 Act contains a preference.
Right.
But the amendment which you showed to us contains a 2020 amendment which takes away that portion.
2020 amendment we are not concerned.
So
because
when
this is
was
post.
the preservation for women, that preference for women, when was that taken away?
I will try to assist, my lord.
That we are not getting anywhere.
Now,
2018, page পেজ 13 আছে, ছেড়ে দাও না, ওইটা নিয়ে দিও। আমি আমার
আমিও দেখিনি
পেজ 13 my lord kindly come to, মানে আমি তোমাকে বলতে হবে না, আমি বলে দিচ্ছি। My lord, first my lord, page 13, 18 December 2018, that is after the order of the Honorable Division Bench. That's why my lord, yes, that's why my lord, I have pointed out, I have made a humble submission that there was no mandatory order directing the authorities to give preference in their judgment. If my lord holds that,
Where is
then
where is that?
yes, my lord, 2A, my lord, kindly sir, come. On receipt of the approval of the vacancy concerned district on 20th, my lord, page 13, page 13. Oh, Josh. My lord, this is appeal, stay application.
Stay application is this.
1-3, my lord, is কি ভুল লিখেছো?
কোন পার্ট?
1-3, ঠিক আছে, হ্যাঁ।
Stay application one.
Stay application of
I
the
have this. Starting from my lord.
page 1-3, my lord, notification 18 December.
Can 1-2.
Roman 3 মিলছে না তো,
তোমার কি এটা করে দিয়েছো?
আমার সঙ্গে তো মিলছে না। মাইলরকে দে তোর কপিটা দে।
My lord, I am handing over this one.
না 1-3 আছে, সব একটা হচ্ছে।
এটা
Page 13.
টেলিং
হ্যাঁ,
আমার তো মিলছে না কেন?
13 দেখো।
আরে 28 এর পর তাই
My lord, page 13.
13
May I kindly see my
No, it's right. Tell.
Your lordship,
Yes,
consider, I have placed before you.
Roman 2. Yes.
my lord, kindly consider, that's why my lord,
my fault, my lord. I marked the my
my lord,
my
kindly
fault.
consider, my lord, that's why my lord, I made a humble submission. First of all, my lord, kindly see 2A, on receipt of the approval, there is amended has come into effect on 18 December 2018.
No,
Whereby
preference.
on receipt,
Yes,
preference is gone.
IA.
Yes.
Gone for the first time.
Yes, preference was not there, but my lord, they may participate. Now kindly see,
IIA.
controller official inviting applicant from self-help group register much was wide. My lord, kindly see, the authority has widened the scope further. Registered cooperative society, semi-government bodies, individuals, group of individuals, self-help groups as an entity specifying the limit. So, my lord, kindly consider one thing. My lord, my humble submission, if my lords, again at the cost of it, if my lords hold that yes, Mr. Sengupta division bench specifically made an observation and made the mandatory order.
Let's take a
Yes.
seat. We have understood.
This is my
Mr. Basu, please continue.
Now,
Yes.
sir, this is I cannot say this is pre-judgment of justice post, but my lord has to think what is the subject matter of challenge before my lord. Can he take trouble to see the writ petition? Only the clause 5 is the subject matter of challenge. Kindly come to page 34, 28, page 28.
Yes.
Clause 5. What is clause 5? Kindly come to page 34. At 35. Oh no, before that, I must show. This notification is only on the basis of division bench order of your lordship's court. Which Mr. Sahara has said, no, it is not. Kindly come to page 34.
Yes.
Second paragraph. And whereas. So this is in respect of an order to be given honor to, this notification has been issued. It has no generality. It is on the basis of the judgment of your lordship's court. So that's why this vacancy was kept as it is, not withdrawn. Now, can I turn over? Can I come to page clause 5?
Yes.
50 lakhs. This is the only prayer. Can my lord court go beyond the pleadings? This is the only pair, 50 lakhs. And how 50 lakhs? 50 lakhs is page 121. That is on 21st July 2014. That is the amendment which the division bench deemed to have been taken into consideration. And in the second limb of my submission would be that if unless you are challenging this, you cannot challenge the consequential notification. And we have also relied upon a judgment for your lordship in the written note. So you cannot enlarge the scope of your writ petition. On the day division bench passed a judgment, this notification came into force.
They were not a party. They were not a party.
You also party doctor. Independent challenge coach vacancy.
Hmm.
So in this score, my lord, I can argue before my lord.
If
which
the
I've
division
already-
bench judgment is to be complied with,
then this amendment has to be taken into consideration. This at page 121.
50 lakh would be the amount.
The amount.
But that preference for
Preference is not the subject of challenge, subject to correction by my lord. Kindly see the read petition. Kindly see the prayer.
Petition paragraph 6 onwards.
Kindly see the prayer.
here, somewhere they must have pleaded in the
Maybe pleaded, but they are not prayed for it.
Kindly read, my lord, page 19 of the stay application.
And what is this cross objection? Kindly see this cross objection.
Kindly read, my lord, paragraph 5, 6, 7, 8. What is my challenge? And 9.
This is not a challenge.
6, 7, 8, and 9. Yes, grounds are there. I shall show. Specific grounds. Paragraph 12, 13, 14.
preference ground, where is that?
Yes.
You are asking decree also, my lord. Only pleading will do. He has to amend it.
Here I shall show. After paragraph 7.
Your turn goes.
Of the are not
Did
what?
not so. Your turn gone.
No.
There is no prayer for that.
No, there is no such preference even. That he was. There was no allegation.
And coupled with the amendment in 2018.
Yes. Paragraph 11 and 12, kindly read, my lord, paragraph 11. The officer states that in the outcome of answer, trying to promote the self-help groups, especially run by the
These
women.
are sermons has been given. No problem about that.
Kindly take up my grounds.
Now, my lord, kindly see the.
No, very well, I will look into that.
Kindly see the cross objection. What is said? 2013 vacancy should be. 3 grounds are there. All 3 are on that.
Yes.
I am also saying 2013 control order should be given effect to in terms of the division bench judgment.
With preference.
Where division bench said that whatever the law of 2013 which has been given effect to should be adhered to.
No, my lord, only one thing, my lord, kindly take into account at the time when the Honorable Division Bench passed an order to make an advertisement in terms of the 2013 Act. Whether at that point of time that notification regarding the so far preference which was given to the self-help group, whether that was there or not.
Division bench order said control order 2013.
Yes.
We take it to be as amended till that date. If that be so.
No, my lord, at the time of making the advertisement, kindly see order. This is very relevant. Kindly see. Advertisement vacancy notice should be published set aside. The authority is directed to initiate for filling up the vacancy. So filling up the vacancy must be vacancy notice must be preceded by a advertisement.
The advertisement and vacancy notice shall be given wide publicity in accordance
Yes.
with the provisions of the control order of 2013.
Now, my lord, let us assuming.
This
but
has been
not
passed in September 2018.
Yes. Now, my lord, no.
So the provision of the 2013 control order as on that date is to be seen.
Well, probably, my lord, I may be wrong, but my lord, I am making humble submission that at the time of making advertisement, when that amendment was there or not, that lifting of that preference. No appeal. My lord, kindly consider the.
September 2018 is the date on which we should be taken.
And my lord, when the vacancy notice was given, 19
should be taken as the cut-off date.
Yes.
The position, the control order of 2013 as it stood on that date.
Yes.
September 2018,
yes.
The date of the division bench order, that should be taken to be the cut-off date. If this is to be complied.
Yes.
On that date, the position was regarding the security, it was 50 lakh, 2015. And regarding self-help preference, that was also there. So now, if this is to be complied with, as per that order, you had to include that preference for women run self-help.
My lord, may I submit, subject to my lord saying that. My lord, kindly come to when the advertisement was done. Pursuant to the vacancy, 2019, my lord, page 94. May I kindly consider one thing. At the time of making the advertisement, what was the law at that point of time? 2018, that amendment has, by that time, has already been taken place. 2019, kindly come page 94.
We have to see whether this order has to be complied with. If this is to be complied with, it has to be taken as on the date of that order. Then 50 lakh remains preference for self.
One simple addition.
And if we hold otherwise.
If it is not, because he is not filing any contempt application. Because he is not a party in the proceeding. He is challenging only 50 lakhs.
No.
He is not challenging, my lord, that part.
Clause 5.
He is
Clause
challenging
5.
clause
Only
five.
clause 5. That apart,
Whether
that
it is
apart.
on that date or
That
future
apart,
date.
my lord, my humble submission, kindly note, take a note. At the time of making advertisement, first of all, there is no mandate from the Honorable Division Bench that to give preference at the time of making advertisement. There was no such. Rather, direction was given that is mandatory to make an advertisement in terms of 2013 control at the time of making advertisement. So advertisement at the time of making, when advertisement was made to 17/7/2019, page 94. Advertisement when it was made, by that time amendment has come 2018. My lord, page 13.
Put it in a written notes of
Yes,
argument.
this is my lord, my case.
List of dates is there or
List
supply.
of date you have supplied.
And 2 pages written submission.
Yes, that would suffice for you. That is your submission.
And if you ask me to cite that judgment, whether it is deemed to have been taken into consideration by the,
What has been deemed to?
because this amendment.
No, that was not challenged. Seটা তো just
Whatever you have already submitted your
So
written.
that point I have not submitted. This is now cropped up now.
That deemed.
When the division bench is passing or the court is passing an order, the amendment of the particular law, even if not placed before the court, it has deemed to have been considered.
What is the citation? Give the citation so that we say.
In my khata, my lord knows I am.
Yes, that proposition. Do you have any quarrel with that proposition? No. It should not be.
But kindly read prayer P and C also. My learned friend also
Just read out for us.
editing the nature of mandamus commanding the respondent, the agents, subordinates and assigns to resign, cancel or withdraw the purported distributorship notice for appointment of payment distribution. So if all editing the nature of mandamus commanding the respondent, their main agents are assigned to re-advertise the advertisement about distributorship also in terms of contract to third. And in the grounds, 4 grounds I have taken, if you want to just allow me to read. I'll read, my lord. Ground number 6 should be treated equally. Ground number 7, 8, and 9. Specific.
That is on equality. But preference for self-help women group is not equality. That is a special preference you are claiming.
Prayer for declaration is the first one, and those are subsequent or consequential.
Ground
number 5 is the only ground he has challenged.
But if you claim any special preference for self-help women groups, then you are not harping on equality.
I have placed my
Again,
I will take my ground number 2. For that to position of also condition of vacancy notice take place by preference to the seminal group. Conditions, well, kindly see conditions. Conditions for not there was condition that 50 lakhs. Preference, there was no such statement pleading that no, this is not the ground.
Is the pleading?
Yeah, yes.
Concluded?
No.
Concluded? How
Ground.
can you file a written note of arguments? Sure.
That is the only one.
He is unable to participate because of 50 lakhs.
You also 7 days. Written notice of arguments.
I have to make a written notes of arguments. Yes.
How soon can you do that?
10 days. 10 days, 12 days. Had I been 12 days, we should have 15 days.
Written notes of arguments filed by the appellants is already on record. Full-stop learned senior counsel for the appellant seeks to cite another judgment and circulate copies of the same on the returnable date, full-stop, and file copies of the same on the next date, full-stop. On the prayer of learned senior counsel appearing for the private respondent and learned your AGP, learned AGP appearing for the state, comma, the time for filing written notes of arguments by the respondent number 1 and the state. The time for filing. The respondent number 1 and the state shall file the written notes of arguments also on the returnable date. Full stop. The matter shall next be listed on November 18, 2025 under the heading to be mentioned.
আবার
Next. Call on this one. এগুলোই রেখে দিন এভাবে আপনারা ভাবে দিন ঠিক
এই এটা নাও দেখছো আমাদের কপি
কিসের ফোনে কপি
ওটা তো এই
the respondent, my lord.
I appear for the appellant.
For Mr. Basu's reply. It was heard some time back. If you would recollect,
So
Mr.
this is that land acquisition matter where, my lord, the issue was whether the proceedings have lapsed.
Yes.
Whether at all I could have taken recourse to the emergency provision under section 17 of the Land Acquisition Act 1894.
Yes.
My lord, I will not trouble your lordship much, but my lord, the only in reply.
Very short, but just to give a very short recap. My learned friend raised 2 points.
Take the microphone a bit closer.
My learned
please.
friend senior raised 2 points. First was the interplay between section 17 and section 11 of the Land Acquisition Act, to which we showed a judgment from their compilation itself. It was 2022 SCC Online SC 1408. If my learned friend will kindly indicate that judgment
Yes,
from
it
this
is there in the
compilation. The Delhi AirTech judgment.
Yes.
That was placed by Mr. Kaur, showing that there is no conflict. And as per admitted records, the proceedings have lapsed, no compensation given, no possession taken, which also dealt with their point of the other point that they argued that we are post-acquisition transferees. So we cannot challenge the proceedings initiated. That was the answer of Mr. Kaur, and to which my learned friend would reply.
Yes, my lord, there has been, my lord, we have not taken the point of maintainability of the writ petition before the learned judge. But my lord, since it's a pure question of law, hence, my lord, we had taken the point in the appeal. The reason is writ petition was not maintainable because it is admitted from the writ petition that the respondent who had filed the writ petition was a subsequent transferee. Subsequent my lord, if during the possession of their predecessor, the land acquisition proceedings have lapsed, a subsequent transferee cannot have a better right than their predecessor. Now, this is the only maintainability point that we have raised.
Yes.
Yes. But in fact, my lordship sees the compilation that we have given.
Yes.
Yes. My lord, we kindly see my lord, page 2, paragraph 3. This point has been specifically taken. There are list of judgments that we have given. I will not cite all of them, but I will only indicate my best 2 out of them.
Page 2,
Page 2, paragraph 3.
Yes. Yes.
This is the maintainability issue. Law is now well settled. It would not be open to any transferee to challenge an acquisition or a purported lapse in acquisition, particularly in the event the transferor during whose ownership tenure the said proceedings have emanated and dealt with had not challenged the proceedings. Now, kindly now, this is the issue.
Which are the best 2 judgments?
Yes, serial number F and serial number G.
Thank you. Yes.
F and G. My lordship sees page 88 of the compilation. Page 88 is serial number F.
Led by Mr.
Yes, obviously. Yes.
Writ petition of a subsequent purchaser was allowed by the High Court. Supreme Court has undone that. But kindly see the first paragraph. Feeling aggrieved by and dissatisfied with the impugned judgment and order passed by the High Court of Delhi at New Delhi in writ petition number 1202 of 2017, by which the High Court has allowed the said writ petition preferred by the original writ petitioner, subsequent purchaser, and has declared that the acquisition proceedings initiated under the LA Act of 1894 with regard to the land in question deemed to have lapsed under 24(2) of the 2013 Act. Now, my lord, hence the appeal. Kindly see paragraph 3. At the outset, it is required to be noted that the original writ petitioner before the High Court was the subsequent purchaser, and as observed and held by this court in DDA versus Godfrey Phillips, subsequent purchaser is not entitled to claim lapsing of acquisition proceedings under the 2013 Act. Therefore, the High Court has materially erred in entertaining the writ petition by the original writ petitioner subsequent purchaser claiming lapsing of the acquisition proceedings under the 2013 Act. This is the main paragraph. Now, lordship kindly takes the next judgment, which is at page 92 of the compilation. Self same facts, my lord. Writ petition allowed by the High Court, writ petition filed by a subsequent purchaser. High Court's judgment was undone by the Supreme Court. But kindly see page 92, the judgment starts. My lord, paragraph 3 at page 93.
Yes.
Yes. Now, so far as the locus of the original writ petitioners being subsequent purchasers is concerned, the said issue is now not res integra in view of the decision of the three judges bench of this case in Shiv Kumar versus Union of India, which has subsequently been followed in the case of Delhi administration through Secretary.
Some other cases have also been added
Yes.
from the previous.
Yes.
Yes.
Now, in the aforesaid decision, this court has specifically observed and held that the subsequent purchaser has no locus to challenge the acquisition and or lapsing of the acquisition. In that view of the matter, the High Court has materially erred in entertaining the writ petition preferred by the writ petitioner's subsequent purchaser and declaring that the acquisition with respect to the land in question is deemed to have lapsed. Even otherwise, on merits also, the impugned judgment and order passed by the High Court is unsustainable. Before the High Court, it was the specific case on behalf of the appellant that possession could not be taken over due to pending litigation initiated by the original landowners challenging the acquisition, which ended up to this court. As observed in this case in Indo Development Authority, if the acquiring body beneficiary was not able to take possession due to pending litigation in a proceeding initiated by the landowner, thereafter the landowner cannot be permitted to take the benefit advantage of the same and thereafter to contend that as possession is not taken over.
Paragraph 4 is relevant in our case.
No, but I'm only on paragraph 3.
3, yes.
Here, my lord, it is an admitted and undisputed position that the writ petitioner who had filed the writ petition were the subsequent purchaser. Now, my lord, to bypass this issue, my lord, the title deeds have not been disclosed. In fact, it is kindly see the writ petition. The writ petition starts at page 34 of my stay petition.
Yes.
Yes. Lordship will kindly take, my lord, page 50, paragraph 5.
Yes. Paragraph
Yes.
5.
Until the time indicated in the present petition, neither any of your petitioners nor their predecessors were ever aware of any proceeding initiated by any of the respondent authorities for acquisition of any portion of any of the said plots of land. Till such time as indicated in the following paragraphs, your petitioners therefore were always under the bona fide impression that the said plots of land are freehold. Now kindly, my lord, see paragraph 6. Your petitioners state that in the recent past towards the beginning of 2023, your petitioners jointly took a decision to utilize the said plots of land by developing the same and by setting up a residential complex thereat. Your petitioners, however, did not have the means or experience or expertise to undertake such development work, and therefore your petitioners started approaching some developers and promoters ready and willing to develop. It was in the course of process of development of the lands that it surfaced for the first time that the plots of land comprised in RS Dag number 39 and 43 and also portions of land comprised in RS and LR Dag number 37, 38, 44, Moja Chapna district had all allegedly been proposed to be acquired sometime in 2005-6 for the alleged purpose of setting up a township thereat by the name of New Township. Now, my lord, they admit. Now, my lord, kindly see, my lord, page 53. This is, my lord, I will not trouble your lordship with those relevant paragraphs, but because, yes, kindly see page 57. My lord, paragraph 15.
Yes.
Your petitioners state that that to the knowledge of your petitioners, no step was ever taken by the respondent authorities in connection with LA case of 24 of 23 of 2005-6 post publication of the declaration under 6 of LA Act of 13 February 2009. That insofar as your petitioners have been able to ascertain, respondent authorities stood idle over the matter after the publication of the Gazette notification on 13 February 2009 and took no further step in relation to or in connection with the said land acquisition proceeding. They were aware, they say that they commenced development works and only thereafter they discovered that the subject plots of land were the subject matter of a land acquisition proceeding. But this proceeding commenced during the tenure when their predecessors were the owners, and thereafter it lapsed. If at all, at best, it is their case that the proceeding lapse on account of us not taking possession and not making payment of compensation, then at best they are subsequent purchasers. If they are subsequent purchasers, then if their predecessors did not challenge the lapse
Lapsing,
proceeding.
Mr. Basu, happens by operation of law.
Yes.
I mean, even if someone does not take it, we can appreciate that they cannot take it, but can the court shut its eyes because it's by operation of law? Lapsing happens by operation. So either it has lapsed or not lapsed. Whoever points it to the court and the read jurisdiction, I mean, Supreme Court has said that they cannot take the point. Even if they don't take the point, they have brought it to the notice of the court. Can't the court look into it? And because it's by operation of law, that's why. Just like you are saying that it's a pure question of law, you can argue here. We agree fully. Maintainability in this context is a pure question of law because there are judgments of the Supreme Court. But still, isn't lapsing by operation of law? We know, we see from the facts are admitted that lapsing has happened by operation of law. Then whether the court can shut its eyes.
Right, it's on a principle of waiver or acquiescence.
And that is precisely our point. Can something which happens by operation of law, it's automatic by operation of law, nobody has a right to waive it because it's not a vested right by virtue of some act of some party. I cannot waive something. I mean, it's beyond their capacity to waive it. Nobody can waive it. It's by operation of law.
But not they had the right to challenge the proceeding. They had the right. But I know that.
Yes, we cannot look into it because the right opens, the window opens once they challenge.
Yes.
So that challenge is not open to them. So the writ petition should not be opened even.
Yes.
On that ground.
Yes.
Very good.
The right has gone when their predecessors themselves did not challenge that.
Yes, that is the judgment.
Yes.
Both the judgments also.
And in fact, from their pleadings in the writ petition, it demonstrates that, and in fact, the title deeds have not been disclosed. They have only disclosed their record of rights.
Obviously, there was no challenge because they have not disclosed any previous challenge.
Yes. If they are subsequent, what is falling from my law that is it has lapsed on account of an operation of law. Perhaps the party concerned did not have control over it.
Party control is nobody can waive something which happens automatically by operation of law because there cannot be estoppel against the law.
Yes.
That principle you may say broadly. I cannot be stopped from taking something which happened by law or waive something. A right can be waived. This is not a right of challenge. To challenge is a right. Yes.
Yes.
But lapsing is by operation of law. The facts are before the court. Can the court shut its eyes? That's one of the difficult points.
But this has taken a considerable period of time.
And action has been taken thereafter on the basis of that acquisition also.
Yes.
Probably. So by now, probably this would be a deadwood sort of, because they cannot open now.
Yes. Time has
think that over.
flown for a considerable period of time.
And all.
In fact, the writ petition at the very first instance could not have been entered in. It should have been the first thing, my lord. We were not there, that it should have been pointed out that it was their predecessors' right to come and complain that the proceedings have lapsed, as I have not taken steps under this concerned statute. If their predecessor did not exercise that right,
they cannot open the window of
they
challenge.
cannot open the window of challenge.
And if they cannot open that,
then further
does not have no business. It doesn't have any business to look into it.
Yes.
Very.
My lord, you will kindly grieve me.
Yes.
That gave an absolute proposition. My lord is right. Like abatement of a suit, an order recording abatement is unnecessary. Suit abates when it has to abate,
yes.
And the consequences follow. But when this proposition was tested by the Honorable Supreme Court, I find that in land
just don't sit immediately behind you.
Yes, so that
accident may happen. No, behind you is Mr. Basu.
No, behind him there is a chair.
No, but he's agile enough to shift to the right, my lord. And he's aerodynamic also, so he'll be shifting quickly.
Yes.
Now, my lord, the only thing is this proposition has attained almost fruition as a proposition of law now settled by the Honorable Supreme Court. I was surprised, in fact, to see this, but
which proposition?
That the fact that a subsequent purchaser will not be heard challenging even
the
a lapse.
Have been cited on that.
Yes, so I mean, so even the lapse thing comes in. Not only not challenging acquisition, I can understand challenging acquisition. A subsequent purchaser can't come in. There, the principles of Order 22 Rule 10 would come in. I mean, if someone has not done anything earlier, then you will be bearing the disability of your predecessor and the like.
Lapse, I thought, would be such a case. It would be akin to abatement of a suit, in which whether or not someone says anything or not, it is abated on a particular day given 90 days after the date of death of the. But here, if your lordship kindly, for instance, sees my lord 2023 1 SCC 39 at page 88. Huh? This has been shown to your lordship. Not kindly see his the part of the ratio is that there can be no challenge. Page 89. Would you lordship kindly see page 89?
Para 3. Not entitled to claim lapsing of a proceeding.
So at the outset, it's paragraph 3. At the outset, it is required to be noted that the original writ petitioner before the High Court was the subsequent purchaser, and as observed and held by this court in DDA versus Godfrey Phillips and India.
Para 1 says that the challenge was on lapse.
Yes.
Get you.
Subsequent purchaser is not entitled to claim lapse.
The rest. Yes.
Therefore, my lord, so
Para 1 says lapse.
And there's a catena of other decisions which have been, my lord, all there in the compilation. My lord will consider every aspect of acquisition, including lapsing. Subsequent purchaser, the door is completely jammed shut.
Right.
So, my lord, that is, my lord, my humble submission regarding the first point not being answered. Mr. Kaur, I don't think has answered the first point at all. The second thing is, my lord, the question of whether 11A would become applicable and 17.4 acquisition would become a normal acquisition if monies were not paid, came up for consideration before an honorable bench of the Supreme Court, and there was not a split verdict. That was that, Lord. I must show you, Lordship. There was a split verdict, not me. Second, Dada.
Sengupta, you are accustomed to these things.
Originally, please come to paragraph 30. Lord, he is preempting my submission. I can see the following sentences after 5 sentences coming, my lord, from an auditory source. Now, my lord, kindly see, my lord, paragraph 13 of my notes. There was a split verdict in Delhi Airtech Services. Delhi Airtech Services, my lord, what are these? Delhi Airtech judgment.
Page 383.
Please come to, my lord, page 383. This I must point out, this we had placed before your lordship, lest before that, na এর আগের যেটা ছিল আগেরটা দেওয়া নেই এই ডেলিটা দেওয়া নেই
1408.
হ্যাঁ
1408.
3 judges. Just kindly see this one. This is 2022 SCC online SC 1408. There was a split verdict in paragraph 1. Lord, kindly see. Lord, page 383 of the compilation.
1 minute. The previous pages were 88 and
88
and 90.
88 and 92.
And this is 380.
This is 383.
যে দুটো ল্যাপসিং এর সেটা হচ্ছে সিরিয়াল নাম্বার FNG 88 and 92
যেগুলো আমরা করেছি যেখানে বলেছি কোনো মতেই হবে না সেগুলো ফর্মালি সাইটেড করে দিই
383. Yes.
Yes, please come to 383. First paragraph only. Appeal has a checkered history. The appeal was heard by a bench consisting of 2 judges, 2 honorable judges, Justice A.K. Ganguly, Justice Swatantra Kumar, and was decided by the judgment dated 18th August 2011 with divergent opinion. In the process after consideration, Honorable Justice A.K. Ganguly arrived at the conclusion that taking over possession of the land without complying the requirement under section 17(3)(a) of the Land Acquisition Act 1894 is clearly illegal and in violation of the statutory provision which automatically violates the constitutional guarantee under 300(a) of the Constitution. However, on taking note that the land had been utilized and developed by the beneficiary of the acquisition, allowed the retention of the land, so on. So, number 2nd paragraph. On the other hand, Honorable Justice Swatantra Kumar, however, disagreed with the said conclusion and for the separate reasons assigned by the learned judge, arrived at the conclusion that section 11(a) of the Act of 1894 has no application to acquisition under section 17 of the Act of 1894. It was further held.
Yes.
It was further held that the default in complying with section 17(3)(a) of the Act of 1894 does not invalidate or vitiate the entire acquisition proceedings. The learned judge, while deciding so, had, however, misconstrued that 80% of the estimated value in terms of Section 3A had been paid to the land loser. In that context, held that the interest provided in terms of Section 34 will be payable. In that view, the learned judge ordered dismissal of the appeal in terms of the directions issued. So this divergence of opinion, my lord, was recorded, was arrived at way back in 2012. My humble submission is that for all material times for the purpose of the subject purported lapse, this clarified law, the law that has been settled now by the 2022 SCC Online SC 1408 would not apply.
Would not apply.
Would not apply.
Why?
Because the factum has taken place much before.
No, but here the law has been interpreted.
But the law as it stood when that thing was being done was that there was
Those same provisions were there.
Same provisions were there.
Those have been interpreted now.
Yes.
That interpretation pertains to since when the provisions were.
Ordinarily in a clarificatory statute, yes.
This is not a clarificatory statute. If it is a statute, we could understand. The Supreme Court
clarificatory goes back.
Lays down the law and says this is the purport of the law. Law was there all along.
But before that, when the law was there was a divergence in opinion on what the law was.
But law was settled. Law was not settled. Divergence of opinion is not a settled position of law. There was no 141.
There was no 141 like binding effect.
Therefore, the law was whatever it was, and that has been interpreted later on. That should be the law from the date of its inception, the statute's inception.
There, my lord, I am humbly requesting your lordship to consider whether my lord will give it that retrospectivity by holding that as
it's not a question of retrospectivity, Mr. Banerjee. This is,
I can understand. There was a cloud.
Something which was there, whatever was there at that point of time, it is explained that means this. That meaning need not be from the date when the meaning is spelled out.
That will always be the meaning. That will always be the meaning.
Yes.
But before that, my lord, there were there was a split verdict in which one of the two judges, having equal bench strength in terms of precedents, and therefore none of the two would actually operate as a precedent qua the other, said that as far as Section 17(3)(a) is concerned, its alleged non-compliance has nothing to do with 11(a) setting in. What would be the effect of that? I'm asking myself. At that point of time, at the relevant point of time when all this had happened, throughout, there is no law holding.
What has been held here in para 13?
Yes. What has been held is, because this judgment I had cited, I had brought to your lordship's notice, para 27. Doesn't declare the law. Doesn't kind of declare the law from that point which my lord is saying, subject to correction. Shall be applicable. Shall be applicable. Shall be applicable. Prospective overruling. Goloknath.
Goloknath spelled it out.
But here he's saying shall be. So if it's not spelled out, to the reverse, it's prospective. And this lapsing can't be something which is continuing, and therefore it's a continuing cause of action. Whatever happens to the law, lapse gets the benefit of that whenever it is interpreted. Lapsing has to be qua an event which took place at a particular point of time. At that point of time, one can say, very well, now the proceeding has lapsed. If that has lapsed, then my reciprocal submission, my lord, this judgment will operate prospectively. And this is, of course, my lord, without prejudice to my earlier submission, that even this door can't be opened because subsequent purchase a complete bar.
That is all.
Almost, I would want to detain your lordship, but I'll detain your lordship another day for about 5 minutes. Just give me 5 more minutes.
Hard in part. Let the matter be listed for further hearing on November 12th, 2025.
Is in some difficulty. Could it be on the 13th or?
He'll only this is in reply. You have already answered. He'll just reply.
This is your lordship.
No further.
This before this page.
No.
I can take 5 minutes just to say what I placed, but
No, but then on the next day you do that first, then Mr. Manager will
Then
conclude.
I'll
You'll conclude.
him
Yes,
and then.
yes.
Lordship.